I would like to begin by reading out a statement, which in return I will ask you and counsel to confirm is correct. I hope that is okay. The hearing on this application, the trial hearing is being held by way of teleconference with Justice Roger Giles. The judge hearing this application is appearing all the way from Australia. Any orders or directions made after or during the course of this application will be issued by the registry in Dubai on Justice Roger Giles' instructions. Will the judge and parties representatives please confirm that the situation is as I have stated?
Yes, we do.
I agree.
I agree.
Yeah. I confirm.
Thank you very much. We are here for a hearing in the matter of CFI-037-2019 before Justice Roger Giles. The claimant is represented by Global Advocates and Legal Counsel. The lead counsel is Michael Puchett-Joyce. The defendants are represented by Kanan Advocates. Lead counsel is Samir Kanan.
Sure.
Yes, well, gentlemen, I've read, of course, your skeletons. I'm reasonably familiar, I think, with the pleadings, and I have read the witness statements and the documents in the e-bundle, which does not mean that I retain every nuance of them. Indeed, probably not at all. That may help with the progress of matters. Mr. Puchett-Joyce, do you wish to have an opening?
Your Honour, in view of what Your Honour has helpfully indicated, I can keep the opening very short because, of course, having read the skeleton arguments, Your Honour is well aware of the ambit of the matters before the court. By way of claim, it's a claim by Global Advocates, by Global Advocacy, for unpaid fees in relation to various files, to which there is a counterclaim, of various points of defence and counterclaim, which are of relatively short order and compass, and which will be explored by way of cross-examination. There are, by way of housekeeping points, there is a preliminary matter in that I understand that Mr. Kanan would like to introduce a letter of engagement, which is in relation to a completely separate matter and dated July 2015. Your Honour, our position is that we don't wish to be at all obstructive, but equally we don't wish irrelevant material to be placed before the court. And we can't see the relevance or appropriateness of the document that Mr. Kanan wishes to introduce. We've therefore submitted some brief written notes in that regard, hopefully to shorten this aspect of the preliminary proceedings. By way of witnesses, I can update the court as follows. Your Honour will be aware that there is a witness statement of Mr. Ali Al-Hashimi. I'm told, and my learned friend Miss Wright will confirm, that Mr. Kanan has, or his office, indicates that Mr. Al-Hashimi is not required for cross-examination, and therefore in those circumstances his evidence would stand. And perhaps I can pause there just for Mr. Kanan to confirm.
Yes, we do confirm.
I'm obliged, Mr. Kanan.
We are confirming that we have no questions to be addressed to Mr. Ali Al-Hashimi to the extent of this.
Yes, thank you.
Thank you, I'm obliged. And I think the other point that needs to be updated is that there is witness evidence from Mr. El-Dasuki. And Mr. El-Dasuki, I understand, though it's more a matter of Mr. Kanan than me, but as I'm speaking, I may as well continue with this aspect. I understand that Mr. El-Dasuki is not being called.
It's not essential that he is here.
I'm sorry, you do echo a little, Mr. Kanan. I'm sorry, I didn't catch that very well. Is Mr. El-Dasuki being called as a witness or not?
No, Your Honour.
Thank you very much. All right. Well, now, Mr. Puchett-Joyce, on the first matter of the document that Mr. Kanan wishes to introduce, is the most convenient way that it'll simply be tendered and received, and whatever relevance it have can be dealt with in the course of cross-examination if necessary or in submissions.
Your Honour, I think that's probably best. I did think as to whether it could be introduced de bene esse, and then it's a matter for the court as to whether it is bene or not.
Yes, well, it's a matter for the parties whether the court's persuaded that it's bene. But that does seem a convenient course. I don't have the document, but I'm sure if it's provided to Mather, she'll be able to email a copy to me, and I can print it off straight away here.
We can do that, Your Honor.
Of course, Mr. Patrick-Joyce, from your point of view, is that convenient?
Yes, Your Honour.
And Mr. Canaan, is that convenient from your point of view? I'll receive it without any ruling one way or the other about whether it's properly before me, and that it will be before me for whatever relevance it can be shown to have.
Yes, Your Honor.
All right, then. Well, if Mather could be provided with it, if she hasn't already, and email it to me, I can then have it before me as necessary. Are they the only preliminary matters from your point of view, Mr. Patrick-Joyce?
Your Honour, yes, they are.
Mr. Canaan, Mr. Patrick-Joyce will then give me, as he's foreshadowed, a short opening, but do you have any other preliminary matters that are conveniently dealt with before he does that?
We have certain opening remarks, Your Honor, only.
Right. Well, I'll come to your opening remarks after I've heard Mr. Patrick-Joyce's opening remarks.
Okay.
Now, Mr. Patrick-Joyce, after both your opening remarks, I'd like one of you to tell me what the proposed order of witnesses is going to be, so I can see what our future is. Mr. Patrick-Joyce, please go ahead.
Your Honour, I'm obliged. Your Honour has the claimant's skeleton argument, and Your Honour has indicated that you had an opportunity to read it. And it may just be convenient for me to highlight literally 3 paragraphs in relation to this. The introductory paragraph summarises or seeks to summarise the matters before the court. It says that the claim is for professional fees owed by the defendant to the claimant for legal work. Sorry, I'm going ahead of your file, Your Honour.
No, I'm there.
Paragraph 1, the matter before the court can be summarised shortly. The claim is for professional fees owed by the defendant to the claimant for legal work undertaken on several identified files. The counterclaim is for fees said to have been incurred and damages said to have been sustained by the defendant because of the claimant's professional misconduct and or breach of its professional obligations, and the claimant denies that there is any substance in the counterclaim or indeed in any of the purported challenges to the fees claimed. Your Honour, I said I'd literally take you to 3 paragraphs. The next paragraph is the second paragraph. The scope of the dispute has been further narrowed as appears from the pleadings. The particulars of claim at paragraph 11. And Your Honour, if Your Honour wishes a note to that, the paragraph in question is to be found at A10. That reads as follows: according to the defendant's response, that was the response to the letter before action, the total disputed amount of the invoices is 314,900 dirham. Nevertheless, it has failed to pay the balance, which it accepts as due and payable. The defendants failed to offer any justification for not making payment of that undisputed balance. And then the third paragraph confirms that the amounts in dispute on the invoices and the full claim, as Your Honour is aware, is for 1.26 million dirham in round figures, and Your Honour has the precise figure on page A2. But out of that 1.26 million, everything is agreed apart from the 314,700. Really, at that point, that summarises the claim, but it may be of assistance just to look on to paragraph 5, which sets out how the 314,900 is comprised, and it relates to a challenge to 30,000 dirham in relation to the fees arising in the Dexter matter. There's then a challenge to 24,500 odd dirham in relation to the Al-Banawi matter, and then there is a challenge in the sum of 260,000 odd dirham in relation to the Abu Zaid matter. And then really, as I say, paragraph 6, other than the counterclaim, the defendant has not particularised any other dispute as regards the sum claimed by the claimant. So I can pause there. Then...
While you are paused, I'm not too sure that you're right, because there does seem to be some dispute over the Abdulazim Al-Fadel case.
Your Honour, yes, but of course that has really fallen away because Mr. Ali Al-Hashimi is not now being cross-examined, and therefore his witness evidence stands. And in our submission, it's absolutely clear, therefore, that the issue concerning Mr. Al-Hashimi must be resolved in the claimant's favour. So the effect is that Mr. Al-Hashimi said to Mr. Beckley in, I think, April 2018, I will discuss the matter internally, the question raised by Mr. Beckley, I'll discuss the matter internally, which he then obviously did, because it's common ground that on the 30th of April 2018, there were telephone calls between Miss Lacan and Mr. Beckley, and Miss Lacan followed up with a full email explaining the circumstances, which again relates to Article 18 of the DIFC employment law. So there is no, as I read it, there was no monetary claim anyway in relation to Al-Fadl, and it, in our submission, now falls away.
Well, it may or may not, but on the pleadings there is a purported dispute over that amount. It may be that it is not going to be pressed by Mr. Kanan, but at the moment it is on the table on the pleadings, and I simply drew your attention to it.
Well, Your Honour, it can certainly be dealt with to the extent that it needs to be dealt with, obviously in the light of the information from the preliminary points that Your Honour already has.
Yes. Well, when Mr. Kanan opens, in the light of what you've said, I'm sure he'll let us know whether or not there is some dispute over the Al-Fadel matter. So
Indeed.
Please continue.
Your Honour, I should therefore open the counterclaim, although it's obviously my learned friend's case in this regard. There is complaint in relation essentially to what happened shortly before the hearing of the Abu Zaid matter before the DIFC Court of First Instance in February 2019. The defendant complains about the conduct of the claimant firm in drawing attention to a problem that arose as a result of an interview which they had with one of the principal witnesses, Mr. Zaghloul, which created an inconsistency necessitating their reference to the mandatory code of conduct of the DIFC courts and the email of Ms. Lacan dated the 18th of February setting out the circumstances that arose on the 18th. As far as global advocacy, the claimant is concerned, they were prepared to continue to represent the defendant to the greatest extent possible, consistent with their primary obligation to the court in relation to how the case was presented. And that was fully set out in the email of the 18th of February. In our submission, the claimant had no alternative but to act as they did because an ethical consideration was raised. They dealt with it wholly properly And that was what they did. In the light of what they did, the defendant then chose to disinstruct and instruct new counsel, which was their prerogative. The claimant firm provided absolutely every assistance that they could in relation to that transition process, making all papers available to new counsel and indeed attending upon the court on the 20th of February for the purpose of effecting the transition. But nonetheless, complaint is made in relation to that, and it is, Your Honour will have seen, the claim in relation to damages is essentially a complete recovery and indemnity for the sum that the industrial group was ordered to pay to Mr. Abu Zaid in relation to Mr. Abu Zaid's Article 18 DIFC employment law claim. And we say, A, there was no negligence, no breach of professional misconduct, no breach of fiduciary obligations, because the claimant had to act in the way that it did. And in any event, the calculation of loss simply does not bear scrutiny. So that's what we would say in brief summary, though it's very much a summary, of what we've set out in our skeleton argument. Your Honour asked in relation to witnesses. So far as the claimant's witnesses are concerned, given that Mr. Ali Al-Hashimi is no longer required, we will be calling two witnesses, Graziella Gerges, who relates, and her evidence relates to the Al-Banawi matter, and Ms. Lakan, whose evidence is covering all of the files in question. So far as the defendant is concerned, I understand, and we will be calling our witnesses in that order, Ms. Gerges first and then Ms. Lakan. So far as the defendant is concerned, we raised this yesterday, and I understand, pardon me, that the witnesses will be called in the following order: Mr. Zaghloul, Mr. Hamid, Mr. Jabira, and Mr. Beckley.
Thank you. That's as you are presently intended, is it, Mr. Kanan? In that order?
Yeah.
Yes.
Yeah. May I start my briefing on this matter, Your Honour? First,
in just a minute, I'll just make sure that Mr. Patrick Joyce has finished his opening.
Okay,
is that
sure.
the opening, Mr. Patrick Joyce?
Yes, Your Honour.
Yes, thank you, Mr. Kanan. I'm sorry to have intruded. Please let me have your remarks.
Thank you, Your Honour. Let me first confirm that when we say that the statement, witness statement of Mr. Ali Al-Hashimi is not required, this does not constitute an admittance from our side that the witness statement of Mr. Ali Al-Hashimi it's taken on its face value. No. However, we are of the opinion that the witness examination of Mrs. Lakan will be sufficient to cover all the requirements and questions to be asked in this regard. This is why we said that the state examination of Mr. Ali may not be required. This is to the extent of this only. Your Honor, let me start by addressing certain issues in this case. Let me first make a briefing of the earlier relationship between both parties. The Industrial Group Limited was a long-time client of Global Advocates and Legal Consultant and Counsel for its corporate and litigation matters. For the legal services assigned to the claimant, invoices was raised by the latter. It is to be noted in this regard for these matters that no letters of engagement had been signed between both the claimant and the defendant in relation to the entrusted legal services. This meant that if there were alternative arrangements between the parties regarding payment, the parties should have abided by them. At the very least, the claimant should have warned the defendant if there are any circumstances which would change their arrangement. Nonetheless, there were various invoices which were raised by the claimant pending to be settled. Unfortunately, the parties were not able to mutually agree on the final settlement of the invoices. The claimant then issued a letter before action to the defendant demanding the payment of dirham 1,171,916.87 dirhams within 7 days. A big part of the reason why the parties could not settle the invoices was due to the events surrounding the Rami Abu Zaid case. The claim for the immediate settlement of the invoices was triggered by the defendant's decision to appoint another law firm to replace the claimant and to attend the scheduled trial hearing on 20th February 2019. This was to the claimant's refusal to defend the vast majority of the defendant's claim in the Rami Abu Zaid matter for daily penalties under Article 18 of the DIFC employment law. Mrs. Sharon Lakan, email of February 18, 2019, 2 days earlier to the scheduled trial, advised the defendant that if they will be requested to attend, they would limit their defense to the recovery of the medical insurance cost amount paid on behalf of Rami Abu Zaid to the extent of 14,000 dirhams, and confirming that TIG does not stand any chance under Article 18 of the DIFC employment law. It's normal, Your Honor, that when your own lawyer tells you you don't stand a chance in this regard, and I cannot defend you except for a certain very, very minor amount, this means that to the understanding of the defendant, this does not represent a sound opinion. 2 days before the trial, the claimant believed, both in fact and law, that there was no basis to defend the Article 18 claim against the defendant, which represented the wage of 946 days of penalties. Yeah. So the claimant left the defendant with no other alternative but to urgently solicit the legal services of another law firm. This was 2 days earlier to the scheduled hearing, namely BSA, to appear on the scheduled trial date in order to present the defendant argument in relation to the non-applicability in whole or in part of Article 18 in regarding to the accrued daily penalties. Due to BSA defense, the DIFC courts, fortunately enough, issued its ruling on 28 February 2019, limiting the penalties requested by Mr. Abu Zaid to 388 days rather than his claim of 946 days. This is a 60% saving on the claimed penalties. It is safe to say that that earlier assumption of the claimant was, least to say, unsound. There was no letter of engagement of the Rami Abu Zaid matter. Nonetheless, the actions of the claimant called into question all the claimant's work in the case, especially the work which was made in preparation for the trial and heading up to the trial date. For example, the claimant charged approximately 72,340 dirhams to prepare the skeleton argument for the trial, but wanted to disregard it completely. After preparing it, they decided to disregard it completely, based only on a 15-minute conversation with Mr. Hatem Zaghloul. Mr. Hatem Zaghloul was called to the office for 5 hours at least, questioning and briefing. All of a sudden, examining the witness statement of Mr. Zaghloul took only 15 minutes. Without conducting any due diligence regarding the circumstances surrounding his statement. Further, fees for removing themselves from the case was to the extent of 16,500 dirhams, which was more than approximately the required recovery of the 14,000 dirhams, which the claimant was intended, the claimant actually intended to limit his defense to the recovery of this amount, 14,000 dirhams, disregarding all other issues subject of the claim. Since obtaining the services of the claimant, it was expected that all invoices would need to be reviewed with a view to finally settle them based on a mutual agreement to the final cost to be agreed in due course. However, and upon considering the outcome of the work handled earlier by the claimant, it was the opinion of the defendant that the claimant failed to provide proper and sound legal support to the defendant, which had weakened the defendant's legal stand, and as a result, the defendant sustained substantial moral and material damages for no reason. Then we move now to the defendant counterclaim, Your Honor. The defendant remains of the opinion that the invoices as claimed by the claimant lack merits and highly exceed the time and effort consumed by the claimant, in addition to the damages incurred by the defendant as a result of the unsound legal advice given by the claimant in relation to the various disputes, and in particular, the invalid application of Article 18. The claimant had professional duties towards the defendant, and its conduct in abandoning the main elements of defense without conducting any investigation or due diligence on the ground on which it is relying is a breach of these obligations. There were also failure to inform the defendant prior to 18 February 2019 with its decision to decline from attending the trial hearing of 20 February 2019, and to give the defendant ample time to solicit the services of another law firm which would be able to represent it and plead on its behalf. 2 days earlier to the trial hearing, this wasn't, under any circumstances, this was not acceptable. If they had the decision to decline, they should have informed and alerted the defendant long before, so that the counsel representing the defendant will have sufficient and adequate time to deal with these matters. Also, it is to be noted in this regard that Counsel Lakan stated in her email of 18 February 2019 the following: as practicing lawyers in the IFC courts, we are bound by the mandatory code of conduct, which of course everybody of the same, which sets out that our primary obligation, first and foremost, is to the court, and we cannot mislead the court. This means that we were now limited only defending the point about medical insurance. This is the only point that we can put forward if the trial is to proceed. We can no longer present a defense that there was an agreement in place between Rami and TIG that he would only receive his end of services benefits once he cancelled his visa. What happened later on would show that the counsel that replaced Global was in line with his ethical approach in this matter, and with the IFC Court of Ethical Requirements. Now, this represented a complete misunderstanding to the case. The last minute withdrawal consisted a complete misunderstanding to the case merits, and as a result provided the defendant with wrong legal guidance. If the defendant relied on the 18 February 2019 opinion of the claimant, it would have incurred additional substantial losses of not less than 1,740,960 dirhams. This amount represents almost 60% saving of the Rami Abu Zaid claim, which had been saved to the benefit of the defendant. Regardless of the above saving, the defendant was denied the opportunity to properly argue its case. The defendant agrees that it was very difficult to make the argument that the existence of an agreement with the employee prevent the accumulation of Article 18 penalties, and that the court precedent was not in favor of the defendant in this regard. Nonetheless, this emphasizes the importance of being granted adequate opportunity to prepare for the case in order to advance the main arguments. Unfortunately, this was not the case. As a result of the aforementioned actions, the defendant incurred avoidable costs, such as paying new law firm its fees for familiarizing itself with the facts of the case. In addition, it incurred fees in appeal because it felt obligated to appeal the merits of the case, since it felt that it was not granted sufficient opportunity to make its arguments. For these services and for attending the trial, the defendant paid BSA law firm an amount of dirhams 194,377 dirhams. In addition to the legal fees for BSA, an amount of 1,210,560 dirhams was awarded by the DIFC courts in favor of Rami Abu Zaid. Further, this also meant that Rami Abu Zaid legal counsel was also awarded the sum of 277,682 by consent order, which was only been incurred as a result of the claimant negligence and unreasonable approach to the case and breach of its fiduciary duties. I believe this would give our stand, would confirm our stand in this case. Actually, it's not a question of what been disputed or not disputed. It's a question of the work done, whether this work had been agreed on, whether there was a cap on these invoices. There was never an agreement on the fees or a cap on these fees. It was only left to the discretion of the claimant to decide what are the fees he is looking for. This grant the right from the other side to the defendant to say, I never agreed to these fees, and therefore let us sit and settle. The opportunity to settle was not granted to the defendant because of the triggering of the action 2 days earlier to the trial on the 20th. This is what happened, unfortunately, Your Honor, and we rest our pleading now, our case now.
Thank you. Well, can you, so we may or may not clear one thing out of the way, tell me whether there is any dispute over the actual El Fidel matter and the fees charged for that? Is there any dispute that you should cover money because of the Al-Bazani matter?
Yes, Your Honor, thank you. Actually, all the invoices are under dispute, are disputed for a simple reason that there was no agreement of whatsoever except for Arwa Bannawi matter. There was an agreement for a cap of 10 to 15 hours or 30,000 dirhams in total. All of a sudden, This cap had never been respected and the claim was much higher. This is only an example for the other invoices. The other invoices, even, there was no agreement. There is no letter of engagement in this regard. So all was left to the discretion. In addition, these invoices, the claimant decided that it should be paid within 30 days. There was no agreement on the date of payment. Taken into consideration the load that the defendant had been subjected to at that time. He has to deal with various other issues. Time was essential to deal with these matters. So Abdul Azim matter was one of these disputed invoices, yes.
All right. Well, it looks as if, Mr. Patrick-Joyce, we need to address the El Fidel matter together with the others.
Your Honour, I can see that, and I will obviously take that into account in my cross-examination of the witnesses. Mr. Kanan has said that there were no letters of engagement, save in relation to the Al-Banawi matter. That is not accurate. I have been provided with a copy of a letter of engagement in relation to the Abu Zaid matter. That is not in the bundle for the simple reason that, so far as we could see, the invoices for Abu Zaid had been raised consistently and over a period of time. Those invoices are in the bundle. Some of those invoices had been paid. It was never previously suggested that a letter of engagement had not been entered into, and had that been part of the defendant's case until now, we would have provided that document.
Your Honor, to the best of our understanding, there was no letter of engagement for Rami Abu Zaid.
Right. Well,
this is what we are informed.
Have you been provided with a copy of the letter to which Mr. Patrick-Joyce is referring? Have you seen that letter?
No, sir.
Well, Mr. Patrick-Joyce,
that letter has only just been provided to me because this point has only just arisen, but it can certainly be provided to Mr. Kanan, and it can be provided.
When we receive it?
Just a minute, please. We are suffering from the usual problems of delay in these things. Mr. Patrick-Joyce, could your side please provide, in whatever is the best way, to Mr. Kanan a copy of that invoice? Let me know when that has been. Mr. Kanan, look at it and tell me whether you have any objection to that being also put before me and made part of the bundle of documents. Right, that's how we'll deal with that.
Yes, Your Honor.
Okay.
Thank you.
Well, for the record, it's a letter of engagement, not an invoice, but I think it was clear from the context of what we were providing.
Yeah. All right.
I do understand.
Mr. Kanan, is that the end of your remarks then?
Yes, Your Honor.
Thank you very much. Well, it looks as if we move to the witnesses, and that means Ms. Gurges.
Yes, my first witness is Ms. Gurges, and I wonder if Ms. Gurges can be called in whatever is the appropriate form for a virtual hearing.
Yes, I'm ready.
Ms. Gurges, I take it, is in Dubai, is she?
Yes. Yes, Mr. Honor.
Ms. Gurges, I don't know whether it's intended that you should be on camera. Certainly you're not on camera so far as my screen is concerned.
Yes. Mr. Michael, can you see me now? Is it clear?
I can. Yes, I can indeed, and
Yes.
I hope the court can see you as well.
I-
Your Honour, you can see me.
Mr. Kanan, can you see Ms. Gurjes?
I believe so, yes, Your Honor.
Yeah.
Thank you very much. Well, I will ask that Matha swear Ms. Gurjes in the usual way. Mr. Patchett Joyce, would you then please, in the usual way, get her to adopt her witness statement? Thank you, Matha. Would you go ahead?
Yes, sure. Okay. Could you please state your name?
Graziella Georges.
Ms. Gerges, can you please repeat after me?
Yeah.
I swear by Almighty God to say nothing but the truth.
I swear by Almighty God that that the evidence shall I give shall be the truth, the whole truth, and nothing but the truth.
Thank you.
Yes, Mr. Patchett Joyce, thank you.
Mr. Gerges, thank you very much. I wonder if I could begin by asking you to give your full name and professional address to the court.
Yes. My full name, Graziella Georges. My full address, I'm working in global advocacy as a paralegal since 3 years back.
Professional address?
My address is in Dubai at Rolex Tower, Sheikh Zayed Road, 21st floor.
Thank you very much, Ms. Gerges. Now, I don't know in what form you have your witness statement. You may have an unmarked copy in hard copy, or you may have the availability of the witness statement electronically on the case lines system. Can you help me as to in what form you have your witness statement?
Yes, yes, sure. I act on behalf of Global in this proceeding in the case, in this proceeding in respect of non-payment of legal fees owed by the industrial group.
Well, no, Ms. Gerges, I don't want you to read anything out. I just want you to tell me
Yes.
whether you have access to your witness statement
Yes,
and whether
I
you
have.
have current access to it in unmarked hard copy form or by electronic means.
Yes, I have.
And which is it? Do you have it physically in front of you or do you have it electronically?
I have physically in front of me and electronically as well.
I see. Well, adopting whichever course is most convenient to you, and for the court's reference, the electronic version is at section C, pages 1 to 5, either by reference to the electronic version or the hard copy version. Do you have a document which is entitled First Witness Statement of Graziella Gerges?
Yes.
And if I ask you to look onto the final page of that document, does it bear the date of the 7th of June 2020?
Yes.
And does it have a signature there on that page?
Yes, Mr. Michael.
Whose signature is that?
It's my signature.
And Ms. Gerges, did you have an opportunity to read through this statement before you signed it?
I'm the one who wrote the statement.
You wrote the statement.
Yeah.
So the next question is, can you confirm the truth and accuracy of what is set out in that statement?
Yes, I confirm.
And do the contents stand as true and accurate now, just as they did in June when you signed the witness statement?
Yes.
And I think if I ask you to look back at page C2 in paragraph 4, you will see that there is a reference to exhibits which in the form of the witness statement formed a separate bundle of documents GG1.
Yes.
Now, as I understand it, in accordance with the rules of the Dubai DIFC courts, the documents in GG1 have been assembled to avoid duplication in the rest of the electronic bundle.
Yes.
You're aware that that's the case?
Yes.
Ms. Gerges, thank you very much. I wonder if you'd stay there because my learned friend, Mr. Kanan, may have some questions for you.
Sure.
Yeah, Ms. Gerges, thank you. In fact, I understand what is specifically your scope of work with Global. What do you do there?
First of all, I'm working in Global since 3 years back. I'm a paralegal. I worked in several cases on which Global referred to me to work on it.
Okay. Now, regarding your engagement with the matter
Yes.
of TIG,
Yes.
which you were required to object to a trademark, to a registered trademark with the Ministry of Economy, correct? Yeah. So, in your experience, does the Ministry of Economy appoint a hearing date within 1 month or 2 months or 6 months? What is the normal expectation for a date of a hearing to be appointed by the Ministry of Economy?
Mr. Kanan, it's a known fact that the ministry does not send normal notification or a party for their legal representative and the honors of the party to ensure that they are aware of any court hearing shall be settled by the ministry. There's no specific date. We shall follow up to ensure that the hearing shall be settled, shall be fixed by the Ministry of Economy on daily basis.
This is well understood, and yeah. I'll assume that this is correct. But at the end, yes, you will be advised of the hearing date, right?
Yes.
Okay. Now, normally, out of your experience, what is the normal time span to schedule a hearing date?
As I mentioned before, that it's a known fact that the ministry does not send normal notifications. So usually, the Ministry of Economy will set a hearing according to our submissions. It may be by, let's say, 1 week, 2 weeks. But according to the fact that the ministry has a lot of cases, and according to the ministry, do not inform and do not notify the party or their representative, and the onus on the party to ensure that we are aware on the date set by the ministry. Therefore, we shall follow up on daily basis in order to ascertain that we are on the same path and on the same track for the client, for the favor of the client.
Mrs. Giles, earlier to this matter, were you instructed to attend any trademark infringement hearing earlier to this case?
Yes. Following.
This is the first time?
Mr. Kanan, following our meeting with Mr. Buckley on 24th, we discussed all the documents and we discussed.
This is not my question. Sorry, Mr. Garrett.
Yes.
What I'm trying to ask is that earlier to this assignment, were
Yes.
you ever assigned for hearings with the ministry regarding a matter, a trademark matter?
Sure.
Okay. What was the time span to schedule a meeting?
This is what,
Normally.
yes, this is Mr. Kanaan, what I'm saying. There's no time with the Ministry of Economy. And I confirmed that with the trademark department, we shall follow up on daily basis to ascertain and to
On daily basis?
Yes, on daily basis. Otherwise, we cannot even be informed because the Ministry of Economy will not inform and will not notify the parties on the hearing date or any notification received. There was no notification received from the Ministry of Economy. So our responsibility is to do a regular contact with the ministry to ensure that there's no dates are missed and the case is wholly compromised.
What happens if a hearing was scheduled and you were not notified of the hearing date and did not attend? What will happen then?
Exactly. Mr. Kanaan, if the hearing is scheduled, we will lose the case if we cannot, if we will not follow up and if we will not attend. The Ministry of Economy, it's while they will finalize and they will take decision that we did not intend on purpose and we might lose the case.
So you're understanding that you need to follow up daily, ask the ministry whether there is a date appointed. Is
Sure.
this correct?
Sure, yes.
Okay. And okay. Now, out of your earlier experience, what was the average time that the ministry would schedule a hearing?
As per my experience, the ministry can schedule a hearing anytime. Therefore, as discussed before, that the Ministry of Economy, it's a known fact that does not send a normal notifications. And according to that, we shall follow up on daily basis, whether it would be in Dubai or in Abu Dhabi, the court hearing date, in order not to miss the case and not to miss the date for the hearing at that time.
Out of your earlier experience,
Yes.
what was the last time you had a case and what was the time span that the hearing was scheduled? In 1 week, in 2 weeks, in 3 months, in the last matter you have attended to?
Yes. Mr. Kanaan, as per my experience and as per the cases
I'm talking
received,
about
yes,
actual, sorry, interrupt.
Exactly.
What happened with you the last time you attended a hearing? What was the time that, what was it, 1 month, 2 weeks after you have filed for the objection, or it was within few days or few months? What was your experience in the earlier matter?
Mr. Kanaan, as I told you before, it depends from case to other. So this is my answer. It depends from case to other whether the Ministry of Economy will schedule a hearing for that case, and it depends on the Ministry of the Ministry of Economy discretion in this regard.
It's well understood that this is the ministry discretion.
Exactly.
However, your experience regarding the last hearing you attended before this, what was the time factor? Before the appointment, one day, what was in your last experience before this one?
Mr. Kanaan, as I said, that it depends from case to other, whether the ministry will schedule a hearing after the summit. Yes.
I'm asking specifically regarding your last experience with a hearing before this hearing. What was the time scheduled for the hearing? Was it within 1 month of your filing, or earlier, or more? What exactly happened in a matter earlier to this matter?
Yes, Mr. Kanaan. As I said, it depends from case to other. So, yes.
One moment, would you both please be silent? Ms. Gurgis, Mr.
Yes.
Kanaan is trying to ask you a specific question, and you are, I'm afraid, not really answering it. He is asking you to turn your mind to the case that you had before, immediately before the TIG case. And he's asking you to tell him in that particular case, if you're able to, what was the time between the filing and the hearing? I think that is what you want, is it not, Mr. Gurgis? Mr. Kanaan. So please turn your mind to that particular case, if you can remember it, and answer that question.
Yes, yes, my honor. As I said, my honor, that it depends on the case, and it depends on whether the Ministry of Economy will schedule a court hearing direct to filing our submissions, let's say. It may be after, it may be within 2 to 3 months, or more than 3 months. So it depends on the case.
It seems, Ms. Giles, that you are not ready to answer this specific question. Thank you. Now, okay, so where such daily or periodically follow up, in fact, necessary from your side? I understand that you have mentioned that the ministry will not tell you about the date, which I believe it's not the case. However, taking into consideration what you are saying, in this specific case, how many times during the period, what was the period before, in this specific case, what was the period that the ministry appointed a hearing after filing? How much this took time? What is the time consumed?
Yes, Mr. Kanaan, as I said, I confirm that all contact with the trademark was necessary to ascertain the status of the objection. The reason for the regular communication with the Ministry of Economy in Dubai or in Abu Dhabi was to ensure that the claimant was aware of the hearing date set for the defendant case.
I fully understand, Ms. Giles.
Yes.
But the question is simply, in this specific matter, since the filing until a hearing was scheduled, what was the time spent?
The time spent since the hearing, since we filed the case until a hearing date is scheduled, the time spent was for communication.
Time span, and the period.
I know the period was 2 to 3 months for making communication and for following up with the Ministry of Economy in order to get the set date for the hearing.
The period for this hearing was 3 months after filing. Would you confirm this?
Yes.
Okay. In fact, it was around 6 months.
Okay.
However, regardless of this, how many times you contacted the ministry to inquire? How many times you had a telephone contact with the ministry to inquire about when the hearing will be scheduled?
As discussed, Mr. Kanaan, I cannot count how many calls, how many phone calls I did with the Ministry of Economy. I cannot count the phone calls, but what I mentioned and what I'm assumed that I confirmed that all the contacts and all the telephone calls with the trademark department was necessary to ascertain the status of the objection and to ensure that no dates are missed and the case is wholly compromised.
I fully understand this, Mr. Gerges, but the fact remains that your billing was based continuously on the phone calls you have made to the ministry.
Exactly.
Okay.
It's
so how many, I'm asking you, how many phone calls you have made during the 3 month period, as you said?
As discussed, Mr. Kanaan, I cannot count the phone calls according to my obligations before the defendant. So I should do these phone calls in order to ascertain in order to ascertain that the status of the objection and was necessary to ascertain the status of the objection.
During the meeting which took place on around 24 October 2017 between your good self, Mr. Fakhri, and Mr. Beckley, did Mr. Fakhri inform Mr. Beckley that the time needed for this matter would not exceed 10 to 15 hours?
Can you repeat again, please, Mr. Akram?
There was a meeting which was held in your presence with Mr. Rabia,
yes,
of your firm. In the meeting, Rabia confirmed in this case 10 to 15 hours.
Mr. Kanaan, I agree that on 24 October 2017, we met the defendant and my colleague at that time, Mr. Rabia. During the meeting, we discussed the Ministry of Economy case only.
But there was, there was a confirmation, which is in writing actually, that the time to be consumed on this would not exceed 10 to 15 hours with a rate of 1,700 dirhams per hour.
No, Mr. Kanaan.
Okay, as you said, it is there in the, anyway, it is the bundle C, bundle C,
C page 32, C32 to cert 30.
C32 to C33.
No, Mr. Kanaan, because during the meeting on the 24th October, we discussed only the case. And the defendant did not mention anything about the fees. And we did not discuss the fees at that time on the meeting.
So in your opinion, there was no confirmation from Mr. Rabi' regarding the fees, the cap of fees to be to the extent of 10 to 15 hours. There was no such a thing.
No.
Thank you. That's it from my side, Your Honor.
Thank you, Mr. Kanaan. Mr. Patrick Joyce, is there any re-examination?
Very short re-examination, Your Honour. Ms. Kanaan, we know that the period in question...
Ms. Gurgis.
Sorry, Ms. Gurgis. My apologies, Ms. Gurgis. We know that the period in question was late 2017 through to 2018. So we're talking of a period of 2 years or more ago. Do you have a vivid recollection of every single telephone call that you made 2 years ago?
Yes.
And if we look at the invoices which we have in the file, we don't need to look them up. I think they range from page D8 through to page D52. Those are the invoices raised by the claimant firm on behalf of, or in relation to, the Al-Banawi file. Yes. Have you had an opportunity to look through those invoices?
Yes.
And in respect of the times and the matters recorded there, are they accurate?
Yes, they are.
Ms. Gurgis, thank you very much. I have no further questions.
Thank you, Mr. Michael.
Yes.
Just Your Honour, the judge may have some further questions, Ms. Gurgis, so you're not released just yet.
But I will release Ms. Gurgis unless either of you wishes to have her retained. She seems to have completed her evidence.
Not from me. It's okay from my side. Thank you.
I'm very happy for her to be released.
Yes,
thank you, Ms. Gurgis, for your assistance. You are free to go. You are released as a witness.
Thank you. Thank you. Honor.
Thank you, Ms. Gurgis.
Well, now that then it's Ms. Lakan.
It is indeed, Your Honour, and perhaps we can follow the same initial process with Ms. Lakan.
Yes, thank you.
Then maybe just a short delay. I apologise. Ms. Lakan had logged out while Ms. Gurgis gave.
So I think I have Ms. Lakan on screen.
Yes, I can confirm I do.
Good morning, Your Honour.
Mr. Kanan, do you have Ms. Lakan on screen? Oh. The small icon of Mr. Kanan seems to have frozen on my screen.
Yes. I have Mr. Kanan on screen and moving. Mr. Kanan, could you say something? I'm not sure about your sound.
Yeah, I am available, Your Honor. Thank you.
Very good.
Mr. Kanan, can you see Ms. Lakan as well?
Yes, I do. Thank you.
Good.
Please proceed, Mr. Patrick Joyce.
Your Honour, would it be appropriate for her to be sworn in the way which...
Martha, would you please swear Mr. Khan in the normal way? Mr. Khan, I take it, is also in Dubai.
Yes, Your Honour.
Thank you.
Could you please state your full name?
Sharon Christina Larkin.
Thank you, Ms. Sharon. Could you repeat, please, after me? I swear by the Almighty God to say nothing but the truth.
I swear by Almighty God to say nothing but the truth.
Thank you.
Yes, thank you, Mr. Patrick Joyce.
Thank you, Your Honour. Ms. Lakan, I wonder if you could begin by, you've confirmed your full name, perhaps you could give us your professional address.
Level 21, Rolex Tower, Sheekside Road.
And Ms. Lakan, you have made one witness statement recently in this matter, but there is another of your witness statements which is also in the bundle, so I shall take you to both witness statements. Could you first turn to either in electronic form, which begins at page C9 of the case lines material, or if you have it in hard copy form, a document which begins first witness statement of Sharon Christina Lakan, and it identifies you in paragraph 1 as a partner and head of dispute resolution at Global Advocacy. Do you have that document, Ms. Lakan?
I have my witness statement of the 7th of June.
The 7th of June. That is the witness statement that I'm asking you about. For electronic convenience, it is to be found at pages C9 through to C18 of the case lines electronic document bundle. Could I ask you to turn on to page C18 and there should be a statement of truth with a signature there.
Sorry, 1 minute. Yes, correct.
Just so that we are clear that it's the same document, does it bear the date of the 7th of June and whose signature is that?
I confirm the date, and that is my signature.
And before you signed this document, did you have an opportunity to read it through and check it for truth and accuracy?
Yes, I did.
And were the contents of this document true and accurate when you signed the witness statement?
Yes, they were.
And do the contents remain true and accurate today?
Yes, they do.
And I think in the course of the witness statement, there are references to various documents which in that witness statement are identified as exhibits. But those documents have been set out separately, as is the custom within the DIFC courts to avoid duplication in the remainder of the electronic bundle. Are you happy that the documents which you've referred to are also faithfully reproduced in the electronic bundle?
Yes, I believe they are.
And perhaps I can then take you to the other witness statement, which is at page G99 through to page G101.
Yes, I have that.
And this is a witness statement which you gave in other proceedings, namely proceedings in which Mr. Rami Bahi Hassan Abu Zaid was the claimant. It should be entitled again, Witness Statement of Sharon Lakan, and identifies you as then solicitor employed by Global Advocacy. You've been promoted in the meantime.
Yes, correct.
And if we look on to page G101, there is a date, but it relates to the 19th of February, it states the 19th of February 2018. Is that a correct date?
I think that might be incorrect.
And what should it be dated? How should it be dated correctly?
It should be February 2019.
And with that correction, is there again a signature under the statement of truth?
Yes, there is. That's my signature.
And again, same questions. Did you have an opportunity to read this document through before you signed it?
Yes, I did.
Were you happy that the contents were true and accurate?
I was.
And are you content that the contents remain true and accurate?
Yes, I am.
Ms. Lakan, thank you very much. There will be more questions from Mr. Kanan, but those questions verify your evidence in witness statement form. Thank you very much.
Thank you.
Thank you, Mr. Kanan.
I'm afraid I can't hear Mr. Kanan. It seems that he is...
Sorry. Okay. I refer to to paragraph 4 of your first witness statement of 7 July 2020, bundle C, page C10. Did the claimant issue any letters of engagement other than the letter in relation to the Arwa Banawi matter, which is bundle D, page 10, D12?
Yes, there were other engagement letters issued to the industrial group.
Would you be able to specify which letters of engagement were issued for the other cases or matters?
Yes, so to my knowledge, there was an engagement letter issued for the Rami Abu Zaid case. There was also an engagement letter issued for the Abdulazim Al-Fadl case.
Was either of these letters countersigned by the defendant? If there is these letters, were they countersigned by the defendant or counter-agreed by the defendant?
To my knowledge, the engagement letters were not returned signed, but I haven't checked my records to confirm that since the issue cropped up this morning.
Okay. You stated in paragraph 20 of first witness statement, bundle C, page 14. Mr. Zaghloul started talking without prompting and made statements that were completely different from what had been said in his witness statements that amounted to serious inconsistencies with the whole defense that we had been instructed to put forward. Based on your email of 18 February 2019, bundle G, pages G97 to G98, to the defendant, is it correct that these statements related to the following statement, which is Hatem told us that he was paid his end of service benefits twice without his visa being cancelled. So his understanding and personal experience completely contradicts what was in the alleged agreement in the first place. It is clearly not the policy across the company that visa cancellation is required before end of service is paid. And this is also contradictory. Were you in the meeting with Hatem Zaghloul when he made this statement?
Yes, I was.
You were, okay. When you were informed that Mr. Hatem Zaghloul had cancelled the visa without payment of the end of service indemnity, did you inquire as to whether there were special circumstances which allowed for the payment of the end of service indemnity without the cancellation of the visa, in particular regarding Mr. Hatem Zaghloul?
No, if I can explain. When the statements were made, Ms. Wilkie, who was going to be the advocate in the proceedings, asked me to step outside. We had a discussion about her concerns, and then we re-entered the meeting room. I was only in there for a short period of time after that. Ms. Wilkie continued with the discussion.
Yeah, but do you recall that Mr. Hatem Zaghloul advised you the reason why his visa remained and he has paid his end of service?
He didn't advise me for the reasons, no.
And you did not inquire from him as well?
I didn't, no.
You did not. Are you aware that Mr. Hatem Zaghloul is a board member of all of the TIG group, and he works not only with TIG Dubai but also with other TIG companies in the area and this Europe and here?
I don't recollect what his position was. I do know that he used to travel a lot.
And you did not ask him why his visa and payment made to him was made earlier to the cancellation of his residency visa. You did not check from him.
I didn't know.
I didn't know. You didn't know. Okay, so, but then you assumed that that there is a hopeless case you will be handling in the trial due to the fact that this is contrary to Article 18 specific requirements.
No. My colleague and I were concerned that the witness had been dishonest in his witness statement and that he was going to perpetuate that untruth when he gave evidence before the court. And we informed the client that we would not be able to put those statements to the court for that reason.
Do you recall what is the discrepancy or this dishonesty in his statement?
Yes, Mr. Zaghloul had indicated that there had been an agreement between him and Mr. Abu Zaid, and during our meeting, he categorically said there was no agreement.
In your opinion, was there an agreement?
I'm sorry, why is my opinion relevant? I'm here as a factual witness.
Okay. Mr. Hamid processed the payment for the end of service indemnity. He is the person in charge. He had stated in his witness statement, bundle C, pages C23 to C24, that it was the company policy to check that the visa was cancelled prior to the payment of the end of service indemnity. Did you inquire from Mr. Hamid whether it is a standard practice that the end of service payment would first require the cancellation of the residency visa?
I think I need to explain something, Mr. Kanan. I was not the lawyer who was conducting the advocacy for the trial in the Rami Abu Zaid case. So a lot of the discussions were with my former colleague, Ms. Wilkie.
But you sent an email on February 18, correct?
Correct.
Then, and it is the understanding that you were involved, Ms. Lagan.
Yes, of course I had some involvement. I was the head of the department.
Oh.
And my colleague, Ms. Wilkie, and I drafted that email together. It was considered appropriate that I send that email out because I was the head of the department, but it was drafted jointly with Ms. Wilkie.
But this email was addressed to the best of your knowledge and based on the information you were aware of?
Yes.
Okay. Did you inquire from Mr. Hamid whether any employee earlier to the matter of Rami Abu Zaid had been paid his end of service prior to the cancellation of his visa?
I don't recollect that I ever asked that question.
So can we say in this that you were not fully aware of the practice and arrangement and procedures within the company which requires the payment of the end of services at the time of the cancellation?
I was aware that that was something that had been raised, but as I mentioned, Mr. Kanan, Ms. Wilkie was the one making those inquiries, and there were detailed inquiries made, as I understand, in relation to all of these points, not necessarily by myself personally.
Okay. The original meeting of 18 February 2019 with Hatem Zardoul was scheduled for several hours. Given that only 15 minutes were spent during the meeting, why was no action taken to investigate the company's standard procedure for the payment of the end of service upon visa cancellation? What I understand here is that you have requested
Mr. Kanan.
Sorry.
I'm going to reject that question because you began with asserting matters which Ms. Lacan has not yet agreed with. That is, the original scheduling of the meeting, how long it took, and so on. If you want to ask that sort of question, you need to first address whether she agrees with those or have knowledge of those.
Thank
The
you,
question was an unfair question for that reason.
Thank you, Ron.
How long was it? How long was it?
How was Mrs. Lacan, basically, when you requested a meeting with Hatem Zardoul, what was the time to be consumed, scheduled to be consumed in this meeting?
I don't believe I was the person that requested the meeting. I believe that was likely to have been my colleague, Ms. Wilkie. But it would have been scheduled for a significant period of time.
But were you briefed of the meeting that the result of the meeting held with Mr. Zardoul by the other lawyer?
I'm sorry, Mr. Kanan, could you repeat the question? I didn't hear the question.
Were you briefed by Mrs. Nimi of the meeting, of the discussion made during this meeting?
So I attended the meeting. I believe it's set out in my witness statement. Mr. Beckley attended with Mr. Zaghloul. Ms. Wilkie and myself were also present. Mr. Beckley left after a few minutes, and I was probably in the meeting myself for maybe 15 or 20 minutes only. And then the meeting continued between Mr. Zaghloul and Ms. Wilkie.
Okay. You had stated in paragraph 23 of your witness statement, bundle C, page C15, we fully attended to continue to represent TIG at the trial on the limited basis ultimately set out in our email of 18 February 2019. Let me ask you to clarify what was the limited basis you referred to.
If you look at the email that I sent to the client indicating that there had been a statement made to us demonstrating that there was evidence going to be put to the court that was untruthful, we were not prepared to raise those statements with the court. We were prepared to continue to run the case on the basis of the health insurance, but we were not going to be in a position to put an untrue statement to the court.
Is it correct to say that the intention was only to plead in relation, to argue in relation of the 14,000 dirhams cost incurred by the company on behalf of Mr. Rami, but you were not ready to argue or plead in relation to the daily penalty under Article 18. Is this correct?
We were absolutely ready to run the case. The preparation had all been done. The issue, as is clear from my witness statement, is that there was an untruth that was going to be put to the court. We were not going to run that point. Every other point in relation to the other aspects of the defense, we were willing to run.
But it is well understood, Mrs. Lakan, that the 14,000 recovery does not even represent 1% of the claim which the client was, the defendant was interested to defend. You were talking about not less than 2.5 million claim for daily penalties accrued under Article 18. So what I understand that your answer was your defense will be limited to defend the recovery of the 14,000 dirhams only. Is this correct?
We were prepared to defend and to run the defense in relation to the healthcare issue, the whole issue.
Which is the 14,000 dirhams only.
And the penalties related to it.
The penalties related to the 14,000 dirhams. Is this correct?
We were, as I have already said, Mr. Kanan, yes, we were prepared to run the defense in relation to the health insurance aspect. I don't think I could be any clearer.
To the limitation of the recovery of 14,000 dirhams only.
Mr. Kanan, I've already answered that, I'm sorry.
Okay, thank you. In your email, you mentioned that...
Could you give me the page reference again, please?
Okay.
Where is it?
Thank you, I have it.
And this means that you stated in your email that this means that we are now limited only defending the point about the medical insurance. This is the only point that we can put forward. The trial is to proceed. This is what is mentioned in your email, right?
I'm sorry, could you direct me to the paragraph that you're looking at?
This is...
I have it, it's okay, I found it.
97, paragraph 6.
I have it, thank you.
Yeah. Okay.
Yes, correct, the medical insurance, that was what we were going to proceed with.
You added that your best case scenario is that you will not have to return the 14,000 to Rami. Correct, right? So in your opinion, this was the best case scenario for the recovery only of the 14,000 dirhams.
My email is there, Mr. Kanan. It speaks for itself.
Speak for itself. Okay, sure. Do you agree that this email would be interpreted by the defendant that it is a decline from the claimant's side to represent it and provide its arguments in relation to the invalidity of the daily penalty in whole or in part? Is this correct?
Sorry, what was the question?
Do you agree that this email would be interpreted, email of 18 February, would be interpreted by the defendant that it is a decline from the claimant's side to represent and provide its argument in relation to the invalidity of the daily penalty in whole or in part? So exactly what you are saying exactly is that you will not be representing, you said that you will not be representing the defendant for any other thing other than 14,000. Is this correct?
No, it's not correct.
Okay. When? Okay. Would you agree that the defendant prerogative to appoint another firm to defend its interest under Article 18 had served the rightful interest of the defendant and as a result reduced the claim of Mr. Abu Zaid by around 60% in light of the legal and valid arguments raised by the other law firm?
I don't know what the question really was, Mr. Kanan. Would you mind framing a more precise question?
Sure, Your Honor. Thank you, Your Honor. The question here is that considering of the limitation of the argument to be that the claimant was ready to produce, this led the defendant to replace Global by another law firm. The end result of this replacement is a 60%, almost a 60% saving out of the claim of Mr. Rami Abu Zaid. In other words,
Mr. Kanan, there are at least two questions so far mixed up, and you're about to ask a third. Please ask precise questions, not a whole collection of questions in one go.
Thank you, Lama. Would you agree with me that the replacement of Global by another law firm as resulted by the 2 days, as a result, the defendant had got a benefit of reducing the claim value of which you were not ready to do? Is this correct?
Mr. Kanan, honestly, there's so much in your question, I don't really know how I'm expected to respond.
Fine. It's a simple question.
It's not a simple question.
Okay.
It's convoluted and it's difficult to understand. If you ask me a simple question, a straightforward question, I will answer it willingly.
The simple question is that it is well understood that you have declined to represent the client.
Well, that's not understood at all, Mr. Kanan. I'm sorry, I've already said that.
Fine. You had started in paragraph 31 of your first witness statement, bundle C, page C16, stating, from my experience...
Sorry, just bear with me one moment while I pull it up.
Moving now to the question of the billing. You mentioned that from my experience with the industrial group, they review all the invoices as they came in and raised issues immediately, if in fact there were any. Would you consider that the reason for not settling your invoices was in relation to the absence of a letter of engagement and or professional fee cap that would regulate the question of payment?
My understanding from the industrial group for the reason for non-payment of our fees was cash flow.
Okay. But you agree with me that you mentioned that there was a letter of engagement. However, this is beside the issue now. The different understanding is different to this. Would you consider that the reason for not... did you inform Mr. Beckley that the fee estimate which you provide for the Bradley Dexter case, as set out in the email of 12 February 2017, were being exceeded?
Give me the bundle reference, please, Mr. Kanan.
Bundle F, page F2.
Thank you.
Okay. Did you, again, I repeat the question, did you inform Mr. Beckley that the fee estimates which you provided for the Bradley Dexter case, as set out in the email of 12 February 2017, were being exceeded?
I don't recollect whether I did or not, but the industrial group was being invoiced for this matter on a monthly basis. So they were aware of the fees.
But the invoicing was the discretion and the estimate of the claimant, and there was no approval from this at that time, consent from the side of the dependent. Is this correct?
Sorry, I don't understand what you're asking.
Yeah, the invoices which were raised, it was raised by the mere assessment made by the claimant regarding time and effort made. But these invoices had not been endorsed. Or were these invoices endorsed or accepted by the defendant?
They weren't rejected, let me put it that way.
They were?
Not rejected.
Not rejected. Okay, thank you. Did you at any time inform Mr. Beckley with respect to the Bradley Dexter case that the original scope of work was being exceeded?
I don't believe the scope of work was exceeded. What is your basis for saying that?
This is your statement, what you have advised Mr. Beckley of. Actually, the scope of work in the beginning was for the maximum sum of 30,000 dirhams.
No, I'm sorry, Mr. Kanan, that wasn't the scope of work. The scope of work was to advise the industrial group in relation to proceedings that they wanted to bring against Mr. Dexter. What is in my email that you're referring to is a fee estimate, and I very clearly said that for DIFC litigation cases, we charge on an hourly basis.
Yeah, but did you inform Mr. Beckley of this? That this is the situation, that you will increase, that you would be able to exceed the cap of 30,000?
I think I've already answered that, Mr. Kanan.
Sorry?
I've already answered that.
Okay. Did you obtain the consent of the defendant before exceeding the fee cap? Was there any approval?
Sorry, Mr. Kanan, there was no fee cap.
Okay.
Please look at my email. It clearly says approximately.
You're asking regardless of the cap. Now, in your email, you have mentioned for the DIFC litigation cases, we charge on an hourly basis. For the type of application, I would estimate that our fees would be approximately 20 to 30,000 dirhams. This is regarding Dexter. Assuming that the application is made against only Mr. Dexter, and that the challenges production. If we add West Truck, then I would expect them to challenge the application, which would increase the cost somewhat. It says if there is no challenge to the application, then I would estimate cost to be between 10,000 to 15,000 dirhams. Keep in mind that the successful party in DIFC proceedings can recover a significant portion of their legal fees from the other party. I hope this assists. Let me know if you would like to arrange a call or a meeting to discuss. In addition to this, did you provide any fee estimate for the hourly basis?
This was on an hourly basis.
Okay, so in particular, this was the fee estimate for the hourly basis. Is this correct?
Correct.
With a ceiling as it's referred to in this email. So, Mr. Bexley, was Mr. Bexley advised thereafter of any change of this assessment or of this assessment of invoicing?
Mr. Kanan, I think you asked that previously and I've already answered it.
Okay.
I nonetheless would like to be clear on this, Ms. Lackham. I think what Mr. Kanan is asking is along the lines, once the fees got over 30,000 dirham, did you say anything to Mr. Beckley along the lines, I should let you know that the fees are over the $30,000 in the email?
I don't recollect doing that, Your Honour. But there were invoices being issued on a monthly basis. And I think because the application took a lot longer than originally anticipated, we were expecting that the application will be dealt with within a month or two. Actually, this matter went for 18 months or more. So it was sometime later when I had the discussion with Mr. Beckley about the fact that the fees had increased.
Hey, one moment, please. You know the rules. You just answer the question. The question was simply, did you say something to Mr. Beckley? The answer I gather is you don't recollect having done so.
Not until significantly later. I don't recollect, no.
Thank you. Yes, Mr. Kanan.
We refer to exhibit email of 30th April 2018 of your witness statement, bundle E, page E2, setting out your views regarding the Article 18 penalties. We also refer to Mr. Beckley witness statement and response set out in bundle C, pages C38 to C39. When you received the email from Mr. Beckley in response to the email setting out your views about depositing the salary in court, did you investigate the possibility of depositing the remainder of his April salary in order to avoid exposure to Article 18 penalties?
I believe we had a discussion with Mr. Al-Hashmi and the chairman of the industrial group and Mr. Beckley.
But regardless of any possible discussion, my question was, there was an email that on 30th April that you have addressed to Mr. Beckley. Mr. Beckley addressed your email inquiry regarding the matter, regarding the payment of the April salary. Your response...
There was no response.
No, sorry. Mr. Beckley asked you in his email of 30th April whether they can deposit the April salary at the DIFC court in order to avoid penalties. Did you respond to this email?
Not in writing. There was a discussion in a meeting or a teleconference.
But as you remember, he sent you an email, but there was no response about this particular question raised by Mr. Beckley.
No written response, correct.
In your opinion, if the amount of the salary payment was deposited at that time with the DIFC court, would this avoid the accruing of penalties under Article 18?
I would have to give that some thought, Mr. Kanan.
Okay. Did you provide him with an answer? I think this is from our side. The questions are complete. Your access, your honor.
Yes.
Thank you, Mr.
No further questions on this matter.
Mr. Patrick Joyce, any re-examination?
Again, very short re-examination, Your Honour. You were asked about letters of engagement and counter-signatures. I wonder if you could look at sorry, my apology, I think it's D12. Can you look at D10 in the first instance?
Yes.
That should be a letter of engagement. It's entitled as such. It's actually dated November the 25th of 2017, but Ms. Gerges has corrected that date to November the 2nd, and that doesn't seem to be a matter in issue. But could we look on to page D12, please?
Yes.
And paragraph 15 in that letter of agreement, letter of engagement.
Yes.
By reading paragraph 15, does that help with regard to the binding nature or otherwise of a letter of engagement, even if it hasn't been countersigned?
Yes, absolutely. That's why it's in there.
Isn't that a matter for me, Mr. Joyce?
It may be, Your Honour. And I would formally apply for the admission of the letter of engagement in relation to Mr. Abu Zaid. And again, the same point will arise, being a matter for Your Honour.
Mr. Canaan, if you received that letter of engagement that Mr. Patrick Joyce wants to add to the bundle?
Yes, we did, Your Honor.
Is there any objection to
But
that
we need
being
time to review it and comment on it.
All right. Well, I anticipate we'll be having a short break soon. So if you would be good enough to review it over the short break. Mr. Patrick Joyce, I think,
Your Honour, I'm very happy for Mr. Canaan to have that facility over the short break. I certainly wouldn't want him to be taken by surprise in any shape or form. Very happy with that.
I can review it now.
It's going to give you a break.
Huh?
It's going to give you a break to review it.
Okay, if we have a break to review it, thank you, Your Honor.
I didn't quite catch that. You would like time to review it still?
Yeah, will there be a break that I can give me the time to review it?
Yes, you shall have time to do that over a break that we'll have shortly.
Thank you.
Mr. Patrick Jones, Patrick Joyce, it's a matter for you, but one thing that I am uncertain about is Ms. Lacken's answers concerning whether Mr. Beckley's email of the 30th of April talking about payment of the El Fadil money into court was responded to. She said it wasn't in writing, there was a discussion about it. That leaves it quite up in the air to my mind just how that matter ended. I think it is a matter for you, but you might think it desirable that I should know what happened.
Your Honour, I'm very happy to clarify that, and that is, I think we need to go in the bundle to E2, Miss Lacan.
E5 is the one I think it is. Let's make sure about the same thing.
Yeah, I think it's a series of emails, which in the nature of these things is nearly but not quite in reverse chronological sequence. So should we just begin by identifying the proper sequence, Ms. Lacan? I think all the emails on pages E2 to E7, of which E8 is a continuation but contains no substantive text. So let's look at E2 to E7. I think if one looks at the foot of E3 first, there was a very short email providing matters for your information from Mr. Beckley to yourself. Do you see that?
Yes, I do.
And then I think the next email in course of time is the one above it on the same page, timed at 10:26 a.m.
Yes.
The third email in sequence is that timed at 4:06 p.m. on E2.
Yes.
And the fourth email in point of time is that on E5 timed at 4:32 p.m.
Sorry, let me just find that.
E5.
At 4:32 p.m., yes.
Now, for the sake of completeness, at the foot of that page is a further email, but it is timed at 4:06, and if one goes on to E6, one can see that it is a duplicate of what we've already seen at E2. And if we go on to E7, we can see that E7 is a duplicate of what we have already seen at E3, and we've already established that there is no need to go on to E8. So there are 4 emails in sequence.
Yes.
And it may help if you just go through, perhaps beginning with the email on received at 10:26 or sent at 10:26, back on page E3, and that says, "Dear Sharon, this is from Mr. Beckley. Further to our conversations this morning, Chairman has requested in writing Global's concurrence that the group not pay a monthly April salary to Mr. El-Fadl."
Mr. Patrick, one moment. This is going well beyond what I had in mind and well beyond any permissible re-examination. I had understood that the evidence as left at the end of the cross-examination was that Thackham had not replied to the email of 4:32 p.m. in writing, but there had been a discussion with Mr. Beckley, and that is where it was left. What I was
Chief, I'm exceeding what is permissible in re-examination. I'm acutely aware that I can only ask questions arising to clarify. My note was that Ms. Lacken believed we had discussions with Mr. Beckley, and then there was the specific point about the deposit at the DIFC courts. She didn't respond in writing, but there was a telephone conference. There was no written response. And then she was asked a legal point, to which she said she'd need to give that some thought. I was looking at the whole of the day because it seemed to me from her answers that all of these emails were in play. But perhaps I can leave it on this basis or ask Miss Lacken to clarify. You've heard, you've been taken to these emails. You have been asked specifically about the final email at 4:32 on page E5. That email ends with a question, what do you think? How was were the discussions and email correspondence that took place on the 30th of April left?
So there was no response, as I said, in writing. There was no written communication dealing with this point. But at the time, due to the nature of the case, we were speaking multiple times a day over a substantial period. So there were conference calls, meetings, telephone calls regularly. And I recollect, I don't have a very good recollection of what was discussed, but I recollect that this point was raised in a discussion.
And we'd now be going back 2 years, and that's as far as you can take it, Ms. Lacken.
Yes.
Thank you, Your Honour. I don't have any further questions.
All right. Mr. Kanan, my question perhaps went beyond Mr. Patrick Joyce, beyond re-examination. So if there is anything you wish to ask flowing from my query, please feel free to do so. Is there anything you want to ask on that matter?
Well, I have just a final clarification required into this effect. There was a very important specific question which had been addressed by by William Beckley to Mrs. Sharon, requesting her specific opinion, reading as follows: what is the possibility of making the payment into court to be held by the court pending the disposition of a possible claim against him? This question was highly important for the defendant to have this clarification. Did Mrs. Sharon respond in particular to this question? Did you?
As I've already stated, Mr. Kanan, I did not respond in
You did not respond. Thank you.
To the client.
Thank you.
But there were verbal discussions with the client.
Verbal discussions regarding the same exact issue?
That's
Or
my
different
recollection,
issues?
yes.
To the same exact issues?
That's my recollection, yes.
And what did you advise Mr. Beckley accordingly? What was your advice to him?
I'm afraid I don't recollect the specific advice, Mr. Kanan.
You don't recollect. Thank you.
Yes. Thank you very much. Now, is there any reason why Ms. Lackham should not be excused as a witness?
I have no objection, Your Honour.
Mr. Kanan, any objection to that?
No, not really. Thank you, Your Honor.
Thank you, Mr. Lackham. Thank you for your help. Feel free to go as witness.
Thank you.
Well, gentlemen, we've been going for a couple of hours. It might be time to have a short break. What I propose is that we break for, say, 15 minutes for a bit of relaxation, and then resume, and we'll then be starting, Mr. Kanan, with your witnesses. Was that correct?
Correct, Your Honor.
I should say, video has become rather difficult. You were frozen for a considerable time, although the sound was good. I wonder if during the break someone might look into the quality of the video that we're getting from you.
No, it's okay, Your Honor. From our side, it's okay.
Okay.
It's clear.
All right.
It's clear.
We'll take a
If I
break.
could also ask, during the break, is it possible in Skype for Business to mute the sound, or would it be sensible to come out of the meeting and resume the meeting by further formal access in 15 minutes' time?
I think one can mute the sound, I believe.
I found the cursors at the bottom. I can see a mute cursor. I've answered my own question. Apologise.
Your Honor, will it be 15 or 20 minutes?
I didn't catch that, I'm sorry.
Sorry, I didn't get it. Is it 15 or 20 minutes break?
15 minutes from now.
Okay, thank you, Your Honor.
Okay.
Thanks.
Can we start, Your Honor?
So, Mr. Kanan, are you ready to commence?
Yes. Mr. Zarnoul, can you please provide us? Can you please provide us with your current address?
Well, one moment. I think Mr. Zaghloul should be sworn, should he not, as was done with the other witnesses?
Sorry, Your Honor.
Not at all. Mr. Zaghloul, Nathan, the court officer, will ask you to take an oath to tell the truth.
Would you please state your full name?
My name is Hatem Ali Zaghloul.
Could you please repeat after me? I swear by the Almighty God to say nothing but the truth.
I swear by the Almighty God to say nothing but the truth.
Thank you, Mr. Kanan. Please continue.
Mr. Zaghloul, Can you please provide us with your current address?
My address is in 6th of October City in Egypt.
What is your present employment with the defendant?
I'm the regional vice president.
Did you read your witness statement in full?
Yes, sir.
Can you confirm that the statement which are set out in your witness statement are correct at the time of signing and as of today?
Yes, sir.
Is that your signature at the bottom of the witness statement?
Yes.
Can you please confirm the dates?
It's 21, correct?
7
7th of June.
7 June, okay. Before we start, with Your Honor, if you allow us for the acknowledgement of the document, or you decide to keep it later on, Your Honor?
This is the document that Mr. Patrick Joyce wishes to add.
Sure.
Yes. Are you agreeable to that or not?
Sorry? Yes. I read it, Your Honor, but this is the first time it comes to our attention. However, we have not seen these agreements which the counterparty is seeking to admit. Given that these agreements relate to the matters which are disputed, however, we believe that it is relevant and that it can be admitted. Nonetheless, in this context, we note that the agreements are not signed. Therefore, in order to provide the court with proper context as to the relationship between the parties, and that there did exist signed agreement between the parties, it is necessary to include the signed prior agreement, which has been forwarded under age 17 to age 25.
Mr. Patrick Joyce, I think we might leave this. It's perhaps not quite as simple as it might seem. We'll deal with the evidence of Mr. Zaghloul and perhaps return to this document.
Yes, certainly, Your Honour.
Yes.
Thank you, Mr. Kanaan. You obtained the confirmation of the witness statement. Is it appropriate for Mr. Patrick Joyce to now ask his questions?
Oh, yes, sure, Your Honor. Thank you.
Well, Mr. Patrick Joyce will now ask you some questions.
Your Honour, thank you very much. Mr. Zaghloul, I wonder if we can begin just by orientating ourselves with regard to all the documents which are relevant in the bundle. I think you've been taken to page C21, which is your witness statement of the 7th of June 2020.
Yes, sir.
And you've confirmed it's your witness statement and the truth of it. If we look at paragraph 11 on page C22, that reads, the claimant was aware of this message, it's a WhatsApp message, because I provided it as part of my witness statement in claim number CF-35 of 2018. Now, that's in fact the Abu Zaid claim, isn't it, Mr. Zaghloul?
Correct.
And for the sake of completeness, we have, I think, not one but two witness statements by you in relation to the Abu Zaid matter. Could you look at, first of all, page G46, please? And And that
Yeah.
should, sorry, I
G46
may be ahead of.
invoice.
Hmm?
Just a second, please, because I got an invoice, G46.
I hope I have it correctly.
I think, yes, I'm the one who got it wrong, please. Sorry. Yes, first witness statement, correct, yes.
I'm sorry, Mr. Patchett-Joyce, my G46 is part of a global tax invoice.
Oh, a G. Did I may not have articulated clearly. G.
Yes.
G46.
Yep, that.
In the case lines documentation.
That is in my, wait a minute. The date of the witness statement, please.
The date of the witness statement is the 29th of October 2018, Your Honour.
In my printout from the e-bundle, that is G12 and following. I wonder if we have a problem.
Oh, now I was giving the reference from the electronic bundle, which I've just checked with. G12 in the electronic bundle is indeed an email chain entitled re for end of service calculation.
Well, we may have a problem, but I have the document, so let us see how we go, and we may need to sort out documents later on.
I'm very much obliged, Your Honour, and I'm sure it can be resolved. Mr. Zadloul, are we talking the same references?
Yes.
If you're looking at page G46, is it a document which says in the top right-hand corner, Defendant H. Zadloul, first HZ, 29th of October 2018?
Correct.
And as we see from the body of page G46, that is the first witness statement in the Abu Zaid matter that you made. And if we go on to page G51,
Yes.
there should be a signature, which is your signature, with the date of the 29th of October 2018.
Correct.
Were the contents of that witness statement true and accurate when you made it?
Correct.
And do the contents of that witness statement remain true and accurate?
I did not revise it recently, but I would assume so.
And then if we look on to G58, there should be a second witness statement. And again, I don't know whether Your Honour has the...
Yes.
Mr. Zadloul, I'm just waiting to make sure that the court has the same document.
No, I don't have that document at all. So we do have a problem.
Oh.
but I'm just logging in to the system, just to see how we go. I see the point. A new hearing bundle has been added by last online. So, G, what am I looking for, please, Mr. Patrick Jones?
It should be entitled The Second Witness Statement of Hatem Zadloul. It isn't dated, but it's in the Abu Zaid matter. The date is on the final page. It's the 22nd of November, 2018.
Yes, I have that now.
I'm obliged. Mr. Zadloul, in relation to this second witness statement, could you turn to page G65?
Yes.
Again, that's your signature under a statement of truth with the date of the 22nd of November 2018. Were the contents of that witness statement true and accurate when made?
Correct.
And do the contents of that witness statement remain true and accurate?
With the explanation that I made during the court hearing that there was some ambiguity of my witness statement, that at the time that I signed or agreed with Rami Abu Zaid of the resignation, I was not aware that the end of service benefits is related to the visa cancellation, but I was made aware after that when I had a call with the CFO, when Rami Abu Zaid called me on the line and sent me an email saying that he cannot get his end of service benefits. And I already talked to Rami Abu Zaid. By that time, myself, and Rami Abu Zaid were aware that the end of service benefits are related to the visa cancellation. And this is already documented in my witness statement during the hearing of the Rami Abu Zaid case.
And I think you say something about that in your most recent witness statement, which we'll come on to, Mr. Zadloul.
Okay.
Now, Mr. Zadloul, let's go back to 2014, 2015. It's correct, isn't it, as you say, in your first witness statement in the Abu Zaid matter, that between the 1st of July 2014 and the end of September 2015, you had responsibility for human resources matters because of the departure of Miss Paula Zietman.
As far as I recall, yes, but can you refer me to the clause that you're checking to, please?
Yes, if you'd like a verification of that, could you look at page G47? Paragraph 6. G47 is the second page of your first witness statement.
Yes, I'm there. Paragraph what? 6?
Paragraph 6.
Okay.
Can we just pause a moment, Mr. Zadloul? Because of the glitch in sequencing the documents, it may be more difficult for His Honour and the court to identify what we're speaking about, so we need to give a little bit of extra time.
I'm with you. If I am not with you, I will let you know, but otherwise assume that I am with you, please, Mr. Patrick Jones. Joyce?
Judge, I'm happy with that arrangement. If we look at paragraph 6, you say, on the 30th of June 2014, the head of human resources, Ms. Paula Zeetzman, left her position and a replacement was not immediately hired. Accordingly, for the period the 1st of July 2014 to the 30th of September 2015, in addition to my other responsibilities, I also assisted with the human resources, the HR function. During this time, the members of TIG's Human Resources Department took instructions from me. This arrangement continued until the replacement for Ms. Zeetzman was in post from the 1st of October 2015.
Correct.
So for the relevant period of time when Mr. Abu Zaid resigned, you were in charge of human resources for the defendant firm, the defendant company.
Yes, but you have to differentiate between human resources and personnel.
Well, yes, but we have Mr. Hamid, and I don't think we're going to be hearing from Mr. El Sukli, but we have also Mr. Jabara. Now, we know that Mr. Abu Zaid resigned with effect from the 30th of September 2015, don't we?
Yes.
And he did that by letter dated the 4th of August, email dated the 4th of August, which we can see, if we want to have a look at it, at page G15. And that is a short letter. It is addressed to you. So he clearly thought you were the appropriate person. I think you were also his line manager. With great regret, I am resigning from my position due to personal reasons. Kindly note that my resignation submitted today, my last day in duty with TIG, will be Wednesday the 30th of September 2015.
I'm not there yet, but...
And we know that I don't think it's in evidence in this matter, but we know that resignation was accepted by, or that you then wrote a letter of acceptance which was countersigned by Mr. Abu Zaid the following day on the 5th of August 2015.
Where is the reference for that, please?
If you go to page G48, please, in your first witness statement.
Okay.
Paragraph 14.
Yes.
By a letter dated the 5th of August 2015, TIG accepted Mr. Abu Zaid's resignation, the letter of acceptance of resignation, and then the final sentence of that paragraph, Mr. Abu Zaid signed the letter of acceptance of resignation, indicating his agreement to the contents.
Okay.
So that all of that took place whilst you were in charge of the Human Resources Department for TIG. That's correct, isn't it, Mr. Zadlou?
Correct.
Then you say that the next event was in October 2015, and you give evidence in this regard at the foot of the same page that we're just looking at. And beginning at paragraph 16 in that witness statement, you say that Mr. Abu Zaid came to your offices, in essence, to ask you to keep medical insurance active. Pausing there, are you happy that that's so far a correct statement?
Yes.
And you then say that you were sympathetic and wanted to help him out by extending the visa and the medical insurance.
Correct.
Were you aware of the provisions of the DIFC employment law?
At that time, no.
And you say there was an agreement. We don't need to investigate that too much, but again, I'm summarizing what you say between paragraph 16 and 19 of this first witness statement. And you, on your version of events, where there was a formal agreement between you and Mr. Abu Zaid, you thought that that agreement would last for about a couple of months.
Correct.
So we're talking about, and I think, in fact, in the judgment, the judge found that the conversation did not take place towards the end of September 2015, but took place earlier. And the finding of the court was that the conversation between you and Mr. Abu Zaid about the extension of his medical insurance and visa took place at the end of August 2015. Do you recollect that as being part of the judgment?
As far as I remember, it's 5 years back, and I really cannot recall the dates with all this, what's going on. So I wouldn't argue that. If this is somebody has a proof for that, I wouldn't argue that.
Well, I'm very much obliged, Mr. Zadlul. We can certainly look at what the judgment says, but the judge came to that conclusion based in large part because we know that Mr. Abu Zaid's wife was pregnant at the time, that it had been a difficult pregnancy, or there had been some complications, but the son was born perfectly healthily in September 2015, and that on that basis the judge considered the conversation would have taken place earlier.
Yeah, but you know that by the virtue of insurance, that if the cancellation of the medical insurance is done before that, then the child will not be covered. Otherwise, the child would be covered. So it's a matter of technicality whether it's when you say that's related to the pregnancy, it's related to the pregnancy and the baby. And as I recall, that the child was not perfectly healthy.
Well, we probably don't need to go into that amount of detail. I think your position is that you're happy to abide by the judge's finding, who heard the full evidence at the time.
I would say so, yes.
Yes. So a couple of months would take us from the end of August through to about the end of October.
I don't understand the question.
Well, it's a simple question of arithmetic. If the conversation took place in August 2015, and what was contemplated is that that would be an arrangement for 2 months, then you would have expected that arrangement to come to an end in 2 months' time,
Yes.
and 2 further months after August is October.
Okay.
We can then move to the next stage, which is in November 2015, and paragraph 23 of your first witness statement, so page 50. You refer to Mr. Abu Zaid forwarding an email exchange that he'd had with Mr. Hamid immediately prior to the date when it was forwarded on to you. Do you see that?
Yes.
And if we look at Mr. Hamid's witness statement, which is at pages G44 to 45,
Yes.
He says on page G45, paragraph 5, he refers to an email from Mr. Abu Zaid asking for his end of service payment to be paid to him. He responded to that email on the same day, asking to know whether his visa had been cancelled yet, as this was in accordance with TIG's policies, a requirement before the end of service would be paid. And there's then details of the exchange of emails, and I can ask Mr. Hamid about the detail of this, but this is what was drawn to your attention in December 2015.
Yeah, if you refer to the point that you were referring to, which is point 23, this is the exact date that Mr. Abu Zaid and I had a phone conversation, and this exactly the exact date when I had the conversation with the CFO, and both of us were aware that the end of service benefit is linked to the visa cancellation.
So that as of December 2000 as of November 2015, we know that Mr. Abu Zaid's employment had come to an end with effect from the 30th of September 2018. We know that you had agreed to extend or keep his visa alive and his medical insurance cover in place. We know that you did not at that stage have in mind the DIFC employment law provisions, and we know that you expected that arrangement to be in place for 2 months, coming to an end therefore at or about the end of October 2015, and we see that there was conversation by email between Mr. Abu Zaid and TIG, certainly in the form of Mr. Hamid, in very early November 2015, and we know that that was brought to your attention in December 2015.
Okay.
That's a fair summary of where we've reached, isn't it?
Yeah, and this is where Mr. Abu Zaid was aware that his end of service benefits is linked to the visa cancellation and the returning of the medical insurance card.
So why did matters not come to a conclusion by means of the cancellation of the visa, the cancellation of the medical cover, and the payment of the end of service benefit in or around November or December 2015?
Because Mr. Abu Zaid was stalling in cancelling his visa. He was not cancelling his visa. Mr. Abu Zaid was stalling in cancelling his visa. He was not cancelling his visa. As simple as this.
No,
he didn't want to cancel the visa. He didn't want to return his medical card.
No, he wasn't. Let us look at the email correspondence that was forwarded to you. And we need, for this purpose, to look at sorry. Yes, we need to look back at G16 and 17.
Okay. G16.
And we need to begin at the foot of page G17 to read the emails in sequence. Which is the email of November the 1st, 2015 at 4:50 a.m. sent by Mr. Abu Zaid.
Which one?
The foot of page G17.
Okay. I'm with you.
It's dated and timed the 1st of November at 4:50 a.m. Dear Faisal, hope you had a safe, relaxing holiday. I'm reaching out to you. This is Mr. Abu Zaid. I am reaching out to you today regarding my end of service. As you are aware, my last working day was the industrial group. With the industrial group was on the 30th of September. As per the DIFC labour law, EOS is paid to employees within 14 days after the last day of duty. It's been a full month today with no payment. And then Mr. Hamid goes back at 7:17, reading above the on the same page. May I know about your visa status? It's been cancelled, ? And then Mr. Abu Zaid comes back at 3:52 on the same day. And here we need to read spanning pages G16 and G17. He writes, Dear Faisal, visa is not cancelled yet. It was agreed with Hatem Zadloul that I will keep my visa until I sort out my new visa position. It was not agreed to relate that to my EOS settlement. The usual process is that the employer pays the employee EOS in full within 14 days after the last day of duty. Then visa cancellation takes place immediately after, or later if that is mutually agreed between employer and employee. In all cases, EOS needs to be released before visa cancellation. And then Mr. Hamid writes, thank you for your email. Kindly contact with HR. If they say to release EOS, we will do the needful.
All right.
He wasn't being evasive at all, was he, Mr. Zadloul?
What do you mean by evasive? I don't understand the word.
Well, your evidence, we can look back at the precise word in the transcript if need be. Your evidence was that Mr. Abu Zaid was being difficult in November and December 2015 about the cancellation of his visa and about the payment of his end of service benefit.
It's very clear from what you've just read right now. The first question, which is something that's formality that nobody on the top of HR or something like that, it's not an HR issue, it's a personnel issue. But when somebody is saying that the first question and the reply from Mr. Faisal, did you cancel your visa? I think that explains it all, and saying that this is the process of the company. He did not mention anything. He did not mention anything. May I know about your visa status? You just said it yourself. Is it being cancelled? Only question marks. And nobody's copied even from this email. This is a normal process, sir.
Mr. Zadloul.
Yes, please, go ahead.
Mr. Abu Zaid, to use his very words, in November 2015, was reaching out to TIG regarding his end of service.
And the reply was, you have to cancel your visa. Because this is the normal process. You want to have your end of service benefits, you have to return the company property, which is the medical insurance cards, the employment card, and the visa. He cannot keep the medical insurance card without having a visa on the employer. We have to be his sponsor in order to keep his medical insurance cards. And it was proven afterwards that Mr. Abu Zaid used his medical cards for him and his wife after the date of leaving the company.
But Mr. Zadloul, as of November 2015, this was a matter exclusively between Mr. Abu Zaid and TIG.
Yes.
And that followed on the 2 months that you had granted without regard to the DIFC employment law from the end of August 2015. That is the picture that this evidence presents, isn't it, Mr. Zadloul?
I'll keep it to your judgment. I don't have a saying on this one.
I see. Well, I've taken you to the documents to give you the opportunity to tell me I'm wrong. Am I wrong?
I told you before, sir, that the policy of the company is cancelling the visa, take your money. And this is exactly what happened after that. And Mr. Abu Zaid was with me on the line when I talked to the CFO, And I tried to help him out. I told him if there is any way to cancel to give him the end of service benefit before canceling the visa, I said, how do you want me to do that? We're going to be exposed.
You were sympathetic to Mr. Abu Zaid, and I recognize that, and it's a very morally laudable thing to do. I acknowledge that. But it also had legal implications, didn't it?
Obviously.
But they were legal implications that you are now aware of, but you've confirmed that you weren't aware of at the time that we're talking about.
Yes, but I told you when I was aware of with Mr. Abu Zaid together, we were aware of.
Now, the picture moves on, and I think that we can, well, let's take it in a little bit of stages. Let's go back to your first witness statement, which is at, I think we've reached about paragraph 23. So let's go back to page G50, please.
Yes, sir.
So the picture that we've got is that as of November, December 2015, you, or TIG, was in touch with Mr. Abu Zaid, and indeed you yourself, I think, had a telephone conversation with Mr. Abu Zaid in December 2015.
Yes.
It's then right that, and this is paragraph 25, you didn't hear from Mr. Abu Zaid for quite some time and tried to reach him.
Yes.
And the next thing you were able to do was reach him towards the end of the summer. It's not precisely clear when, but Mr. Abu Zaid returned to Dubai, proceeded with the cancellation of his visa on the 26th of September 2016. We have that at paragraph 28.
Okay.
And then we also know that there was payment of his end of service benefit, which, again, if anyone wants to note, it's page G18 evidencing the payment into his bank account, but I don't think we need to worry overly about that. Mr. Abu Zaid then began proceedings in 2018 relating to the very matters that he had drawn expressly to your attention in November 2015, namely the late payment of his end of service benefit. That's correct, isn't it?
I don't know. I wouldn't be aware of that.
You say you weren't aware of that. If we look at the first page of your first witness statement that we've just been looking at, it says claim number CFI-037-2018. That is the year in which Mr. Abu Zaid commenced his claim for late payment and therefore penalties under Article 18 of the DIFC employment law, wasn't it?
I lost you. What's the point? Can you please take me
well,
to the point?
All I'm doing, Mr. Zadlul, and I don't think there's anything between us on this, identifying the time when Mr. Abu Zaid, the year when Mr. Abu Zaid started his proceedings in relation to the non-payment of the end of service benefit and therefore his claim for penalties under Article 18.
I believe you, but you can also check, because these things will go to the lawyer.
It's a matter of, Mr. Zadlul, it's a matter of record. We probably don't need to spend much time on that. But in the light of this claim, a full case note was provided by the claimant under cover of an email, and we can find the email and the full case note at G32 to 39. It's actually addressed to Mr. Beckley, and we can ask Mr. Beckley to confirm receipt, but it is a note in relation to the Abu Zaid matter.
Okay.
And we find that note, it's an extensive note, at pages 33 to 39 of the bundle.
Okay.
Is this a document with which you're familiar, Mr. Zadloul?
No.
Well, let's look at what it says in shorter rather than longer term, because we can explore it in more detail with Mr. Beckley. And Mr. Beckley was your general counsel at the time, wasn't he?
Yes.
So internally, he would have acted for legal matters on behalf of TIG.
Correct.
And therefore, as he's received this document, then we can expect that he would have acted upon it. So let's just not read it entirely. We can look at it in detail at our leisure. It's introduced by way of the 3 paragraphs, and it looks as if the claimant's application was made on the 23rd of May 2018 from the 3rd paragraph.
Page what?
On page G33, 3rd paragraph, we have a date for when Mr. Abu Zaid made his claim.
Yeah, 23rd of May 2018.
And then the next heading considers the merits of his case, and we can see in the 1st paragraph under that heading express reference to Article 18 and of the DIFC employment law, and in the 2nd paragraph express reference to Article 19 of the DIFC employment law, can't we?
Yes.
Then we have those articles set out, faithfully reproduced between pages G33 and 34.
Mm-hmm.
And then the case law relevant to the law is introduced under the heading DIFC Court of Appeal with reference to the frontline decision, a Court of Appeal decision of the DIFC courts. There is then a very long section which spans pages G34 and G35, which explains the impact of the Court of Appeal's decision in Frontline and the very real problems that you have.
If you may allow me, Your Honor, this is legal issues. I'm not sure what is the relevance of these issues with the case in hand.
Well, it's relevant to the strategy, which we'll come on to.
Something, and I will let Mr. Patchett-Joyce continue.
Thank you, I'm glad. We can just pause on the 2nd paragraph of G35. The final words say the law appears to be on his, that is the claimant's, Mr. Abu Zaid's side. It's quite clear advice, isn't it?
Where do you want me to
G35,
yes.
2nd paragraph, which begins the issue,
Yes.
final words of that paragraph, the law appears to be on his, that is the claimant's, Mr. Abu Zaid's side.
Yes.
That is clear advice backed up with the detail of this section as to the real problems that faced TIG in relation to this case, isn't it?
I have no saying. It's first time I see this document, and I really don't understand really why are you heading with this, yeah? What has relation to do with
Well, I can take it further with Mr. Beckley, and perhaps that would be the best course. But can we just pause at G36?
Okay.
And that is headed towards the foot of that page, strategy for defense. And if we go over the page, we have a section headed "The Intent of the Parties." Do you see that?
I'm at strategy, above the strategy or below, under the strategy?
After strategy of the strategy for defence, if we turn over the page to G37.
Okay. Yes, I'm at page 30, G37.
You see that there's an indented section, and the heading to the indented section is "The Intent of the Parties."
Okay.
And then if we look to the body of the next paragraph, in the middle of that paragraph, what is argued is that the intent of the parties should be taken into consideration.
I'm not there.
Well, it begins, "The above points are all are key to differentiating TIG's position from that of the employer in front line." Do you have that paragraph?
Yes.
And then 3-4 lines in the middle of the line, "The intent of the parties should be taken into consideration."
Said that the intent of the parties was never addressed by the court or the parties themselves.
No, but the important point for present purposes, Mr. Zadloul, is that your evidence as head of HR at the relevant time was critically important to the strategy for the defence, wasn't it?
This is you're mixing up with the HR and personnel again. It's the rest. What you're talking about, all the payments, all these things, it's an administrative thing. It falls under personnel, which I was not handling. So the HR finishes when I hire somebody, I fire somebody or accept his resignation, and the rest is systematic things that the company will follow. That's why even if you from your mails that you're discussing, he was discussing with somebody else, not us, because it's procedure after that. It's with Mr. Faisal, it's with Mr. Mohammed Dusui, it's not with anybody of us. Because
no, Mr. Little, this is a case note addressed to your general counsel, and you have already accepted that your general counsel was responsible for implementing legal, for taking charge of legal issues internally. And yes, we see that the strategy for defending Mr. Abu Zaid's claim was carefully considered, and because you were head of the HR department at the relevant time, you are central to the strategy. That's the simple point, isn't it, Mr. Zadloul?
At that time, I was not the head of HR.
No.
Now, what time are you talking about?
In 2018, you were not.
Yes.
But the events in question relate back to August, September, and following of 2015, and we know that in August and September of 2015, you were head of HR, and you did in August 2015, at the end of that month, have a conversation with Mr. Abu Zaid about the continuation of his visa and the extension of his medical insurance cover. That we've already established, haven't we, Mr. Zadloul?
No, but with a small correction that I was acting as the head of HR, filling for somebody. That's not my job. I'm having additional responsibility that I'm not the expert of HR, because HR needs or requires certain experience that I don't have.
No, I accept.
For example, an HR boss or head would know the rules and regulation of the IFC regarding hiring or firing.
Yes, Mr. Zadloul, I have some sympathy with the plight in which you found yourself, but going back to paragraph 6 of your first witness statement, you say quite clearly that in addition to your other responsibilities, you assisted with the HR function. During this time, the members of TIG's Human Resources Department took instructions from me.
Correct. Well,
so
I did not change that. But can you please read the words again? Can you please read again? You said assisted, and take this. When they need instruction, hire this guy or fire this guy. It's not process, normal process or not.
No, Mr. Zadlul.
Don't put
I've
words
read
in
the
my mouth.
full paragraph.
Yes.
Mr. Zadlul, I've read the full paragraph, and it says, during this time, the members of TIG's Human Resources Department took instructions from me. It's clear.
Yes. Clear.
And then if we go back to the note which was provided in September 2018, back to G39, the conclusion.
Yes.
It's quite long, but permit me to read it. In view of the potential value of the claimant's case against TIG, and in view of the unfavourable position taken most recently by the Court of Appeal in relation to paying end-of-service benefit on time, we would strongly advise TIG to consider how it will proceed with this case. Whilst we believe we may have a reasonable chance of defending the deduction of the cost of the health insurance from the claimant's end-of-service benefit, this is only one part of his claim, and it's also the least valuable. The court may determine that TIG were correct in deducting this amount. However, this does not of itself relieve TIG from paying the claimant the remainder of his benefits within 14 days of the termination of his employment. This latter part of the claim poses far more risk in terms of financial value and the light of the Court of Appeal's recent decision in the matter. However, as detailed above, there are arguments we can make to differentiate the facts of this case from that of Frontline if the court takes a less strict approach than it has previously and looks at the intent of the parties. We could be successful in defending the case. A more liberal approach is supported by the new draft legislation, and it is encouraging. However, ultimately, it is difficult to determine what approach will be taken, and then we may be in a better position after disclosure. That is clear advice as to the risks, first off, in the first instance, isn't it, Mr. Zadlul?
Why are you addressing this to me? I really don't understand. You could address this to William Beckley. I have nothing to do with that.
All right. Well, I will take that up further with Mr. Beckley. It was in the light of this case strategy, however, that you made your first witness statement a matter of about 6 weeks later. That's the first witness statement we've seen beginning at page G46, yes?
Yes.
And though it was a matter of a month later, it was in response to what Mr. Abu Zaid had been saying. You made your second witness statement, which we've seen beginning at page G58.
Okay.
And we can see that in the course of those witness statements, you were saying that an agreement was made to keep the medical insurance and visa alive, and that is consistent with the strategy we've seen in the case strategy of the 10th of September, isn't it?
Again, I have no comment in relation to the strategy you're referring to. You're asking me something that I have no relation to, so I'm not...
I'm asking you about the circumstances in which you came to sign your first and second witness statements in the Abu Zaid matter, Mr. Zadlul.
Yeah, the legal counsel told me that there is a case, we need to take your witness statement, tell us what happened. So I told him what happened. I don't know anything about the strategy, I don't know anything about what you're referring to. Please tell the truth, what happened, and this is exactly what happened. And the second witness statement saying that, Mr. Abu Zaid saying that, what do you have to say about that? So I said what I have to say about that, and this was the help of your associate.
Well, let's come on to this and let's have a look at what occurred in February 2018. I don't know whether you were on the line or listening to the evidence when Miss Lacan gave her evidence.
No.
Well, let me read you my note, which was made earlier this morning or earlier today, because we're in different time zones.
Mr. Patrick Joyce, is this the proper way to do it?
Maybe not in the first instance.
Maybe
Miss...
not in the ultimate instance either, but let us wait and see whether we get to that.
Indeed. Mr. Zadlou.
Yes.
The case brought by Mr. Abu Zaid was listed by the DIFC Court of First Instance to be heard on the 20th and 21st of February 2018. That's a statement of common ground, and I hope we can start from that common agreement.
Yes, sure.
And for the purpose of familiarization with the process and going through your evidence, you attended the claimant's offices on the 18th of February. That's correct, isn't it?
Correct.
Can you just tell me, let's begin, what time of day did you attend?
It was in the morning.
Yes.
I was requested to free myself the full day because they want to review the witness statements before the case tomorrow.
And you attended at their offices. Who was there?
I think Sharon, and I don't recall the other lawyer's name.
You don't recall the other lawyer's name, but you recall another lawyer being there.
Yes, yes.
Man
so
or woman?
It was two ladies. One that has prepared with me the witness statement with William Beckley and helped preparing that, and the other lawyer that I've never seen before.
I see. So I think the name has been provided, Naam Hoare, who was going to be counsel in the hearing on the 20th and 21st of February.
Correct.
Were you alone or were you accompanied?
I was with Mr. William Beckley. He introduced me and then he left. He said, you'll stay with them until you finish, and he left after that.
And what happened then, Mr. Zadlou?
I recall stayed very short time. I was really surprised, and Mrs. Naimhall left the room for a while and then came back and said, that's it, thank you very much.
Well, Mr. Zadlou, I'm going to suggest to you that that's not actually what happened. You agreed that you attended, having been asked to set aside a full day for the purpose for which you were attending, yes?
Yes.
I would suggest to you that even on your own evidence given so far, that Mr. Beckley left shortly, but you continued,
Yes.
that suggests that the meeting was within a compass of only 15 minutes is not accurate, and that it was a longer meeting.
That's why I recall it. As I recall it as a short meeting. I believe that this is something very good about Dubai, that it has cameras all over. You can get the cameras where I entered the building, when I get out of the building, and where I entered the office and got out of the office. It was a really short meeting. I was really surprised.
Well, Mr. Zadlou, if you had wanted that evidence, you could have at least made inquiries earlier. I don't think any inquiries were made in that regard, were they?
You're saying you're saying that I am not saying the truth, and I'm saying this is how I recall it. I'm telling you how we can come to a normal, common ground. I'm not saying anything. You're saying that I'm not saying the truth. I'm just replying to your your accusations.
No, I'm not making any accusations. I'm just putting to you that it looks from the evidence that we have heard that the meeting probably took much longer than 15 minutes.
Not with Mr. Name-Hall, Ms. Name-Hall, definitely not, as I recall.
Well, let's look at this in a little bit more detail. If we look at the file, the email, which was sent subsequent to the meeting that you had on the 18th of February, we'll find that at G97 to 98.
Yes.
And yes. If we pick it up, well, let's read it. As you know, we've been preparing for the Abu Zaid trial, and I spent a number of hours this morning with Mr. Zadloul going over the court procedure and his witness statement. So I would suggest to you that, having been asked to go in for a full day, you actually spent several hours during the course of the morning doing exactly what you were asked to do.
No.
We have previously advised you that this case would be an uphill battle. This is reverting to G97. That this case would be an uphill battle because the law is against us and the case law is against us. Factually, too, it has been problematic proving the existence of an agreement between TIG and Rami that his end of service would not be paid until his visa was cancelled because there was no written agreement in place. And then we have a critical paragraph. However, this morning, during our session, even without prompting, it became apparent that there simply was no agreement made to pay Rami his end of service benefits only upon cancellation of his visa. Hatim told us categorically that the extension of the visa was not linked to the end of service payment, and in fact that he himself had no knowledge that it was company policy that end of service was only paid upon visa cancellation. Furthermore, Hatim told us that he was paid his end of service benefits twice without his visa being cancelled. So his understanding and personal experience completely contradicts what was in the alleged agreement in the first place. It is clearly not the policy across the company that visa cancellation is required before end of service is paid, and this is also contradictory to other witness evidence submitted to the court. Now, just pausing there, Mr. Hatim, it is correct, is it not, that not once but twice you were paid your end of service benefit without cancellation of your visa?
Can you please read the first line again?
Please answer the question, Mr. Zadloul.
Yeah, because they did not probe, they were just asking, as exactly I replied.
Please, you're asked a direct question. Please answer it. It's a yes or a no.
Yes, I'm answering the question, Your Honor. We're saying that I am...
Please answer it directly, Mr. Zadloul. It is one which requires a yes or a no answer.
So can I have the question again, please, Your Honor?
Please repeat it, Mr. Giles.
It is correct, is it not, Mr. Zadloul, that not once but twice you were paid end of service benefit without your visa being cancelled?
Yes.
Thank you. So, from your personal experience, there would be no linkage between end of service benefit being paid and cancellation of visa, would there?
If you stay as a board member serving for the company and other companies, sitting on the board as a non-executive, yes.
Good. And I'm not asking you about your status, I'm asking you about your experience.
But this is my experience that I've been with the company since 1991. I've been always having my residency, not only in, even before the TIG was formed, there is the Banawi Industrial Group since 1991, and I have residency in Saudi Arabia, and I have residency in Dubai, because this is required as a board member to stay and travel whenever I'm asked to attend the meetings.
So Mr. Zadrul, the picture that we have thus far in going through this email is that what is reported to have been said by you was certainly accurate, whether or not it was actually said by you. We've reached that position, haven't we?
It is accurate, yes, but there was a continuation. I was not allowed to continue. I was not even asked to continue, which is the probing that you were talking about, which is the first line, even without probing.
Yes, you volunteered material which was inconsistent with your two witness statements that we have just seen.
It is very consistent. We're saying, well, I'm still
I'm sorry, Mr. Zadrul, I don't know whether I'm alone, but your response is breaking up a bit.
No, can you hear me?
Please start that answer again, would you, Mr. Zadrul?
Sorry?
Could you start your answer again?
Your Honor. Hello? Can you hear me?
Yes.
Yeah, we can hear you now.
Zadrul, we did not catch your last answer. There was a problem with transmission. Would you mind repeating what you said?
No, not at all, Your Honor, because I'm saying that this is my personal experience. It's not with whatever I said, because I always say I finished my executive role company, but I took my residency because I have an executive role in the company. So I'm still a board member in so many companies of the group. I was not allowed to continue this explanation. That's why I wanted to say that's why this is a reason that I was not aware of the end of service benefits linked to the visa.
I'm again having difficulties. Mr. Zadrul, can you hear me?
I can hear you very good. Can you hear me?
No, I'm afraid I didn't hear your last answer.
I'm saying that my experience with the group, that I've changed from an executive role to non-executive role, sitting in a board of different companies of the group. That's why I did not know at the time that the visa cancellation is linked to the end of service benefits. However, I was not allowed to even continue. Miss Nima left the room immediately and came back and said, "Thank you very much, that's it." I was not even, I did not continue to this explanation. And I was really surprised about this mail. Yeah.
Well, Mr. Zadrul, I think I caught what you said. And what I've noted is that you did not know at the time that the end of service benefit was linked to the cancellation of the visa.
Correct.
And that was your personal experience.
Yes.
And you were bringing your personal experience to bear in August and September 2015, and in particular when you had the conversation that has now been found to have taken place at the end of August 2015. You were bringing your personal experience to bear, weren't you?
To what? To bringing my personal experience?
You were relying on your personal experience when you had the conversation with Mr. Abu Zaid in late August 2015, as His Honour Sir Jeremy Cook found in the Abu Zaid case.
Correct, until we had the phone call with the CFO and we both came to the same understanding.
Well, we'll come back to that. But we now have a picture where what we've just read in the paragraph on page 97 is accurate in terms of describing your personal situation. What I would also put to you is that not only is it accurate in describing your personal situation, but you raised and spoke about your personal situation in the course of this meeting on the 18th of February 2019.
Correct.
And that therefore all of this so far is accurate, isn't it?
Accurate but not complete.
Well, then it goes on, the impact of what we now know is fatal to the defence.
That's not, I cannot judge that.
There was no policy, was there, Mr. Abu Zaid, Mr. Zadloul?
No, there is a policy, but it does not apply to board members.
It was
Because
a policy.
yes.
If it was a policy at all, it was one which you were oblivious of at the relevant time, so far as Mr. Abu Zaid is concerned.
Mr. Abu Zaid was not a board member, sir.
That doesn't matter. We're looking at whether there is a linkage between end of service benefit and cancellation of visas. And,
okay, please go.
And you have already agreed that that was not the case in your personal experience.
Correct.
And you have also agreed that you were relying on your personal experience when you had conversations with Mr. Abu Zaid, as found by the judge in the end of August 2015.
Correct.
And that state of affairs would have endured for the next 2 months, because that was expressly in your contemplation when you had that conversation.
Correct.
And that at the end of those 2 months, you were not only still in contact with Mr. Abu Zaid, but he was actually coming to you, in his words, reaching out with regard to the end of service benefit.
Nothing other than the mails that's documented in the case.
Well, we've gone through those, haven't we, Mr. Zadloul, and they're pretty clear, aren't they?
Yes.
So what I would suggest to you is that what is recorded here as having been said was said, and on the basis of your personal experience, if there were a policy at all, it was subject to many exceptions.
Patrick Joyce, 2 questions.
Ah, yes. Let me take it therefore in stages. What was said and is recorded here as having been said was consistent with your personal experience, correct?
Yes.
And what I would suggest is that if there is any shadow of doubt, it was indeed said in these terms in the course of this meeting. And that's correct as well, isn't it, Mr. Zadloul?
Yeah, but during the course of the meeting, I was aware that the policy saying that the visa is cancelled by the service benefits.
But the effect
during the time of the meeting, please go ahead.
The effect of saying what you said, which you volunteered, it was without prompting, was inconsistent with the basis of the strategy of the case and inconsistent with your 2 previous witness statements, wasn't it?
So, I would assume so, but if you are my lawyer, and I'm telling you this is exactly what's happening, don't you probe me and ask me what do you mean and to explain this, or what's the tear, or what's the policy? How do you this is the policy? I'm talking to my lawyer. So I'm telling him this is my experience. That's why I was not aware. After that, I was aware during the phone call, and this is what happened. That my situation is different because I was a board member. So I was, as you correctly said, I was building on my personal experience. That's why
Again,
I was not aware. But
I'm not
after
getting all of your answer. I don't know whether the court is.
Mr. Joyce, have you got much longer with Mr. Zeglul?
Probably not, Your Honour. I've probably taken this paragraph as far as I can.
No, I was wondering whether we need to take a break to try and do something about the connection, because the last answer, I think I got it, but it's not a very good connection.
No, I would certainly prefer to sort the sound out, Your Honour, because a mishearing or a partial dropping off could be critical.
Yes. Mr. Zeglul, whereabouts are you?
Sorry?
Whereabouts are you? Are you in Dubai or Egypt? Or
Egypt.
where?
I'm in Egypt, Your Honor.
I am not technical enough to be able to answer my question, but if you were to log out and then log back in again, possibly we would get a better connection. Have you got someone that might help you to get a better connection to us?
Sure, sir, I will do that. I can hear you very well, by the way.
Yes, unfortunately not the reverse. And your picture is also not very good at all, without being personal. So we will wait here. Would you mind logging out and coming back to us as soon as you can, we hope with a better connection.
All right. Sure.
Your Honor, we've contacted TIG in Egypt, and we've asked them to try to assist Mr. Hatem in getting a better connection.
That would be good, thank you. Yes. Well, keep in touch with them if you would. Let us know if there's going to be undue delay, but otherwise we'll wait here. We'll wait online.
Your Honor, in addition, you said that you couldn't see Mr. Kanan clearly. Would it be better if we if we seat him closer to you? Would that help?
No, Mr. Kanan is fine. There was a period when the picture was frozen. That was the problem. But where he is at the moment, although he's very dark, is all right.
Thank you.
Your Honor? Hello?
Yes, I can hear you, Mr. Zaghloul. I cannot yet see you.
Okay. So is it better connection?
That is better. Yes, that is. It has worked so far. Mr. Patrick, do you have better reception? I've lost your sound, Mr. Patrick Joyce.
Sorry, that was my fault, Your Honour. I was on mute. But Mr. Zaghloul, whatever you've done or your IT has done has worked very well as far as I'm concerned.
Yes.
Very good.
Thank you.
Glad to hear.
Well, let us resume then. Thank you.
Thank you. Mr. Zaghloul, let us go back, therefore, to your first witness statement in the present proceedings, the only witness statement in the present proceedings, which is at page C21.
Yes, sir.
We've looked at the time that the meeting spent, which is dealt with in paragraph 6, and I've put that in issue. That's page 22. And then looking at the paragraph that, with reference to the paragraph that we've just been looking at on page G97, that is in part set out in paragraph 7, and then at paragraph 9 you say as follows. And can we just read paragraph 9 together? In December 2015, I had a phone call with Mr. Rami Abuzaid. At the time of the call, I ascertained that it was the defendant's policy to pay the end of service entitlements upon cancellation of the visa, and confirmed the defendant's policy to Mr. Rami Abuzaid in the same call. You see your evidence there?
Yes.
From whom did you ascertain the defendant's policy?
From the CFO Abdulaziz.
I'm sorry, the connection has gone poor again, and I did not catch that. Would you repeat it?
From the CFO, Mr. Abdulaziz.
Thank you.
From the CFO, and I think you gave a name. Who was the name? What was the name? Could you?
Abdulaziz Al-Fadil.
Abdulaziz Al-Fabi.
Abdulaziz, Azim, A-Z-E-E-M.
Yeah.
Al-Fadil, A-F. A-L, sorry.
Yes.
A.
Yes.
E-I-L.
Mr. Abdul Aziz
Abdulaziz
Al-Fine. Right. But not a witness who's being called on behalf of TIG.
I don't know.
So the position, Mr. Zaghloul, is really this, isn't it? in your witness statements, you had given evidence of an agreement. Your personal experience is quite contrary to the basis of that agreement. Are you with me so far? The agreement was that end of service benefit and cancellation of visa would be combined or would interrelate. Your experience says otherwise, doesn't it?
Yeah, but we have the agreement that's already. I shared the WhatsApp message that Mr. Abu Zaid sent to me, and it's already in the file.
That's October 2016, isn't it?
Yes, which is an agreement, as far as I recall the date. But I have it still on my phone, by the way. I can get you the exact date. It's, we have an agreement. So we had an agreement with Mr. Abu Zaid after this phone call saying that please cancel the visa and take your money, your end of service benefits.
Well, Mr. Zadlul, let's deal with that WhatsApp message straight away. The WhatsApp message was dated October 2016, wasn't it?
I have to check, just a second.
Well, if you look at page G62,
it's October 9, 2016.
We can see it at various stages. If you look at paragraph 14 on G60.
G60?
Yes, paragraph 14. You say, I only received a single WhatsApp message from the claimant, which is Mr. Abu Zaid, which is dated the 9th of October 2016.
Yes, correct.
That was after his visa had been cancelled. That was cancelled on the 28th of September 2016, wasn't it?
I don't recall the date, but fine. Yes,
well, if we want to find that date, let's look at page G19.
Yes, it's there.
That gives us a date of the cancellation, which is the 26th of September, doesn't it?
Correct.
So the WhatsApp message was after the cancellation of his visa and shortly before the payment of the end of service benefit. That was paid on the 2nd, received into his account on the 6th of November. Look at page G18 if we need to identify that date.
All right.
So the WhatsApp message was whilst the process of cancellation of the visa and payment of the benefit was in hand, wasn't it?
According to the date, yes.
Well, it was. You're not suggesting the dates otherwise, are you, Mr. Zadlul?
No, no, no.
So the position, therefore, is we've covered the alleged agreement, we've covered the personal experience, but you only knew your personal experience was wrong in December 2015, because that's what you tell us in paragraph 9 of your witness statement at C22, and you were disabused of your misapprehension, or you understood what the defendant's policy was from speaking to Mr. Abdulaziz Azim Al Farain, the Chief Financial Officer, in December 2015, didn't you?
Can you repeat again, please, because I lost you?
Yes, you ascertained what the defendant's policy really was only in December 2015.
Yes.
Thank you. Now, let's just, for the sake of completeness, go back to pages G97 and 98. We then see how the claimant dealt with the position as you told them on the morning of the 18th of February. As practicing lawyers, sorry, I should pick up the paragraph before. The reality of what has now come to light does not just have consequences for TIG's case, but also in our advancement of the defence due to our ethical obligations to the court. As practicing lawyers, in the DIFC courts, we are bound by the mandatory code of conduct, which sets out that our primary obligation first and foremost is to the court, and we cannot mislead the court. This means that we are now limited to only defending the point about medical insurance. This is the only point we can put forward if the trial is to proceed. We can no longer present a defence that there was an agreement in place between Rami and TIG that he would only receive his end of service benefits once he cancelled his visa. Additionally, any person who gives evidence to the court and relies on that alleged agreement, knowing that it did not exist, is potentially exposing themselves to perjury charges, which has criminal and civil consequences. Even if the judge agrees TIG is justified in deducting medical insurance, the value of this aspect is insignificant in contrast to the claim for penalties for delay. So what happened on the morning of the 18th of February is really, I would suggest to you, Mr. Zadloul, pretty clear. You had previously given evidence of an agreement, and you spoke in terms, in categoric terms, on Monday the 18th of February, saying that there was no such agreement. And that is recorded very clearly. Yes? Well, let me pause there. What is your response to what I've said so far?
Where is this agreement that I said there is an agreement and there is no agreement? I don't understand.
We've been through your first and second witness statements in the Abu Zaid matter, which is premised on an agreement being in place.
What was WhatsApp message and saying his own words saying that as agreed? Can I read the message for you?
Yes.
Hi Hatem, sorry, I'm sending you a message since I will be shutting down my mobile phone shortly as I'm taking off to Cairo. I'm referring to our conversation with Wael. Wael is the HR in charge regarding my end of service. And as I was told that I will receive my end of service as soon as I cancel my visa with strategy, I received the same confirmation from Adia by email before a few days before and canceled my visa. According to what I was told and trust I have in TIG, I received the cancellation process before collecting my end of service on the day of my cancellation. So this is not an agreement. I see this from my point of view as an agreement. Why are you saying that there is no agreement?
Mr. Zadloul, I think we've been through this. We know the date of Mr. Abu Zaid's visa being cancelled. It was the 28th of September. We've just looked at that, haven't we?
Yes.
He wrote this WhatsApp, unsurprisingly, in October 2016, in circumstances where he had honoured his side of the bargain by having his visa cancelled, and he was expecting to be paid his end of service benefit. It hadn't been paid in October 2016. It wasn't paid until the 2nd or 6th of November 2016. And unsurprisingly, Mr. Abu Zaid is drawing those particular circumstances to your attention. That's correct, isn't it?
Yes.
Thank you. So what we have in the email is a more or less contemporaneous record, i.e. at the time in question, of what the partner and head of department at Global and specialist counsel at Global say happened. I would suggest to you, Mr. Zadloul, that what is set out in this email at G97 and 98 is probably accurate because it relates to important matters which were at the forefront of the writers' minds.
Is that not a question for me, Mr.
It's probably not a question.
Yes.
Submission. Would you? The email was written on the evening of the events we've been exploring, wasn't it, Mr. Zadloul?
Yes.
Would you expect the events which are set out and recorded in this email to be fresh in the mind of the writers of that email?
No, because we went to another lawyer and we told him exactly what happened. We don't see any misleading to the court, and we did not mislead or we did not say any false statement. We just said the truth, and the lawyer still defended us. So I was really surprised that the night of the trial, our lawyer that has been preparing with us for so long time, that says that, oops, we have a problem with the statement of Hatem, that we stayed with him twice before, and he did not, he's now saying something different.
Well, the court is going to have to decide on this, isn't it? And there are really three alternatives, Mr. Zadloul. The first alternative is that what's recorded here was never said at all.
Mr. Patrick Joyce, you are really getting further into submission rather than...
Okay. I take the point. Mr. Zadloul, let me put it this way. If Miss Lacan and or Miss Hoare had misunderstood, they had plainly set out their understanding of what had happened on the 18th of February in this email, hadn't they?
Which is surprised. As I said, I was surprised because, again, she left the room for a while, came back, thank you very much, after a very short while.
So this email, I take it from that response, was drawn to your attention at or about the time it was received by Mr. Beckley.
Yeah, Mr. Beckley told me about it. Yes.
So
what did you do? They told me, what did you do? So I said nothing.
Well, Mr. Zadloul, if Miss Lacan and Miss Hoare had got it wrong, it must have been obvious to you that they had got it wrong in what they were saying in this email, mustn't it?
Yes.
Well, did you say so?
To Bill Beckley, of course.
To Mr. Beckley, and did you say so to Global, to Miss Lacan and Miss Hoare?
If you can see that this is not directed to me, I thought it's directed to the Bill Beckley and to the chairman, Mr. Khalid Jabra, and Mr. Ariel Hashmi.
Yes, but it relates to you. You were asked about it, and I'm asking you if you have any knowledge of someone going back to Miss Lacan, or you asking someone to go back to Miss Lacan and say, no, you've got it wrong.
But Mr. Beckley knows exactly what happened, and he doesn't need me to tell him to direct him how to do his job.
No, but Mr. Beckley had left the meeting at a very early stage, as Miss Lacan said, and as you confirmed. So the only person who can, the only person.
What happened? He asked me what happened. I told him exactly what happened, and it's up to him to decide what to do next. It's not up to me.
Thank you. Mr. Zadloul, I think the remainder of the email concerns purely legal matters and matters which cannot be taken further with you. May I ask you this? If we, and forgive me, let me just gather my papers together so I've got them in order. If we look at the defence and counterclaim in this matter, at page A19,
Yes, sir.
we can see that that is the statement of truth is Mr. Beckley's statement of truth for and on behalf of the industrial group. If we look on to the end of the amended defence and counterclaim at A29, this was made on the 16th of February 2020.
Hold on, because I did not get it yet. Just yes, I'm at 829. Yes.
And that is signed for and on behalf of the industrial group by your legal representatives.
If you say so.
And we know from Mr. Beckley's evidence that he left the employment of TIG on the 18th of November 2019. So it's unsurprising that he was able to sign the original document and unable to sign a statement of truth for the amended document.
What you're saying?
You agree that Mr. Beckley left in November 2019 and therefore could not have given instructions to sign the amended document?
I have no idea about what you're talking about. It's whether he left or he stayed, the date he left, whether he gave instruction. It's not to me to say. How can I say that?
Did you give instructions for this statement of truth to be signed?
Me, myself?
Yes.
No.
So you can't help me with any disparities in relation to the basis on which the amendment was sought and the amendment as in fact made. So I don't think I can ask.
If I interfere, Your Honor, the time schedule now we are hearing the testimony of William Beckley within 1.5 hours, and we still have 2 other witnesses to examine. So maybe, I don't know, it's your the decision, Your Honor, but I think the time limitation has been extended more than reasonable. We still have to ask Mr. Zadloul some questions also.
Well, I finished my
Joyce is almost at hand.
Judge, Your Honour, I can reassure the court I finished my cross-examination. The witnesses, Mr. Hamid and Mr. Jabira, will be relatively short, and Mr. Beckley, I'm sure, will be called on time.
Anyway, have you finished with Mr. Zadloul?
Yes, I have. I have finished with Mr. Cross-examiner, Mr. Zadloul.
Thank you. Well, Mr. Kanan, then if you have any re-examination, let's get that done and we can move on. It's when you're ready, Mr. Kanan. Thank you.
Sorry?
Yeah, okay, go ahead.
Yeah. Mr. Zarul, it appeared that you have been exempted from the requirement that the end of service indemnity will only be paid at the time of the visa cancellation. Can you explain the reason why this happened with you?
As I told you, before, that I'm an employee of the group since it was called Banawi Industry Group since 1991. My relation basically is continuous, even if I leave the group and I don't work for the group, which happened, for example, in 2011 to 2014. I still have the residency in Saudi Arabia, which I used to have for the meetings as a board member for other companies in Egypt, Saudi Arabia, and Switzerland at that time.
So I understand here that due to the continuation of your relationship with the group and being a board member in certain companies in the group, you were exempted from the requirement of cancellation of the visa earlier to the payment of your end of service dues. Is this correct?
Correct.
Correct. Were your statements in the meeting of 18 February 2019 inconsistent with your witness statement, as Mrs. Lakan stated in paragraph 20 of her witness statement, which can be found under bundle C, page C14?
I have no C14.
No, C. Maybe C24.
I have Mr. Sharon Lakan, C9 to C18. Is this the one?
Yes, that's it.
So can you direct me, please, which paragraph?
Paragraph, page C14, which
C14. Okay, I'm at C14, yes.
2021. 20. I put 20. Paragraph 20.
Paragraph 20.
Okay, 20 or 21?
20. Both.
Both 20 and 21.
Okay.
So, were your statements in the meeting of 18 February 2019 inconsistent with your witness statement as Mrs. Lakan stated in paragraph 20 of her witness statement? Was it inconsistent or not?
I'm just reading it. First time I read it.
Okay.
Completely different from what has been in the witness statement. Yes, it is consistent, but yeah, that's a very short meeting, actually.
Okay. Were you ever provided with the opportunity to provide an explanation as to your statements during your meeting on 18 February 2019?
No. As he said, she said there's something wrong. It was obviously, is there something wrong? Talking to my lawyer, is there something wrong? Said.
How do you interpret this? I mean, what was the reason for cutting short the meeting with you?
I don't know, but I think I would assume this would be an assumption that they thought that this is the end of it, and they did not know the full truth, as you correctly asked, what was the reason behind being paid or something like that, and then they found out that there is no chance, as whatever they're building was baseless if they were going to continue to this.
Would you consider?
Sorry.
Would you consider that the decision not to appear on the 20th February hearing was taken earlier to hearing you in this on 18 on this during this meeting?
I don't see that arises out of any cross-examination, and I don't see how it's relevant. It's not presaged in any pleading. I think it's an improper question, Judge.
The question is rejected, Mr. Kanan.
Thank you, sir. Given the importance of the testimony, would you have expected more time to clarify your position during this meeting?
Definitely, yes.
Did they ever seek any further clarifications from you regarding your statements which you made during the meeting on 18 February 2019?
No, it was a short meeting, and I was really surprised of the reactions. And I was really surprised of the reaction. And even their own words, he immediately asked if there's something was wrong. I was really surprised then. What's going on?
Was the meeting a matter of minutes or hours?
Definitely minutes.
When you were invited to attend the meeting, what was the time span that you were expecting?
This has been covered in the evidence already, Mr. Kanan.
Okay, thank you, sir. One more question, sir. Your Honor. Was it the claimant that prepared the witness statement, or did you prepare the witness statement personally?
Again, please.
Your witness statement was prepared by you personally, or by the claimant, by Global?
No, they were coming there with William Beckley to the office, and we were doing these statements together. They were asking the question, and I was answering them.
Did you provide the statements to the extent that you believe were correct?
Yes, of course. Even they thought that they instructed me not to say anything that's not correct.
But you were not. Okay. Did the claimant consult with you on the legal strategy at any time?
Definitely not.
Were you in a position to give advice on the legal strategy?
No. No, sir.
Did you at any time try to hide that you were a member of the board?
No, sir.
If you had been asked about it at any time, would have informed him?
Sure, it's a legal documents. It's in the commercial registers and all these things. So there's nothing to hide.
I think our questions have been covered, Your Honor.
Thank you, Mr. Kanan. Is there any reason why Mr. Zaglul also cannot be excused as a witness?
No, I'm very happy for Mr. Zagul to be released.
Yes.
Yeah,
Mr.
sure.
Zagul,
Thank you. He can be released.
free to go as a witness. Thank you.
Thank you, sir. Thank you.
Mr. Patrick Joyce and Mr. Canaan, let's just go back to this document, the engagement letter. What I am uncertain about from what Mr. Canaan said was whether or not it's disputed that the engagement letter was received by TIG. I understand his response to include, yes, but it wasn't signed and returned, which I don't think is disputed. What I'm uncertain about is whether it's disputed whether it was ever received. Can you clear that up for me, Mr. Canaan?
We acknowledge now that it was received, but we have to check with the client. The document would show that it had been received, but we need to verify this and check it over with the client.
I'm sorry, I understood. Yes or no, is it disputed that that document was received by TIG?
I cannot confirm it, Your Honor, because we need to check it with the client.
Right. Well, now, can you check with the client very quickly then? Surely someone can set some inquiries in train, because it seems to me that is the...
Whenever we have a break, I'll try to check with the client, Your Honor.
Good. Well, please do that when we have a break and you're able to set about that.
Sure.
It seems to me that that might be the question that there is. Now, as I understand it, we need to have Mr. Beckley at what will be 2:30, because he's arranged for that time, and that's a particular time in Canada. Is that correct?
Correct, Your Honor.
Right. How long do you expect you'll be with him, Mr. Patrick Joyce?
Sorry.
I will be sometime with Mr. Beckley because we need to go through the invoices in relation to the Albanoui matter, and there are several invoices to go through there, but I will be as quick as I can.
Well, what I did not check, what is the time in Canada now?
It's 8 hours, so the time 4 a.m.
Right. Okay.
It's 8 hours, so
5
a.m. 5 a.m.
5 a.m.
Right. Very well. Well, we need to bear in mind that the plan is to start with him at 8:30 my time, and it starts to get very late over here. So there may be a limit of our ability to sit. Let us hope that that does not arise. So whatever happens, I suggest we should break off if we have not completed one of the other witnesses in order to start with Mr. Beckley at the appointed time. Does that seem sensible?
It is, Your Honor.
All right. All right. Now, we want to just take a 10-minute break now and then start on one of the other witnesses.
Meanwhile, I'll check with the client, Your Honor.
Who's next? Mr. Hamid, isn't it?
Yes.
Yes, Your Honor.
I think both Mr. Hamid and Mr. Jabera will be short.
Yes.
All right. Well, I think a 10-minute break now would be a good idea. So we'll break for 10 minutes. We'll come back. Please get Mr. Hamid organised, and we'll move on as best we can.
Good.
Thank you all.
Thank you, Your Honor.
Thank you, Olga.
Are you hearing me? Can you see me?
Yeah, I can see you.
Mr. Patrick Jones, you're hearing and seeing?
Yes, Your Honour.
Thank you. And is that Mr. Hamid that's with you, Mr. Kanan?
Yes, yes, I'm just yes, Your Honor, he is here.
Good afternoon, sir. When you're organised, let me know, and I'll ask Matha to swear Mr. Hamid in the usual way. Are you ready to go, Mr. Kanan? Are you ready to go?
Yes, Your Honor. Thank you.
Martha, would you be good enough to swear Mr. Hamid?
Could you please state your full name?
My name is Faisal Hamid. I am working as an apparel accountant for the industrial group.
Thank you. Could you please repeat after me? I swear by the Almighty God to say nothing but the truth.
Okay.
Can you say it, please?
I swear.
I swear.
That will be fine, thank you. Yes, thank you, Mr. Kanan. If you could have the witness statement verified as before.
Mr. Faisal, can you please provide us with your current address?
DIFC, the industrial group, DIFC, Dubai.
And what is your present employment with the defendant?
Senior payroll accountant.
Did you read the witness statement in full?
Yes.
Can you confirm that the statements which are set out in your witness statement are correct at the time of signing and as of today?
Yes, correct. As of today, correct.
Is that your signature at the bottom of the witness statements?
Yes, correct.
Can you please confirm the dates?
7th of June 2020.
Yes, thank you, Mr. Kanan. Mr. Hamid, Mr. Patrick Joyce will ask you some questions. Okay. He has told me he will not be long, so we will try and hold him to that.
Yes.
Thank you.
Thank you, Your Honour. Mr. Hamid, you verified your first witness statement of June 2020. You also made an earlier witness statement in the Abu Zaid proceedings. That witness statement was made on the 29th of October 2018 and appears at page G44 and 45 in the bundle.
Do you have access to that, Mr. Hamid?
Yes, I have.
Could you just turn those pages up, 44 and 45?
Okay.
Again, if we look at the foot of page 45, there's a statement of truth bearing a signature and a date. Is that your signature?
Yes, and date is 29th of October 2018.
Yes. And were the contents of that witness statement true and accurate when you signed that witness statement?
Yes.
And they remain true and accurate?
Yes.
If you look at that witness statement, we can see that in paragraphs 5 and 6, you refer to correspondence by email.
Yes.
And may be convenient if we just turn that up. The correspondence is at pages 15 to 17. 15 to 17.
I don't have this 16.
16? Okay. So, في الكتاب عندكم
عندي 14 يا حبيبي. عندي 14. جيب ثواني.
خليل صنع.
Do you have those? Oh, no.
Can you repeat that?
Then I do have the correspondence email right now with me.
No, that's fine. As long as you have the documents, Mr. Hamid, that's fine. If we look at those documents, the first in time is at the foot of page G17. You see that? That's the email dated the 1st of November, but timed at 4:50 a.m.
It's exactly correct. Yes.
And certainly so far as the evidence is concerned, and I think this is probably accurate, this is the start of this email correspondence, because I think you've just been on holidays. It may even have been an Eid holiday.
Yes, exactly. Correct.
So that would explain why Mr. Abu Zaid would know that you've spent some holiday time. And he says, I am reaching out to you today regarding my end of service. And then he raises the point about my last working day being the 30th of September. As per the DIFC labour law, end of service benefit is payable to employees within 14 days after the last day of duty. It's been a full month today with no payment. You go back and ask him about his visa statement.
Yes.
We see that further up the page.
Yes.
That's 17. And then he comes back to you later that afternoon, spanning pages G16 and G17, saying visa is not cancelled yet. It was agreed with Hatem Zadloul that I will keep my visa until I sort out my new visa position. It was not agreed to relate that to my end of service settlement. The usual process is that the employer pays the employer's end of service in full within 14 days after the last day of duty. Then visa cancellation takes place immediately after or later, if that is mutually agreed between employer and employee. In all cases, end of service benefit needs to be released before visa cancellation. And then you wrote back to him later that afternoon, thanks for your email, kindly contact with HR. If they say to release the end of service, we will do the needful.
Exactly.
So having looked at that short run of correspondence, it was the case that Mr. Abu Zaid was indeed, as he describes it himself, reaching out to TIG, wasn't he?
Yes. Yes.
And if we look back at page G45, to be fair to you, you say in paragraph 5 that Mr. Abu Zaid sent me an email. So, sorry,
Yeah.
Paragraph 5, page 45, G45.
Yes, I will have this one.
Do you have that? Do you have G45, Mr. Hamid? There's no doubt that what Mr. Abu Zaid has said is accurate. He started the conversation and he was reaching out to you, and I think you confirmed that position in paragraph 5.
Yes.
And then around the same time, paragraph 7, he called you twice. So he was really very keen on following it up, wasn't he?
Yes.
But you must have known from the contents of the emails that we've just been looking at that the industrial group, TIG, was at risk because Mr. Abu Zaid had referred you expressly to the DIFC labour law requiring payment of end of service benefit within 14 days after the last day of duty, which its common ground was the 30th of September 2015. You must have known you were at risk, or the TIG was at risk, mustn't you?
Yeah.
Must have known from the email exchange that TIG was at risk.
Yeah, but as per the prior to release the end of service, I may ask the PRO whether they cancel the visa, or the same time I subsequently required HR approval as well. So in this Rami case, I request him to talk to HR and get the approval. Once we have the approval, we can release it.
Why didn't you explore the matter internally? Because you knew that the TIG was at risk of being in contravention of the DIFC labour law.
Yeah, this is the procedure what we are following since I joined the group. Once the visa has been cancelled, then only we are releasing the end of services.
So am I right, Mr. Hamid, that as far as you're concerned, you don't step outside what the sequence that you've described under any circumstances?
Yeah, and for that also he is a senior manager also. For this case, he has to talk to his line manager. Once the line manager also insists me to do so, I will definitely do. But without any confirmation or approval, I cannot release the end of service of the Rami. So,
but Mr. Hamid, isn't this an extremely limited view? Because on the one hand, you were in contact with Mr. Abu Zaid, who was telling you that TIG was at risk. And on the other hand, you had your own powers within TIG to move the matter forward internally. You could have kept in touch with Mr. Abu Zaid and or referred matters internally, couldn't you? You could have done one or both of those steps.
Yeah, in this case, I already verbally informed his line manager, and they said that they will take care of this. Once it's ready, they will inform me, then only you need to release the end of service.
And so your response is booming, and I think I heard you say that you took it up with a line manager. Is that right?
Yes.
And could you just repeat, so that I can catch it, what you took up with the line manager and what happened?
I informed that Rami is following with for his end of services, and I do not have the clearance, and his visa has not been cancelled. And could you please advise on this? Then he said that okay, we will come back to you regarding this.
And that was your internal line manager in TIG?
Yes.
Who was that?
Mr. Abdul Aziz.
I'm sorry, Mr. Could you repeat the name again, Mr. Hamid?
Abdul Aziz Al-Fatih.
You. So am I right that as far as you're concerned, you did take the matter up internally and
Yes.
therefore assumed it was outside of your hands and being taken care of by someone else?
Yes, because he is my line manager, I informed to my line manager.
I think we can go back now to your first witness, and the person who was taking it forward was Mr. Abdulaziz Al-Fayan.
Abdulazim Al-Fadi.
Thank you. That is the same Mr. Abdul Azim El Fadl who you refer to in paragraph 9
Yes,
of your
exactly.
witness statement that we're looking at on page G45.
Exactly, correct word. This is the person, correct.
So as far as you're concerned, the matter was in Mr. El Fadl's hands from November 2015 onwards. You have no knowledge as to what he was doing, but you, so far as you were aware, it was in his hands from that date. Is that correct?
It's correct, correct. After that, Ram didn't come back to me as well.
But you yourself heard nothing between November 2015 and September 2016.
Yes.
Mr. Hamid, can we then return to your witness statement, more recent witness statement of the 7th of June 2020, pages C23 and 24?
Okay.
Could we look at paragraph 6 on page C24, and this is simply to correct a typographical error. We've been looking at your first witness statement of the 29th of October 2018. We know it only has 2 pages, so the reference to pages 2 to 7 should, I think, be a reference to paragraphs 2 to 7, or it may be to the exhibit. Maybe it's to an exhibit which has been deconstructed. I won't take that further. It's a small point. Mr. Hamid, do I take it from your answers that you had no authority to instruct the legal representatives of PIG to sign an amended pleading?
No, I don't have any idea about it.
Thank you, Mr. Hamid. Those are my questions.
Thank you so much, sir.
On any re-examination?
Yes, Your Honor. Was it a company policy to pay the employee end of service indemnity after cancellation of the visa?
Yes. When I joined the group, since we are following that.
Okay. Now, was there anybody earlier to Mr. Rami Abu Zaid, who, except for possibly for Zaghloul, that his visa was cancelled earlier, that his end of service was paid earlier to the cancellation of his visa?
Exactly correct, because he is one of the board member of the group.
Okay, fine. But any other person other than him that he was paid the end of service earlier to the cancellation of the visa?
No.
So it was a standard policy of the company.
Exactly.
Is this in line with the labor law of the UAE?
Yes, in my previous company also we were following the same rule.
So you are following the rules
of
which are implemented under the civil law and under the labor law of the UAE.
Exactly correct.
Were you advised at any time that there is a requirement to pay the end of service indemnities at the time of terminations or within 14 days of terminating the services of an employee?
Your Honour, I'm not sure that this arises from cross-examination.
I don't think it does, Mr. Khan. It hasn't from the beginning of your re-examination.
Okay. Thank you, sir. That's it.
Thank you, sir.
Mr. Hamid, thank you for your assistance. You're free to leave as a witness if you wish.
Thank you so much, sir. Thank you. Have a good day.
Khaled.
I think we have Mr. Jabera.
Sure.
Yes, thank you, Martha. Would you please do the...
In relation to the question raised earlier, whether the defendant had received the email of Global regarding the arrangement, payment arrangement. Actually, we have checked briefly, and the person concerned there, he said he did not receive anything until now. On the same token, from our side, we have sent an inquiry on Monday, July 27th. On July 26th, addressed to Global, inquiring, which states, please find below some comments regarding the index. One of them, are there further letters of engagement or agreements Global would want to rely on? We understand that Global claiming that the basis of this dispute is contractual, but we have not received any response to this email, Your Honor, until this moment.
Very well. Well,
sorry.
I note what you have said, that at present, it seems that TIG is unable to agree that it received that document. So Mr. Patrick Joyce will consider what he wants to do about it. So we'll go back to Mr. Bearer and deal with his evidence.
Can I add one thing, Honor? If the inquiry is, can we know that whether it was sent by email or by hand or by courier, this will make easier our accessibility.
I'm sure that those instructing me will have heard that will make inquiries.
Thank you, Your Honor.
Gentlemen, we must try and avoid the talking over each other because of the delay. I would expect that to be something taken up between the legal representatives as soon as possible to try and sort out what has happened. Now, I will say no more about it, but as I said before, let us go to Mr. Jabera.
We will do that, Your Honour.
Yeah. Thank you, Mather. Could you please swear Mr. Jabera?
Could you please state your full name?
Khalid Hamid Jabra.
Could you please repeat after me? I swear by Almighty God to say nothing but the truth.
I swear that I would say nothing but the truth.
Thank you, Mr. Jabra. Yes, please, Mr. Kanar.
Yes, sir. Can you please provide us with your current address?
My current address is DIFC, Building 7, Floor 8, TIG Company.
What is your present employment with the defendant?
I'm the director of TIG.
Did you read the statement, your witness statement in full?
Yes, I did.
Can you confirm that the statements which are set out in your witness statement are correct at the time of signing and as of today?
Yes, I can confirm that.
Is that your signature at the bottom of the witness statements?
Yes, it is.
Can you please confirm the dates?
7th of June, 2020.
Yes, Your Honor, we have.
Thank you. Yes, Mr. Patsakouris.
Thank you, Your Honour. Mr. Jabera, as I see the papers, this is your only witness statement. You've not made a previous witness statement, either in this or in any matter such as the Abu Zaid case, have you?
No, I did not.
One small point to correct a typographical error. If you look at paragraph 1 on page C19.
Yes.
I think it should be, I was employed by the defendant from September 2015, because your employment is with TIG and has never been with Global Advocacy.
Yeah.
You're happy for that correction to be made, are you?
Sorry, but yes, I maybe did not realize that, but it was, I'm the director of TIG, that's for sure.
And then
Dean, a moment, please. Mr. Jabra, one other thing of almost no importance. You say, I am the director. Do you mean that you are a director of the company, or is there a special office of the director?
I'm the director of TIG.
What does the director mean? Is that like the chief executive officer or some similar position?
For the legal structure of this company, there is a position called director. So against DIFC, I'm wholly responsible about the company.
Right. Thank you very much.
Yes.
Mr. Jabera, thank you for those clarifications. Having read your witness statement, am I right that you cannot speak to the particular circumstances of the Abu Zaid matter because you had no involvement in that matter?
No, I can't. I was maybe involved, but I have to stick to my statement here, the witness statement.
Thank you very much, Mr. Jabera. I'm sorry that it was perhaps some of the matters could have been dealt with, but that's all that I asked by way of a cross-examination. Thank you very much.
shall we excuse Mr. Jabra?
I'm very happy for
Yes,
that to happen.
yes, Your Honor. We have no questions.
Thank you. Thank you, Mr. Jabra.
Okay.
You're free to depart from the case if you wish.
Thank you.
All right. Well, Mr. Beckley is the remaining witness, and I take it his time can't be advanced in any way. Is that a possibility or not? Mr. Kanan, are you able to say?
I didn't get it, Your Honor. I didn't get it. What did you say?
Is it possible, do you know, for Mr. Beckley to start giving his evidence early than 2:30? I think the time over in Dubai would now be about 5 to 2. Is that right?
5 to 2. We can try to contact Mr. Beckley if Your Honor directs us so, and try to bring him earlier to the stand.
He will be giving evidence from his own computer, I gather, from an earlier hearing. Is that as you understand it?
Yes, Your Honor. Actually, the sound is not really. There is some. The sound is not clear, but we'll try to work on it.
All right. Mr. Patrick Joyce, which way would you like to go? Is it better, do you think, to just leave the arrangement as it is?
I'm in Your Honour's hands as to what arrangements are made. I can see benefit in bringing Mr. Beckley's witness comment to the start of his evidence forward if it's convenient to him and if he can be raised. Otherwise, it is an early start for him. I don't want to put any witness under undue pressure. I'm happy to reconvene at 2:30 if that's more convenient.
I think we will leave it as it is. We will commence again at 2:30. But we might just spend a moment now considering what happens next. After Mr. Beckley's evidence, that will be a conclusion of the evidence. How do you wish to then deal with submissions? It is something I would wish to move onto without although clearly it cannot be today. Let us take you in order. Mr. Patrick Joyce, what is your proposal for going into submissions?
Well, again, I'm in the court's hands. It can either be dealt with by way of written closing submissions, as to which an appropriate time could be given, or again, an appropriate time could be found in a diary for oral submissions.
I would suggest the same, Your Honor. Let's start by written submissions and submit it to Your Honor.
I think we will certainly need some oral submissions. There are matters which I can see need to be debated, and I cannot see pure written submissions is sufficient, but nor do I want delay. Would either of you be in a position to move straight into oral submission?
The submissions so they like them.
Are we immediately after the evidence?
On the next day?
It will be more convenient, Your Honor, to do it later this evening at any time that it is reasonable. I'm sorry, Your Honor, you are in Australia. We don't want to keep you late also. So
I'm not saying today, I'm saying tomorrow. That is, we start again.
Tomorrow, any time, Your Honor.
I mean, do you think you can do your respective cases justice if I ask that we move to written submissions tomorrow? Or do you think that would be too much, and you think to do your clients' cases Justice, you need a little time to prepare at least a written outline.
We can do it by tomorrow, Your Honor. Or by Sunday, because we have a weekend coming up.
I'm sorry, I didn't catch that.
We have our weekend coming up here on Friday and Saturday. So if we have to do it tomorrow, it will be late tomorrow, not earlier to another 2 hours, which is around, it will be 4 o'clock our time here. So for all intents and purposes, I would suggest to keep it until Sunday, Your Honor, or Monday, whatever is the timing reasonable and suitable for you. But because of the time pressure, we cannot finish it tomorrow before 4 o'clock our time, or maybe 5 o'clock. We are not sure, Your Honor. So if we leave it to on Sunday, we are working in Dubai here, but we can still do it on Monday also.
Right. Well, now I think that I understand from that Mr. Kanaan, you think tomorrow would really be asking too much, and there should be at least a little time, and we might make a time a few days away. It does seem to me that maybe that is the preferable course, to make a time early next week. That would give you the opportunity to have outlines in the sense of at least heads of submissions rather than kind of full written submissions, and we can deal with the matter in that way. Back to Mr. Patrick Joyce. What do you think about taking that course, and what is your availability? And then I'll return to Mr. Kanaan about availability.
Your Honour, I think what Mr. Kanaan has said is probably a sensible course. One wants to deal with matters quickly, but one also wants to reflect and put in a proper outline of closing submissions, which will be helpful and constructive to the court. My own personal circumstances are that Sunday is inconvenient for me, but next week I'm more than happy to make myself available at whatever time is convenient to everybody.
All right, well, we will leave it up in the air now, but the thought is to perhaps fix a time, not Monday as far as I'm concerned, but say Tuesday, if that is a convenient time for both of you. And maybe make a 9 o'clock start Dubai time, if that's also convenient. I don't have in my mind what time it would be for Mr. Patrick Joyce. So the tentative thought then is that we will move to oral closings, but based on written outlines, which you will be able to prepare and provide by, let us say, Monday lunchtime. And we'll move into oral submissions on Tuesday at 9 o'clock Dubai time. That's the tentative program. If you would like to both think about it and see whether that is a good way to go.
From our side,
yes, it will be a very early start for me, but I'll manage that, no problem.
We could make it later because we won't have the same time pressure. What would be a convenient start time?
Well, I will be 3 hours before, 3 hours earlier than Dubai time. So 10 would be 7 o'clock in the morning. I'm very happy to start at 7 o'clock in the morning, and it would free everyone's day up.
Yes. Well, let's think of 10 or 11. 11 would be, that's starting to get late for me. So 10 seems a reasonably good compromise. And there's also the normal Dubai time.
Yes.
Yeah. All right. So that's what we can confirm that unless other ideas occur to us at the conclusion of Mr. Beckley's evidence. Otherwise, we'll turn the case till 2:30 Dubai time. Anything else?
No, I'm very much obliged, Your Honour.
Right. Thank you very much. I'll see you in half an hour or thereabouts.
Thank you.
Mr. Patrick Joyce in one screen and Mr. Canaan on the other.
Yes, I can, Your Honor.
Thank you. And if you both of you would say something so we can make sure Mr. Beckley can hear you.
My name is Michael Patrick Joyce, and I'm saying something now, so I hope you can hear me, Mr. Beckley.
Yes, I can hear you, Michael.
Good morning,
Thanks.
Mr. Beckley.
Good morning. How are you, Mr. Canaan?
Fine, thank you.
Very well. Yes, ready to go, Mr. Canaan?
I am, but there is the oath first, maybe?
Which?
The oath.
Oh, yes. Martha, would you please swear Mr. Beckley?
Could you please state your full name?
William John Beckley.
Could you please repeat after me? I swear by Almighty God to say nothing but the truth.
I swear by Almighty God to say nothing but the truth.
Mr. Beckley, sorry.
Yes, Mr. Khan, please go ahead.
Can you please provide us with your current address?
Yes, I live at 51 Highland Woods Court, London, Ontario, Canada.
And what's your present employment with the dependent, if you are still employed?
No, I'm retired.
Okay. Did you read this the witness statement? Your witness statement, did you read it in full?
Yes, I did.
Can you confirm that the statements which are set out in your witness statement are correct at the time of signing and as of today?
Yes, I can confirm.
And is that your signature at the bottom of the witness statements?
Yes, it is.
Can you please confirm the dates?
My fourth witness statement is dated July 1st, 2020. My third witness statement is dated 18 November 2019. And my second witness statement is dated 18 November 2019. And my first witness statement is dated 18 November 2019.
Thank you.
Oh, yes.
Yes, well, Mr. Patrick Joyce will now ask you his questions, Mr. Beckley.
Okay.
Mr. Beckley, I wonder if we can start with the Al-Banawi matter, which is covered by your third and fourth witness statements.
Okay.
And if we look at, starting with your third witness statement at page C32,
Okay, third witness statement.
third witness statement, page C32.
Okay.
Paragraph 5, you refer to the first meeting that you had with Mr. El Fakhri and Ms. Gerges on the 24th of October 2017.
Yes.
Now, you supplement that by, I think, paragraph 13 of your witness statement, your fourth witness statement. Paragraph 13 begins on page C37.
Yes, paragraph 13.
Yeah. And you say, in relation to what transpired between yourself and Mr. El Fakhri principally, but also Graziella Gerges, you say at paragraph 13, in relation to the time estimate that you say Mr. El Fakhri gave, you say you verbally accepted it and made a note of.
Yes.
I haven't found that note in evidence, Mr. Beckley.
Well, I certainly made a note of it at the time, and I had that note when I put together my witness statement.
But on the material evidence, and I'm sure I'll be corrected if I'm wrong, on the material evidence before the court, there is no copy of any note.
Yeah, I don't believe there's a copy of my note that I made.
Now, Mr. Beckley, you say that the overall costs were estimated at between 15,000 and 20,000 dirham. That's your evidence, isn't it, in this regard?
No, between 10 and 15 hours.
Okay, 10 and 15 hours. I think if we look, forgive me. Could you look back at page A23, please?
A23.
Mm-hmm.
Okay, I have A23.
And this is the pleading put forward on behalf of the industrial group. This is the amended defence and counterclaim. It begins at page A20, if you just want to confirm familiarity with this document.
Right.
And at the foot of page A22, sets out the pleading in relation to the Al-Banawi matter, paragraph 6. Do you see that at the foot of page 22?
I do, yes.
And then if we turn on to subparagraph C on page 23, the pleading is as follows. Particularly, Mr. Beckley states that in paragraph 6 of his third witness statement, when asked about these fees, Mr. Rabi Al Fakhri stated that the overall cost would be between 15 and 20,000 dirham. And that's the source of what I was putting to you, Mr. Beckley.
Yes, well, it was actually between 10 and 15 hours, and I think at Mr. Fakhri's rate, it would have come out between 15,000 dirhams and 20,000 dirhams based on the 10 to 15 total hours.
Well, what was said? Was it spoken about in terms of hours? Was it spoken about in terms of dirham? What is your evidence in relation to what was said, Mr. Mr. Beckley?
Both. Between 10 and 15 hours, and then we knew his rate.
Could we now look at the document at bundle D1? That should be an email from Ms. Gerges to you of the 25th of October 2017, so the following day.
It was D1?
D1.
Okay, I have D1.
If we look at that, it refers back to the meeting, so it's the matters of the previous day are being reprised. And then we see just above the table with partners' rates. On other note, we would like to share with you that our professional fee to handle the matter will be on an hourly basis, with a deposit amount of AED 30,000 as per the following fee structure.
Yes.
Mr. Beckley, if what you said was right in relation to the discussion on the 24th of October, it is strange indeed, is it not, that Ms. Gerges, covering what had been said in that meeting, doesn't talk about a capped rate, but talks about an hourly basis, and doesn't talk about a cap of 15 to 20,000 dirham, but talks about a deposit amount of 30,000, which is double the lower sum and 50% more than the higher bracket that you say you were quoted the day before.
Yeah, which was totally rejected. We never made a 30,000 deposit, and I think we rejected the rates as well. The rate was lower.
Well, we'll see what you said in response. If we go on to D15 and 16, I think we have to, there are two relevant emails here, we have to read them in reverse order. So let's start at the foot of D15, your email to Ms. Gerges of 4:04 p.m. on the 26th of October. And we go over the page. This is what you write. Dear Graziella, it was a pleasure to meet you and Rabbi. Please provide us with a fee cap for this matter. If what you say had indeed taken place 2 days previously, you already had an answer to that, didn't you, Mr. Beckley?
I don't follow you.
Well, if Mr. Rabbi had indeed said, well, it'll be a certain number of hours, or which will equate to 15 to 20,000 dirham, you know from what has been said 2 days previously what the fees are. You don't need to ask right at the beginning for the provision of a fee cap. You've already got it, haven't you, on your evidence, Mr. Beckley?
No, we don't. I had a conversation with Mr. Rabi, and we agreed, and he told me that the fee cap would be between 10 and 15 hours.
Well, if that was the case, why didn't you remind them of what you say took place?
Remind them of what?
Of the agreement that it would be 10 to 15 hours or 15 to 20,000 dirham, whichever it was.
I did in my conversation with Mr. Rabi.
Which conversation with Mr. Rabi?
Regarding the fee cap.
The earlier conversation of the 24th of October.
No, we had a conversation where we agreed that the fee cap would be between 10 and 15 hours.
Where do we find, when did that conversation take place?
I'm not certain, but it was around this time, of course, because we're just initiating the litigation. I've told them that we need a fee cap, and Robbie came back with a fee cap of between 10 and 15 hours, which I accepted.
Well, if Miss Gerges was writing to you, as we've already seen on the 25th of October, saying, please provide a deposit amount of 30,000, had the agreement on your version of events taken place before that or after that?
I'm not certain whether it was before or after. I can't recollect, but it was around that time, of course. And we, of course, rejected the 30,000 deposit.
Well, we can test that, because if it had been beforehand, what I put to you must be right. Namely, why did you not take it up with Miss Gerges in the email that we are looking at on the 26th of October?
Because I was dealing with Mr. Robbie, not Mrs. Gerges.
But you had been told...
She's an assistant. The head attorney on this matter was Robbie, and he was the person I was dealing with. And he is the person that agreed to the 10 to 15 hours fee cap.
Well, Mr. Beckley, you had met both Mr. Rabi and Miss Graziella 2 days previously. Miss Graziella...
I can't control the interaction between those two. She worked for him. I was dealing with Mr. Rabi with respect to the fee cap.
Well, why write to Miss Gerges saying, please provide a fee cap if you were dealing with that matter with Mr. Rabi?
Because she didn't do that, and I then contacted Mr. Rabi, and we agreed that it'd be 10 to 15 hours.
Well, wait a minute, Mr. Beckley. Are you dealing with Miss Gerges, or are you dealing with Mr. Rabi? Because in the email I'm dealing with...
Mr. Rabi was the attorney in charge of the matter. Mr. Rabi was who I was dealing with. Mr. Rabi is the individual with whom I made the agreement on the fee cap, 10 to 15 hours.
Well, what I would suggest to you, Mr. Beckley, is that on the state of the emails that we are looking at, it is quite plain that there was no fee cap as of whatever the time was of D15, 4:06 on October the 26th. 2017. Because if there had been agreement, you wouldn't have been asking that question, would you?
No.
And then you say, we do not make any advance payments or deposits. We pay only on the basis of invoices for work completed. And then you go on to say what the invoices should contain. Now that's plainly picking up what Miss Gerges had said in her email, which we've already looked at, and which included not only reference to a deposit, but a deposit amount of 30,000 dirham. So you must have had you must have known of that figure and had it in mind when you were writing your email that we're looking at page D16.
Which figure is that?
And you must therefore have known, Mr. Beckley, before on your case there was any discussion of a fee cap, that the deposit amount was being contemplated as being 30,000 dirham, because that's what you'd been told in the email to which you are responding.
Well, certainly. And it was rejected in my conversation with Robbie, where we agreed upon the 10 to 15 hour fee cap. We rejected the 30,000 deposit.
Well, let's continue with this email. You say, we do not expect to be billed for mundane clerical tasks or routine emails and phone calls.
Yes.
Well, we'll be able to look at the fee notes in due course to see the matters which you challenge. But let's continue. Let's continue with reading into the sequence of correspondence. If we go back to pages D14 and 15.
Yes.
This is Rabi picking up on the email that you had sent to Graziella. We see that from the first line, don't we?
Right.
Second paragraph, we agree that no advance payments or deposits will be made. You will be receiving from our end invoices for the completed works on monthly basis, showing the works that have been accomplished. So, correct. Accepting what you say and speaking purposefully to the advance payments or deposits, but telling you were going to be billed on a monthly basis.
That's right. With a fee
and
cap
then we know,
the
basis of calculation, don't we? Our fees will be calculated on hourly basis by reference to the time spent by the team working on your file. This includes
correct,
time
up to the fee cap of between 10 and 15 hours.
Well, where is this in
That
either your email to Mr. To Graziella Garges or Mr. Rabi's response to you?
It was based on the conversation that I had with Robbie.
When?
I'm not sure of the exact date, but it was certainly around this time when we agreed upon the fee cap for the matter.
Well, so far, you would, I think, agree with me that we find no reference at all in the contemporaneous documentation to an agreed fee cap, do we, Mr. Beckley?
No, because it was between Mr. Robbie and myself, a verbal agreement that it would be between 10 and 15 hours.
Well, let's go on to the next document in the sequence, which is a letter of agreement, a letter of engagement, and we'll find that at page D10. Do you have the...
Yeah, I have D10, yes.
Okay. Now, we know, and I think it's common ground, that this is actually misstated. It should be November the 2nd, 2017. So reading the correct date as November the 2nd, it's as follows: letter of engagement, scope of work. That's set out in 2, and we won't go outside the scope of work unless we agree the scope of additional work in advance with you. And of course, you had already been told by Mr. Rabi, looking back at D14, that the hourly rate includes time spent meeting with you or with others in person, advising you, reviewing papers, drafting pleadings and other documents, correspondence, traveling, and waiting time. So
I don't believe this document was ever signed by us.
Well, we'll come on to that, Mr. Beckley, but we know what Mr. Rabi had put back to you in relation to what the fees, what was chargeable under the fees. We've seen that in D14. and we therefore can read that into the scope of work on page D10, can't we? That's where we've reached as of the first 3 paragraphs of D10.
Yeah, but I believe this scope of work is correct.
Yes, and it must be read in the light of the previous correspondence and the email from Mr. Rabi, which we've been looking at
Yeah,
D14. Let's
I believe
continue.
the scope of work is correct, even though it was this so-called letter of engagement was never signed by us.
Well, let's continue. Your legal team, you're told that it's going to be Mr. Rabi, assisted by Ms. Graziella Gerges.
Who is the legal assistant.
Yes. And then we go on to page D11. Our legal fees and disbursements. Our fees are generally calculated by reference to the time spent by the team working on your file. This includes time spent meeting with you or with others in person, advising you, attending on telephone calls, reviewing papers, drafting pleadings and other documents, correspondence, travelling and waiting time. So what was said in D14 is expressly picked up in paragraph 6 of this letter of engagement, isn't it, Mr. Beckley?
Yes.
And then you're provided with standard hourly rates. There's a section, a paragraph on disbursements, a paragraph on tax and VAT, governing law at the foot of the page. Then we can go over the page to paragraph 11 in relation to small claims, and then the agreement. Do you have that, Mr. Beckley?
Which page are you on?
Now I'm on page D12.
Okay.
Agreement. Once you've had an opportunity to review this engagement letter, please sign below to indicate your acceptance of the same and return a copy to us. Paragraph 15. By continuing to instruct us, you will be deemed to have accepted our terms of business as contained herein. Please contact us if you have any questions regarding the above. We look forward to working with you. It's absolutely clear, isn't it, Mr. Beckley? Whether or not it was signed is beside the point if, as you did, you continued to instruct Global. And that's what paragraph 15 says, isn't it?
Yes, and it was on the basis of the agreement that we had with Robbie that the fee cap would be between 10 and 15 hours.
Well, where is this agreement, Mr. Beckley?
Why didn't you ask Mr. Robbie? I'm telling you there was an agreement.
Well, Mr.
Robbie worked for Global. Why don't you ask him? We had an agreement, a verbal agreement, that it would be between 10 and 15 hours fee cap.
Mr. Beckley, you were general counsel for the industrial group.
That's right.
You are in receipt of a letter of engagement. Nowhere does that letter of engagement, nor anywhere else in the papers that we have seen, refer to capped fees, which you now claim to be the case. If you received, and when you received this letter of engagement, surely as general counsel, you would go back to Mr. Rabi and say, we're not billing on a time spent basis, we're billing on a capped basis.
No, we're billing on an hourly basis up to a fee cap of between 10 and 15 hours.
And there is no cap in this letter of engagement, is there, Mr. Beckley?
As I told you, the fee cap was based on the conversation that I had with Mr. Robbie. We agreed that the fee cap would be between 10 and 15 hours. We had a long-standing relationship with Global. We had a number of cases with Global. We had no letters of engagement with Global. We had a practice. And as a result of that practice, which we applied to many other cases, some of the other cases we had fee caps, but we were always billed on an hourly basis up to that fee cap. With respect to this case, the fee cap was between 10 and 15 hours. And Mr. Robbie can confirm that.
Mr. Beckley, what we do have is a letter of engagement and I'm asking you to confirm that that letter of engagement makes no reference at all to fees being capped, does it?
No, because we didn't, and we did not sign that. The fee cap was based on an agreement that I had with Mr. Robbie, and we agreed that the fee cap would be between 10 and 15 hours.
And I'm asking you on the face of this letter of engagement, which is deemed accepted by paragraph 15, to confirm that there is no reference at all to a deemed fee cap, is there?
The fee cap was based on a conversation that I had with Mr. Robbie.
All right, let's move forward. Let's go on to the email.
Please, I'm sorry. You seem to have a trouble with delay. We can all read the letter, and I was going to say that the law of diminishing returns is very much in operation, and I trust that you will bear that in mind in other areas in which you cross-examine as well. As I get that you are about to move on to something else.
I'm going to take the witness to D13, please. Would you look at the fourth paragraph beginning with reference to Graziella Gerges's email?
Right.
With reference to Graziella Gerges's email, we agree with the terms of the letter of engagement. And you then say it's not necessary, but you agree those terms, don't you?
Yes.
Thank you. Now, the matter concerned a trademark dispute, which was the subject of a regulatory or administrative process by the Ministry of Economy in both Dubai and Abu Dhabi. Is that correct, Mr. Beckley?
Yes, that's right, with the Trademarks Department of the UAE.
Yeah. And Miss Gerges gave evidence this morning. You probably weren't able to hear it, but it's been she's been cross-examined on this in relation to the process that needs to be undertaken when you're dealing with a matter involving the Ministry of Economy. And she says that the Ministry of Economy does not provide any notification of hearing or status update. It is the responsibility of the party to make its own inquiries of the ministry. Is that within your knowledge, Mr. Beckley?
I believe that may be true.
Thank you. And therefore, in order to keep abreast of substantive developments, the onus, the burden, the responsibility is on the party or the party's legal representatives to inform themselves appropriately of the progress of the case. That must follow, mustn't it?
Yes.
And there is a further particular aspect in that I think if you are going to challenge a decision of the ministry, you have to do it within a very short period of time, namely 15 days. Is that within your knowledge?
No, I'm not aware of the specifics. That very well may be, but I am not aware of them.
I think you simply don't know. You're not in a position to contradict me, but you're not in a position to confirm either.
That's correct.
But if I'm right, then regular contact with the Ministry of Economy would be absolutely essential, wouldn't it?
Yeah, I believe that it would be. I don't know whether it would have to be on a daily or weekly basis, but I believe that some routine contact would be required.
But Mr. Beckley, it wouldn't be routine contact, it would be regular contact to update about the substantive progress of the case, wouldn't it?
No, it would be routine. It would be a routine contact with the administration of the Trademarks Department.
Well, that's
not legal. It's not a legal matter. It's a routine administrative matter.
Mr. Beckley, if this step was not taken regularly, then the legal representative would be unaware of the progress, the client would be unaware of the progress, and a short time period may well go by. That's the effect of what we've just been discussing, isn't it, Mr. Beckley?
Certainly.
And therefore, what I would put to you is that whilst it may be routine, whilst it may be regular, it was essential.
Yes, I believe it would be absolutely necessary.
Yeah, and that therefore that sort of contact is plainly within the scope of the work in paragraph 2 of the
No,
letter
it
of
isn't, because as you will recall, in my email, I specifically said that we were not going to pay for these routine matters.
And what I'm putting to you is that regular contact was essential. That takes it out of the routine.
I think you're incorrect.
Maybe a matter for the court. And what I would suggest to you and put to you is that the claimant, in order to represent TIG properly, was under an obligation to maintain that regular contact. And I think from what you've said, there's common ground between us that that's the case.
I agree with you. Those routine contacts were probably required in order for them to perform their obligations to us.
So let's now look at the invoices to which you take exception. And if we look at page C33 to 34, this is your third witness statement, and under paragraph 8 we have a list of the invoices, and under paragraph 10 we have a list of the overbillings according to you.
Michael, did you say C33?
I said C33.
Okay.
And I'm asking, what we'll do is we'll look at C33 and 34, which identifies the overbillings that you claim, and then we'll relate those to the invoices, which are in section D. Do you have C33?
Yes, I do.
So the first invoice is invoice 17418, and you take exception to 330 dirham. And if we go to D8, we will find invoice 17418.
Mm-hmm.
There's only one item there for Ms. Gerges, and that's the first item. She was assisting Mr. Rabi, as you are well aware and as we've seen from the letter of engagement. Are you seriously suggesting that her attendance at the initial meeting should not be billable hours?
Absolutely not billable.
Why?
Mr. Rabi was there. She was there as a note taker. We don't pay for secretarial services.
No, she was a paralegal and she was assisting him.
I put it to you that she was not providing legal advice.
Let's look at the back at what the letter of engagement says. Bottom of page D10, Mr. Rabi, Senior Legal Counsel from our Civil and Commercial Litigation Department, will carry out most of the work on this matter assisted by Ms. Graziella Gerges, who is his legal assistant in the CCL department, and other lawyers and support staff, as may be required from time to time. She was his legal assistant, wasn't she?
That was her title.
Well, that's what she was doing. She was a paralegal. She wasn't simply performing an administrative function, was she?
As I recall, she was a note taker.
We differ in that regard, but let's go on to look at the next invoice, where you challenge 6,916 odd dirham, and that invoice is at pages 19 to 21 of Bundle D. Now, the full invoice is 29,720. The work undertaken by Ms. Gerges is identified by the abbreviation PA down the right-hand column. And I have been unable to identify that which is disputed, namely the 6,916 dirham. Can you help me with which sums you dispute and which sums you do not dispute in this invoice?
Where was the invoice? D?
D19 to 21.
Yes, I'd have to do a thorough analysis, but it was certainly related to the PA lawyer reference.
Well, we know that because all of the other references are RF, so it's Mr. Rabi, and you're not challenging his fees. But if we look at the end of this invoice, we can see that the paralegal, Ms. Gerges, carried out 10.25 hours, for which the charge-out rate was just over 10,000 dirham.
Right.
We know you're challenging just under 7,000 dirham. What I'd like to know is which elements you are challenging, Mr. Beckley.
Routine matters.
Well, tell me, go through and tell me which of the PA items you challenge and which you accept.
We would reject the contacts with the Ministry of the routine contacts with the Ministry of Economy.
Why would you reject that? Let's take the first entry.
Because we said in our email that we were not going to pay for these routine contacts.
Let's go back
That's why we rejected it.
Let's go back to page D19. First entry for Ms. Gerges, she visited the Ministry of Economy to submit an official search. That is a substantive step, isn't it?
I said the routine contacts with the ministry.
So that's okay, is it?
If it's a legal related matter, yes. If it's a routine contact with the ministry, it was rejected on the basis of our email.
Second entry, phone call in relation to a power of attorney in order to file a reply. A substantive step, wasn't it?
Yes.
Next entry, again talking about the power of attorney in order to file the reply. The same answer, the same point and the same answer, Mr. Beckley.
Which item are you on now?
Preparing and sending an update email in reference to our phone call conversation regarding the power of attorney in order to file our reply. Substantive step.
Yes.
Then the next entry is follow-up at the Ministry of Economy and obtaining certificates. Again, formal step, isn't it?
No, it's a routine matter. Follow up with the Ministry of Economy and obtaining certificates.
Well, I thought you might say that. Let's look at the next entry, which is for Mr. Raby, an entry which you don't challenge, where Mr. Raby reviewed the new provided search from the Ministry of Economy. How could Mr. Raby have done that work which you don't challenge without Miss Gerges doing the work which you apparently do challenge?
You mean, how could he do it?
Yes, because he was relying on her work, including the follow-up and obtaining certificates, wasn't he?
Yes.
So therefore, if in order to do his work, which you accept, the certificates had to be obtained and were obtained by Miss Gerges, that cannot be classified as routine, unchargeable work, can it?
Certainly Robbie's review of those certificates is billable.
And so is Miss Gerges's. It's of a
For
piece,
doing a
isn't it?
routine matter like obtaining a certificate? I don't think so.
Well, let's read on what Mr. Raby did. He searched through the internet on the use of the trademark. Miss Gerges, at the foot of the page, says that she was reviewing a document and doing a search on the website for the two trademark logos of the opponent to check their validity. That work was of a piece and exactly the same nature that you accept was properly chargeable by Mr. Raby. What I put to you is if it's chargeable by him, it's chargeable by her.
I think that's ridiculous. Of course, he had to rely on an assistant to provide the certificates, but the legal work was the review of the certificates.
And what I put to you is that he could only do that because of the work that Miss Gerges undertook. Let's go on to page 20. Miss Gerges reviewed the reply amended against the opponent, preparing and signing the dockets for Mr. Hassan in order to be submitted on Sunday before the Ministry of Economy. That's not a mundane task, is it, Mr. Beckley?
I'm not certain what it involves. I can't make a determination of whether it's routine or not.
And then the next entry for Ms. Gerges, preparing the documents to file the reply before the Ministry of Economy. The documents had to be put in proper order for filing, didn't they?
Yeah, a routine secretarial task.
We disagree. Let's go on to the next one. Sending an email to Atlas in order to translate the trademark logo before filing the case. Is that mundane, routine?
Well, absolutely.
If you look on the page D25.
The translator? A communication with the translator? Really?
Could you look on to page D25, Mr. Beckley?
I'm at D25.
That is invoice 17694 in relation to legal translation. And if we look onto page D26, it's in relation to an invoice from Atlas.
That's correct.
That's not an invoice that you challenge.
No, we do not challenge.
How could a legal translator do the work if the material to be translated is not sent to them?
I don't think they could.
And that is precisely what Miss Gerges was doing, as we see when we look back at page D20.
Yes.
So it wasn't mundane, it was absolutely necessary, wasn't it?
It's the most mundane thing I can think of, sending a document to a translator.
It is integral to the case and representation of the industrial group, isn't it, Mr. Beckley?
No, it is not. It is a routine administrative matter.
How was the translator to get the document for translation unless it was sent to them?
Come on, please be reasonable.
I am being reasonable. I'm asking you how a translator could do work which you accept was billable and chargeable if the document in question is not originally sent to them.
Well, of course they couldn't do it.
Thank
But
you.
what we're talking about is the transmission of the document.
Well, let's read on. The court.
That's legal work other than a routine administrative matter just doesn't make sense.
So when Ms. Gerges visits to submit the reply memo and she obtains a date receipt for the memo, and given the importance of timing in this matter,
A routine administrative
that
matter.
is mundane.
A mundane, routine administrative matter. We agreed in our email that we would not pay for these routine matters.
Well, we disagree that this is routine or mundane. Regularity was necessary, and this is substantive steps. Let's just look at the next entry, which is an entry for Mr. Rabi, following up with Graziella on submitting the memo to the Ministry of Economy. So his follow-up is fine and billable, but the fact that he's following up with his legal assistant is not billable as far as she's concerned. Is that right, Mr. Beckley?
Come again, I didn't understand the question.
Yes, you accept that the entry for Mr. Rabi, following up with Graziella on submitting the memo to the Ministry of Economy, is properly chargeable?
Yes.
He could only follow, we know that he followed up with Graziella, and yet you are challenging her billable hours.
Definitely, because she did the routine task. He was ensuring that it was done properly.
All that we know is he was following up on submitting the memo, and we've seen what she was actually doing, attending, getting date stamps, etc.
Yeah, routine administrative matters.
Well, we differ. Then we've got the visit to the ministry for checking the meeting schedule, a phone call for checking again on the schedule of a meeting between both parties, and then finally sending an email attaching the power of attorney from the client in order to send all scheduled meetings to the representative in this matter. And she then finally visits the Ministry of Economy for the matter at the top of page 21. How was TIG's interest supposed to be represented if Miss Graziella Gerges had not done all of that which is set out in this invoice?
As we said in our email, we were not going to be paying for routine matters. This was a routine administrative matter.
And having gone through in some detail this invoice, I won't do the same with all of them, but having gone through in some detail with this invoice, are you in any better position to identify the 6,916.67 dirhams which you dispute?
Yes, the routine administrative matters that were charged by Ms. Gerges.
And what are the ingredients, what are the components of the total 6,916.67?
Routine administrative contacts with the Trademarks Department.
Would you like to point them out so that we can do the sum and get to 6,916.67?
Well, just go through the invoice and just segregate those hours.
I've tried to do that, Mr. Beckley. I've not been able to do it, and I'm asking for your help.
Okay, well, that's going to take some time.
Mr. Beckley,
at some
you put this in your witness statement. Did you not do it for the purposes of the witness statement?
Yes.
Well, why are you not able to do it now?
Because I don't have the backup materials that I utilized to do that analysis.
So we can't take that any further. Mr. Beckley, let's move on to the next invoice, which is 17929, page D27.
D27?
D27.
Okay, my comment D27.
Thank you. We know from page C33 that you challenged 750 dirham in relation to this bill. There's one item for 1,000 and the rest adds up to 750. So I assume that the alleged overbilling is the first 4 items on this page.
Yes, I believe so.
Let's have a look at them. She phones someone in Hayam, who is the Abu Dhabi branch, regarding the case. Global have an Abu Dhabi branch, don't they? And the Ministry of Economy operates both out of Abu Dhabi and Dubai, doesn't it?
What was your question again, please?
Yes. Are you aware that Global Advocacy has an Abu Dhabi branch?
Yes, I believe they do.
And are you aware that the Ministry of Economy, particularly for relevant purposes, the Trademarks Department, has an office in both Abu Dhabi and in Dubai?
Yes, I believe that's correct. I know that's correct.
So given that Ms. Gerges is based in Dubai, for Abu Dhabi matters, it makes sense for someone local to Abu Dhabi to deal with it, doesn't it? It would save costs and time.
Yes.
In relation to the power of attorney, we have an internal phone call in the first item, preparing and sending a detailed email to the MOE, the Ministry of Economy, with the power of attorney, phoning the Abu Dhabi team in order to update about the Ministry of Economy, and sending email attaching the required documents to Abu Dhabi.
Yes.
So what she did was she made arrangements. She sent the documents by electronic means rather than going down Sheikh Zayed Road, thereby saving time and costs with regard to a necessary step. That's what...
Yeah, a routine administrative matter that we specifically told them we would not pay for.
And Mr. Rabi is in Dubai as well, isn't he?
Yes, I believe he was.
How was this going to be done as time efficiently and as cost efficiently by any other means, Mr. Beckley?
I think it was done by the most efficient means, but it was a routine administrative matter that we said that we were not going to pay for.
If you need to file a power of attorney, which you frequently do in a UAE circumstances, that is a necessary, essential step in the action, isn't it?
Yes, a routine administrative matter.
We disagree on it being routine. Let's try and go a little bit more quickly. Invoice 18212, you challenged 2,916 dirham.
Which page was that, Michael?
Sorry, D29.
Okay, I have D29.
You challenged 2,900 dirham. There is an item for 1,000 dirham, which is following up with the MOE. I take it that the other items, all the other items, are challenged.
Yeah, we would have challenged anything that was routine administrative matter. And those contacts with the Ministry of Economy were, in our opinion, routine.
You've heard me put points in relation to follow-up matters and in relation to emails, and we can read the matters that you challenge, quite a lot of them involving following up. Why do you make an exception for the 1,000 dirham on January the 31st?
I don't know, perhaps we should have excluded that as well.
It's inconsistent, Mr. Beckley, isn't it?
Yeah, as I say, I don't have my backup materials with me. Probably we should have excluded that as well.
Well, again, you must have given some thought to it for the purpose of the document at page C33, mustn't you?
You said C33?
Yes, C33 is the source of the overbillings being stated to be 2,916 against an invoice amount of 3,916.
Okay.
Now, surely this jogs your mind as to why you made a differentiation between all the other items and apparently this one item.
No, I don't. As I say, I don't have my backup. I mean, I'm at home. I don't have any backup materials. I used to do that analysis.
So you can't shed any light on that?
No, I'm afraid not. Perhaps it was a mistake. Perhaps we should have taken out the 1,000 as well.
Well, what I would put to you is none of this is mundane or routine.
Well, that's because you have a different definition of what a mundane, routine administrative matter is.
And then let's go on to 18380, where you dispute the whole of the invoice. This is at page
I'm
D31.
sorry, Michael, which page?
D31.
Mr. Patchett, Joyce, I don't expect we'll be going through everyone. The issue is joined, one might say, fairly thoroughly.
Yes, that's why I went through one invoice very thoroughly.
If you have a particular, please do it, but otherwise I'm not too sure that it's terribly useful.
I'm obliged, Your Honour. Let me just, in that case, maybe we can go through the invoices together, Mr. Beckley, and if there's anything arising beyond the matters that I've already put to you in relation to earlier invoices, only those will I raise. So the next invoice is, as I say, D31 to D32. There's nothing that I wish to ask you about that. Then we can go on to D35, which is invoice 18779. And in relation to 18779, there is an alleged overbilling of 3,132 against an invoice amount of 4,166, meaning that you accept a sum of 1,034 dirham on the face of this invoice.
Yes.
Could you point me to where I find support for the sum of 1,034 dirham as being an item arising on the face of this invoice?
Yeah, based on the analysis that we did at that time, obviously we felt that some of it was justifiable.
Well, Mr. Beckley, there is no entry which alone is in the sum of 1,034 dirham and 30 fils. And there is no combination of entry in the sum of 1,034.30 fils. So on the face of this, it's completely impossible, is it not, to say what you say was overbilled and what you say was accepted?
Well, on the face of it, of course not, but we did an analysis to come up with the amount that we thought was legitimately owed to them.
I see. Well, let's go on to D39 to 40, which is the next invoice which you challenge. I don't think there's anything that I need to raise in relation to that. We've covered similar matters previously. Then the next invoice is at D41 to D42. Again, very similar entries to those that we've already previously explored. Then we can go on to D45 to 46. A series of follow-ups again, so we don't need to detain time in that regard. D47 and 48, a series of follow-ups again, which we say was absolutely essential. D49 to 50, again, there's nothing particular arising from the face of that which we haven't already covered. And D51 to 52, where again matters of review and visit and sending emails to update you are the matters which you seek to challenge. Mr. Beckley, what I would suggest and put to you, and it may be that it's just a difference in wording, it's what you believe is mundane and what I regard as mundane by reference to these timesheets. I would put to you comprehensively and compendiously that there was nothing mundane about what Miss Gerges was undertaking on each and every one of those invoices. Do you agree?
Absolutely not. As you know from my email, we said we were not going to pay for routine matters.
Let's move on to the El Fadl matter. And the El Fadl matter is dealt with in your second and fourth witness statements. Sorry. Yes, I think we can deal with El Fadl relatively shortly. Mr. El Fadl's employment was terminated on the 29th of, his employment came to an end on the 29th of April 2018. I think that's common ground, Mr. Beckley.
Yeah, I believe so.
And you had substantial concerns, which we don't need to go into in detail for present purposes. You had substantial concerns about whether Mr. El Fadl was being a good employee. Is that correct?
Yeah, that was the reason for the termination.
I think actually he terminated rather than you terminating, but it doesn't matter. As of the 29th of April, there was a parting of the ways, wasn't there?
Yeah, there was a parting of the ways, and then subsequently we were formally terminated for cause.
Well, you approached Mr. Al-Hashimi for advice, and he said that he would need to refer the matter internally in order to provide you with comprehensive advice, didn't he?
No.
What did he say?
He basically said that there was no obligation on our part to pay anything to Mr. El Fadl, but it was subsequently followed up with an email from Sharon.
Sorry, just find the appropriate passage. Mr. Al-Hashimi was the managing partner of Global, wasn't he? He still is.
Yes. Yes.
Ms. Lacken has specialist knowledge of the DIFC, and
That's
she
right.
is, so when you approached Mr. Al-Hashimi with regard to a matter pertaining to the DIFC employment law, it would be reasonable for him to refer that question to someone who is an expert in that field, wouldn't it?
I think Ali's an expert in that field. I believe I'm not exactly certain, but I believe he was on a legislative committee with respect to DIFC law. I mean, we considered Ali to be an expert in DIFC law in addition to Sharon.
Well, whatever his position, what I would suggest to you is that he said in terms that he would consider the matter internally and revert.
That's not what I recall, but it was followed up by an email that we received from Sharon.
Yes, so we can see that email at pages E2 and E3.
Yes.
Let's look at E2 and the advice that you received from Ms. Lacken on the 30th of April. So I think the day following any conversation with Mr. Al-Hashimi.
No, I don't believe I had a conversation with Ali following that.
No, so there was a conversation with Ali and then you received the email from Sharon.
Yeah, that's what I recall, yes.
Yeah. Sorry if I didn't express it clearly. That was certainly what I was intending to put to you. It's common ground. So let's see what Ms. Lacken says. Dear William, there are some risks to be factored in before deciding whether or not you make payment of Mr. El-Fadl's April salary or not. Of course, if you make the payment to him and then it turns out that the company has a monetary claim against him, he will not have the opportunity to set off the amount of his April salary against that monetary claim. However, as you know, the DIFC employment law imposes an obligation on the employer to pay all wages at least monthly and within 7 days after the end of the pay period. If you do not do so, then you are risking being found to be in breach of Article 17 of the employment law, and Mr. El-Fadl would almost certainly bring a claim seeking payment of that amount. Given that to date we have not terminated his employment, it would be difficult to explain to the court what the legal basis is for not paying him his April salary. It would be difficult to defend any claim for payment of this amount, particularly as we are not able to quantify a monetary claim at this time. It's quite clear and categoric advice, isn't it, Mr. Beckley?
Yes, it is.
And then it goes on, additionally, pursuant to Article 18 of the employment law, once his employment is terminated, you will have only 14 days in which to make payment to him of all outstanding dues, failing which penalties accruing on a daily basis equivalent to the last daily wage for each day you are in arrears. Given the amount of Mr. El-Fadl's monthly salary, penalties could end up being significant. If we terminate for cause pursuant to Article 59A of the employment law, then assuming that the court finds that a reasonable employer would have terminated in the same scenario, Mr. El-Fadl will not be entitled to claim his gratuity. It seems to us that the most important issue to focus on is to preclude Mr. El-Fadl from being entitled to claim a gratuity payment. To that end, we need to make sure that our termination for cause is as strong as possible. In particular, that we terminate for cause promptly. By paying his April salary, we will also appear reasonable in front of the court. So again, it was clear you should pay his April salary, wasn't it?
Yes, it was. And then I followed that up with my email, which is at E5.
Yeah.
Asking some specific questions related to Sharon's email. but I never received a reply to those questions.
Well, Mr. Beckley, those questions had been forestalled by clear, categoric advice, which we've just been looking at. And what you say in E5, my main concern is, as you state, that if we make the payment to him, and then it turns out the group has a monetary claim against him, the group will not have the opportunity to set off the amount of his April salary against that monetary claim. So that's the point you received. The point you'd received advice on, and were told in particular that there was concern given we are not able to quantify a monetary claim at this time.
What's your point? What's your point?
Fair point, thank you.
What's your point?
What is my point? My point is that your email had already been answered.
Incorrect. If it had been answered, then why would I have posed those questions?
Because you didn't like the answer that you received first time might be an answer to that.
I don't think so. Go and look at my questions in my email on E5. They are not addressed in Sharon's email, and Sharon didn't address them.
There is another point which needs to be put into the mix, isn't there? Can we look at page C37?
Michael, I'm at C37.
Thank you. And we're picking this up at paragraph 11. You say there, and you've just said it again, neither Ms. Lacken nor Mr. Al-Hashimi, who was copied into the email, replied to your concerns and inquiries you had addressed in that email. I don't think you were present when Ms. Lacken was asked about this, and she said, I did not respond in writing. There were verbal discussions about this exact issue.
I do not recall any verbal discussions responding to my queries.
Are you in a position to say that what Ms. Lacken was saying was wrong, or just that you don't recall?
I don't recall.
Thank you. And in any event, if we go back to paragraph 11, what you say is this raised concerns about the claimant's ability to handle the matter and the accuracy of any advice provided by it. We differ in relation to that, but we know the ambit of the difference. You then go on, which resulted in the claimant being replaced by another legal representative for the Abdelazim El Fadl matter.
Yes.
So the position is that you were concerned on the basis that you've described, whether correctly or not, and on the basis of those concerns, the file was moved to another legal representative, wasn't it?
That's right.
And we know that Mr. El Fadl terminated his employment on the 28th or 29th of April, and indeed it may not have been accepted till the 30th of April, but the 14 days for payment under the DIFC employment law extended through till the middle of May, didn't it?
I can't speak to that. I'm not certain. I haven't.
Well, as a matter of law, 14 days from termination of employment would be a fortnight from at the earliest, the 28th of April, wouldn't it?
Yeah, I believe you're correct.
So therefore, given that you replaced Global with another legal representative, you must have been in a position to take full advice from that other legal representative, mustn't you, Mr. Beckley?
Yes.
Thank you. Let's move on to Dexter. And here, the issue is that costs incurred by Niam Hall, and I don't think there's any lack of clarity. She married and her married name is Wilkie. So there are various references in the papers to Niam Hall and Niam Wilkie. It's the same person, just to clear that up. But the issue is costs incurred under invoice 19736, and we can make that good as a starting point just by looking at the same witness statement, the fourth witness statement at C38.
Which paragraph, Michael?
22.
Yes.
So you say, more particularly, the costs incurred by Ms. Nemhor under invoice 19732, dated the 31st of July 2018, were excessive. Now, let's just paint a little bit of background in relation to this matter. Mr. Dexter was, or the action was, the subject of a pre-action application for disclosure, I think.
Yes, that's correct.
And that application was successful, as I understand it.
Yeah, but basically we received an order for him to produce.
So in essence, you've got what you bargained for. You got what you wanted.
Yes.
And I think you mentioned that Miss Hoare had done an excellent job.
Yes, she certainly did, until we got our bill and realized that the bill was excessive.
And Mr. Dexter proved elusive, didn't he?
Yes, he was. Uncooperative, I think, is the more appropriate.
Oh, okay. Yes. Yes, he didn't cooperate. Let's agree on that word. And I think that if we start, we can see the protracted nature of the time scale, because we can start the document trail at pages F1 and F2, can't we?
Okay, Michael, I'm at F1.
Thank you. And this is in relation to the matter we're talking about, Dexter. And we can see the date of this, February the 12th, 2017.
Right.
And then it's a point that Ms. Lacken was asked about over on page F2. The costs were set out. An application fee and a then estimate of or then indication of legal professional fees.
Right.
But we can gather some indication of the difficult nature of the matter, because this document was dated, as we've seen, February the 12th, 2017, and the invoice to which you take exception was dated July the 31st, 2018.
Correct.
And I think that was the culmination of the application for pre-action disclosure. So that was when it all came together, so far as you and Global were concerned.
That's correct.
Now, we have a copy of that invoice at pages F3 through to F8.
Okay.
And we can see the items that Miss Hoare was engaged upon because her initials appear next to the entries under lawyer.
Correct.
Now, let's just have a look at the entries that she records. Reviewing the case file in contemplation of hearing on the 10th of July, reviewed the witness statements, 1, 2, 3 witness statements in preparation for drafting the skeleton argument to be submitted to court. That's a reasonable step to take, given what was being pursued and the stage that things had reached, wasn't it, Mr. Dexter, Mr. Beckley?
Yeah, insofar as the narrative is concerned, I think all of the steps were required. The issue that we have is the excessive hours that are billed for those items.
But it takes the time that it takes in order to do the job, and do the job as you described excellently, and to achieve the success that was obtained.
Well, surely you can't seriously be saying that when they give a fee quote of between 20 and 30, that this billing is anyway reasonable.
What I'm putting to you, Mr. Beckley, is that the indication provided in February 2017 must have been known to you as well as to Global, that this was anything other than a straightforward application. It must have been apparent to you, yeah. And therefore, when we look at the bill which is raised, we have to view this bill through the eyes and knowledge of July 2018, the best part of a year and a half having elapsed since the document at F1 and F2. We have to do that, don't we?
Sure.
Now, let's approach it another way. You say that of Miss Hoare's hours, which amount to chargeable time in the sum of 74,300, you say there was 30,000 overcharging.
Agreed.
How do you calculate that 30,000 by reference to this detailed invoice that we have at F3 to F8?
Well, as I told you, I don't have my analysis with me, but we did an analysis and came up with that number. But what that number doesn't take into consideration is that the previous email indicated that the total fees would be between 20 and 30. To arrive at this amount for that matter, I mean, I think you'd have to agree is absolutely ridiculous.
Well, Mr. Beckley, we've dealt with that point because we've looked at the fact that 18 months have flowed by between February 2017 and July 2018. And you agreed with me that we had to look at this invoice through the eyes and with the knowledge that people had in the 31st of July 2018, and it was a very different matter from that which had originally been contemplated 18 months previously. You've agreed with that?
No, I don't. I disagree with that. Essentially, the scope of work was identical.
Well, in that case, it should be very easy, by reference to this document, to identify which are the component parts of the 30,000 dirham that you say was overcharged.
Well, based on the analysis we did, we came up with that number, but then we have to take into consideration the email which says the fees would be between 20 and 30,000. To suddenly arrive at this excessive number is just absolutely incomprehensible.
This
I mean, talk about bill padding. I mean, really.
Mr. Beckley, this analysis that you keep referring to is nowhere in evidence, is it?
No, it was done by me when I put together my witness statement.
And you put together your witness statement in relation to Mr. Dexter on the 1st of July this year.
No, I had previous witness statements.
You had previous witness statements, and we've looked at, or we will look at all of them in due course. C27, your first witness statement, is in relation to the Abu Zaid matter.
When I did my analysis, it became very evident that there was excessive overbilling by Neem Hor.
Well, Mr. Beckley, we'll get there in due course.
And when you take the email into context, where there was a 20 to 30,000 dirham quote, this looks even more ridiculous.
Mr. Beckley, we'll get there, but let's just go through your previous witness statement. C27, please.
Which witness statement is that, Michael?
Well, that's your first witness statement. There were 4 of them, and we're going to just look at each of the 4.
Okay, I have it.
So if we look at C27 through to C29, that is your first witness statement, November last year, but it pertains to Abu Zaid, doesn't it?
Yes.
Second witness statement, C30 to C31, again the 18th of November 2019, that pertains to Mr. El Fadil.
Correct.
Third witness statement, again the 18th of November 2019, and that relates to the Al-Banawi trademarks matter, doesn't it?
Yes.
None of those witness statements concern Dexter, do they?
I'm not talking about the witness statements per se. I'm talking about the work that I did in preparation for those witness statements, which included my analysis of all the billings.
Well, Mr. Beckley, you weren't asked to do any analysis in relation to Dexter, apparently until the 1st of July, until preparation for your witness statement on the 1st.
No, my analysis included all of the cases.
Well, where is it? If it's so important, where is it?
I don't know where it is at this time. I resigned my employment in November.
Yes, indeed, you resigned your employment in November.
And I didn't carry files with me.
But the witness statement in relation to in relation to the Dexter matter is the first.
Actually, you don't need my analysis with respect to that matter. All you have to do is look at the numbers, especially in relationship to the email which was sent by Sharon, and you'll be able to easily come to the conclusion that there was excessive overbilling with respect to this matter.
Mr. Beckley, we do need
You can do your own analysis. Just look at the hours. It's ridiculous.
Mr. Beckley, we do need your analysis because it is in this witness statement dated the 1st of July that you depose in paragraph 22 to more particularly the costs incurred by Ms. Hoare under invoice 19736 dated the 31st of July 2018 were excessive.
Precisely.
You must have had recourse to your analysis in order to calculate 30,000 dirham.
With respect to this matter, my witness statement was based on an analysis of this bill.
But you have already told us that you retired in November last year, and you didn't retain your papers.
That's
so
right.
On that basis, were you saying on the 1st of July that Miss Hoare had inflated the billings by the precise figure of AED 30,000?
That was based on my previous analysis, and if you look at the email in which there was a fee quote of between 20 and 30,000 dirhams, it becomes readily evident that this billing is excessive.
Did you just pluck this figure out of the air, Mr. Beckley? I'm sorry, I have to put it to you that bluntly.
No, it was based on an analysis that I previously did. I went through every single item.
So you were relying on memory of something...
Precisely, exactly.
Well, wait a minute, Mr. Beckley. You were relying on memory of something which, even if you did it on the last day of your employment, had been undertaken at least 8 months previously.
Correct.
So again, I ask, and I should actually put to you the source of this, which is again, I put to you, how could you challenge effectively an invoice 19736,
which
in
page
a
number?
In a particular sum, and without recourse to documents which were not in your possession any longer and hadn't been in your possession for months? How could you do it?
Just by examining the bill. I mean, the bill is excessive.
We don't have this analysis, and you are unable, even though this witness statement was the 1st of July 2020, so a matter of 6 weeks ago, you're unable to shed any light on how you estimate the excess that you say was to be found in this invoice.
Not only that, but based on the email in which the fee quote was between 20 and 30,000, it becomes readily apparent that this billing is absolutely excessive insofar as the hours of Ms. Hoare are concerned.
Well, I don't think we're going to be able to take that much further in that regard. Let me just, if I may.
Mr. Patchett, Joyce, may I intervene at this point?
Yes, Your Honour.
It's a matter for you, but I'm curious about one thing. According to paragraph 22, the invoice is totaling 157,000 dirham. Invoice 19736 is for an amount of 116,000 dirham, which means that another 80,000 or thereabouts dirham must have been invoiced. From invoice 19736, it's apparent that quite a deal of work had been done at some time prior to July 2018, because the proceedings must have been commenced, witness statements must have been prepared. When was there the invoicing for the other 80,000 odd? Because I don't think the invoices are in the bundle. Were they paid?
I can help with that. The short answer is no, but I can establish that as follows. Mr. Beckley, could we just look at tax invoice at F3, the invoice in question, which is number 19736?
Yes.
And we can see that the file number is DIFC 0.02.2017, can't we?
Right.
And the way that the claim has been put together is to identify what you say is in dispute and take that from the unpaid invoices and focus on the matters in dispute. That's how we've approached this case, isn't it, Mr. Beckley?
Yes, I believe so.
And we can see that there were previous billings in relation to DIFC 0.02.2017. If we go back to A12, which is an interest calculation for and in respect of the unpaid invoices. Do you have page? Oh, maybe I'm going too fast.
Michael, you said A12?
I did. It's a continuation of a document which begins at A7.
Yes, I'm at A12.
And this is the interest calculation for unpaid invoices. And we can see, I don't invite us to look at them in detail, we can see the earlier invoices, which His Honour was asking about, as really the second block of invoices under matter number. You can see that the first 10 or so are COR blank 031.2016, yes?
Yes.
And then the outstanding invoices in relation to DIFC 02.2017, which we have already established is the Dexter file, are set out at sundry dates from April 2017 and following.
Yes.
Or no, sorry, it's an American version of dating. It's November 2017 and running through to the end of 2018. So we do have details of other invoices which are unpaid in relation to the Dexter matter. Does that help, Your Honour? And we haven't put those invoices in because there was no issue that they hadn't been paid. The question has been focusing on those which where there's a challenge.
Just give me a moment, if you would.
Can you excuse me? I'm just going to take a short break. I'll return in a couple of minutes.
Yes, certainly.
Would it be sensible to have 5 minutes for that purpose?
Well, just let me just check something in case I need to take it up with you, which could be done in the absence of witness. You are reading paragraph 22 as confining the objection to the costs in invoice 19736.
Yes, and I can make that good if I take the court back to the particulars of claim. Begins, as you know, at A7. And if one looks at A8, you have paragraph 10 towards the foot of that page.
Yes.
And you'll see there that there's reference to a response on behalf of the defendant to the claimant's letter before action. The response is the 7th of July 2019. And that response is in the bundle. And the summary of the response is then set out. Bradley Dexter matter, the disputed invoice number 19736, issued on the 31st of July 2018. Then the defendant says that only the hours spent by Ms. Hoy in relation to that invoice were excessive, does not elaborate as to why the time spent was not reasonable and necessary, nor why it took 12 months before highlighting their concerns. And then going on at paragraph 10.1.2, again, following on from the response, the defendant disputes AED 30,000 worth of the time spent by Ms. Hoare. The first time the defendant raised any concerns in relation to the fees invoice on the Bradley Dexter matter was in the response.
And now, if I go to the defence and cross-claim, what does it say about paragraph 10?
It's page 24, A24, paragraph 10. The letter referred to in paragraph 10 is admitted.
Yes, but if one looks on the previous page, then it is the crossed out 2 and now 5 Bradley Dexter case. Arguably, that was a wider objection, despite what the response to the letter before action had been. I simply raise that for your attention.
Your Honour, I'm happy to go to take this witness to the response, and the response is to be found in H. Give me now, where is the letter?
It's H14.
Ah, thank you very much. Yes, H14, and we have the sum in relation to the Albano on the first page, and then the 30,000 is where are we? Yes, we then find the details set out on page H16.
Yes, well, we can read what it says. This may end up as a matter of submissions. There may, in fact, be no contest.
Yes, I am relying on the defendant's own document in this regard.
Well, I'm not too sure what Mr. Breckley can add to things. As I say, I simply raised it for possible consideration. It's a matter for you.
Well, I think that given the source of the 30,000 which has been put, as I'm relying on the defendant's own documentation, and we know of an analysis which apparently was undertaken but which has not seen its way into the bundle, that I can't really go beyond what the defendant themselves say about their case.
Very well. Now, I've just had a message saying that we do need to take a 5-minute break for recording purposes. I'm not too sure what that means, but that's what I'm told. Is this a convenient time to take 5 minutes?
Yes, it would be a convenient time indeed.
Yes. Well, we'll turn off the sound and vision as before and resume in 5 minutes.
I'm obliged, Your Honour.
I think we have lost Mr. Kanan, at least on vision. Mr. Kanan, are you there to hear us still?
Yes, Your Honour.
Okay, we've lost your vision. Oh, there you are. You're back. Thank you. Mr. Patrick, how much longer do you expect to be?
Not that much longer. I've dealt with, as you're aware, Your Honour, Albanowi and Al-Fadl. I'm coming to the end of Dexter. Mr. Beckley's involvement in Abu Zaid is relatively limited, and there are one or two further points that I need to deal with, but I'm hoping to deal with it in, say, no more than half an hour maximum.
That's fine. Thank you. All right. Are we ready to continue? No objections? Yes, thank you. Please continue, Mr. Patrick.
Thank you, Your Honour. We were looking at the run of invoices set out in the interest calculation in relation to Dexter, which we've identified on A12 as being those identified as DIFC 022017. Do you recall that just before the short adjournment, Mr. Beckley?
Yes.
Miss Lachen was asked in cross-examination about the fee estimate at F2 and was asked whether she had informed you or anyone else at TIG that the fee was being exceeded, to which her answer was that she cannot recall whether she did or didn't, but that the matter was being invoiced on a monthly basis, so TIG would have known. Now, if we look back at A12, we can see that so far as the file in question is concerned, there was an initial billing on the 4th of November 2017, because it is month, day, year. Do we see that, Mr. Beckley?
No, I don't. Can you give me some more detail, please?
Yeah, it's a rather dense schedule or table. Let's begin by the first line, which relates to another file, COR.031.2016.
Right.
That's an invoice number 16905. We don't need to look for it because we know the due date. Sorry, the date sent is the next column.
Right.
Which is 10/15/2017.
Correct.
So obviously there are only 12 months in a year, but there are 12 months in a year, but there are 30 or 31 days in a month. So the date 10/15/2017 is intelligible only if it's month, day, year. So an American approach rather than an English approach.
Okay.
And then if we go down the left-hand column, we see COR.031 until we get to DIFC 022017.
Correct.
And that we know is the Dexter file. And we can see that the unpaid invoices in relation to the Dexter file started with an invoice sent on the 5th of October.
Correct.
And then the next invoice was sent on the 13th of December. These are all 2017. Further invoice of the same date. Then an invoice of the 14th of February, 25th of March, 29th of April, 16th of May, 17th of July, 31st of July, 12th of August, 30th of September, 28th of October 2018.
Correct.
So the evidence, and what I'd ask you to confirm is your agreement with the evidence that Ms. Lachen was giving, namely that invoices were being raised on a monthly basis. So you would have seen the sums mounting up on those monthly invoices as we work through.
Correct. They billed on a monthly basis.
Yeah. Thank you very much. Now, yes, while we are looking at, no, let me deal with that later. Yes, let me see. Let me pass very briefly to Abu Zaid, though I may come back to an aspect of Dexter or arising from Dexter. Mr. Beckley, you have provided no specific witness evidence prior to your fourth witness statement. No, sorry. Your first witness statement in relation to Abu Zaid is to be found at C27 to C29.
I'm sorry, Michael, which witness statement was that?
I'm moving from Dexter to Abu Zaid, and
Okay.
your first witness statement of the 18th of November 2019, beginning at C27, relates to Abu Zaid.
Okay, I have the first witness statement.
Yes. Now, the case note, which is set out and referred to at paragraph 5, the case note is to be found at page, the covering email is page G32. If we have G32, that is an email addressed by Miss Wilkie to you in relation to Abu Zaid, and it's a note. You can probably help me with this note more than Mr. Zadlou, but you can see the contents of the note. We can just go through it by way of the headings, I think. The case management conference and the application is set out. Then the merits of the matter are discussed by reference to articles 18 and 19 on G33. Are you with me, Mr.?
Yeah, I have the case note, but I'm looking at a copy of the case note that is not in the index. So if you could direct me to the paragraph title.
Okay. As long as it's unmarked, I'm perfectly happy for you to deal with it in hard copy. We know it's a document you received on the 10th of September 2018, and it arises, as we see in the introductory 3 paragraphs, from a case management conference, and it's important that TIG is fully aware of the potential liability, and that's set out. Then the merits of the claim and articles 18 and 19, matters which I'm sure you're fully familiar with, and indeed the frontline case is referred to on the following page. So we've now covered the first 2 pages, pages G33 and 34. And G35, in the course of setting out the analysis, Global referred to the strict liability approach that the Court of Appeal had adopted in Frontline, and this is the end of the 2nd paragraph on the 3rd page, which is G35. You were told the law appears to be on his, that is Mr. Abu Zaid's side. And that, I think, is something you would accept, Mr. Beckley, is it?
Yeah, I'm sorry again, Michael. Can you direct me to the heading so that I can?
Okay. Well, I was going to go. I'll do it by page numbers rather than anything, but because to go back, and the first page of the document you have in front of you should have 3 headings after the title: case note, merits of the claimant's case, and the DIFC employment law.
Correct.
Then the 2nd page begins quite an extended discussion of the DIFC Court of Appeal and the
Correct.
impact of the frontline judgment.
Correct.
Going over to the third page, continuation of this discussion. In the second paragraph, there is reference to, in the third line of that paragraph, the strict liability approach adopted by the Court of Appeal in Frontline, and a conclusion clearly expressed, namely that the law appears to be on his, that is, Mr. Abu Zaid's side. And we'd reached that point, and I was asking you, not only it's correct in terms of what's written there, it's correct as a matter of legal analysis within your knowledge, isn't it?
Yeah, based on the Frontline case.
Yes. And then there is reference in this in the next paragraph to what was said to be Mr. Abu Zaid's uncooperative approach, and then the fact that there is no written evidence of a proposed or what was said to be an agreement between the between TIG and Mr. Abu Zaid is referred to. Then we go on to the law in relation to deductions, documents, and towards the foot of the fourth page of this case note, there's a heading, Strategy for Defence, yes?
Correct.
And essentially, the strategy for defence was based on what Global had been told by your witnesses, TIG's witnesses, to the effect that there had been an agreement between Mr. Zaghloul and Mr. Abu Zaid in relation to the extension of cover for the extension of cover for medical insurance and non-cancellation of visa and payment of the end of service benefit. That essentially was what was told and which forms part of the strategy for the defence.
Okay.
So are you happy with that summary?
I mean, am I happy with her summary of Frontline?
Well, not only her summary of Frontline, but we've moved on from Frontline to the strategy for defence. Do you have that heading?
Yes, I do, yes.
And that says, in the event TIG wishes to continue defending this claim, it's suggested that we work together over the coming weeks to develop the strategy, and what you were told or what the available information is set out on the documents identified previously.
That's correct.
And then going over the page, obviously there needed to be a basis for differentiating or distinguishing your case, TIG's case, Abu Zaid's case, from the Frontline case.
Correct.
And the strategy involved the intent of the parties.
Correct.
And we don't need to read it, we can read it in the fullness of time. There are elements which are then identified as matters to be followed through.
Correct.
And then the basis for differentiation was made clear on the page we've just been looking at with the intent of the parties. The next page continues with further documentation. Then at the foot of that page we're just looking at other matters for consideration. And then we go on to page G39 in the bundle, the last page of the note. And we have the conclusion, don't we, Mr. Beckley?
That's correct.
And the conclusion is, in view of the potential value of claimant's case against TIG, and in view of the unfavourable position taken most recently by the Court of Appeal in relation to paying end-of-service benefit on time, we would strongly advise TIG to consider how it will proceed with this case. While we believe that we have a reasonable chance of defending the deduction of the cost of the health insurance from the claimant's EOSB, end-of-service benefit, this is only part of the claim, also the least valuable. The court may determine that TIG were correct in deducting this amount. However, this does not of itself relieve TIG from paying the claimant the remainder of his benefits within 14 days of the termination of his employment. This latter part of the claim poses far more risk in terms of financial value and in the light of the Court of Appeal's recent decisions on the matter. There are arguments we can make, and if the court takes a less strict approach than it has previously and looks at the intent of the parties, we could be successful in defending this case. Now, it was a central element to the less strict approach that there was said to have been an agreement between Mr. Zaghloul and Mr. Abu Zaid in relation to the extension or the continuation of his medical insurance and visa in exchange for a delay in relation to the EOSB. Is that within your knowledge, Mr. Beckley?
I believe that's correct.
And the problem with what happened on the 18th of February, is disclosed in the email which Miss Lacan sent to you, dated, bearing that date, and to be found at G97 and 98. Do you have that document?
Yes, I'm scrolling down right now.
Yeah.
Michael, you said G, what number was it?
97 and 98.
Michael, I have G97.
Thank you so much. Now, again, we're going to have to look at this in a little bit of detail, but I hope we can go through it relatively quickly. As you know, we've been preparing for the Abu Zaid case. I spent a number of hours this morning with Mr. Zaghloul going over the court procedure and his witness statement. Mr. Beckley, I think it's right that you were there and attended in the morning, didn't you?
Yes, I attended at their offices, but I was asked to leave the interview between Hadam Zaghloul and Neem Hor.
And that was because Mr. Zaghloul had been asked to clear his diary for that day, so as to attend for the purpose of familiarization with the process that was about to take place in the court. Is that correct?
Yes, it was for preparation for the hearing.
And then we see that the email goes on as follows. We previously advised you that this case would be an uphill battle because the law is against us and the case law is against us. Factually, too, it has always been problematic proving the existence of an agreement between TIG and Rami that his end of service would not be paid until his visa was cancelled because there was no written agreement in place. And that's really essentially what I was putting to you and can be seen from the case note that we've already looked at. Are you happy with where we are so far, Mr. Beckley?
Yes, I'm sorry, I've just lost it on my my iPad, but please continue.
It might be helpful for you to follow it, but I will continue reading whilst you unlock the iPad. The next paragraph is as follows. However, this morning during our session, even without prompting, it became apparent that there simply was no agreement made to pay Rami his end of service benefits only upon cancellation of his visa. Hattem told us categorically that the extension of the visa was not linked to the end of service payment, and in fact that he himself had no knowledge that it was company policy that end of service was only paid upon visa cancellation. Furthermore, Hattem told us that he was paid his end of service benefits twice without his visa being cancelled, so his understanding and personal experience completely contradicts what was in the alleged agreement in the first place. It is clearly not the policy across the company that visa cancellation is required before end of service is paid, and this is also contradictory to other witness evidence submitted to the court. Have you been able to unlock your iPhone, Mr.?
No, I'm afraid it's out of charge.
Okay, well, let me continue reading. The impact of what we now know is fatal to the defence. Now, just pausing there, if we have a strategy, a case note, evidence on the basis of an agreement, and Mr. Zadloul then presents and says, no, there was no agreement, that is a fundamental and stark difference, which as a lawyer, you will appreciate, engages ethical considerations. Would you agree?
Yes, I'd agree on that characterization, yes.
Thank you. And then we can go on. The reality of what has now come to light does not just have consequences for TIG's case, but also in our advancement of the defence due to our ethical obligations to the court. As practicing lawyers in the DIFC courts, we are bound by the mandatory code of conduct, which sets out that our primary obligation, first and foremost, is to the court, and we cannot mislead the court. This means that we are now limited to only defending the point about medical insurance. That is the only point we can put forward if the trial is to proceed. We can no longer present a defence that there was an agreement in place between Rami and TIG that he would only receive his end of service benefit once he cancelled his visa. Now, just again pausing there and following through on the ethical dilemma that we've already identified, a lawyer properly instructing themselves would, in the circumstances that have arisen, consult the mandatory code of conduct, wouldn't they?
I believe so.
And therefore it was perfectly proper for Global to give consideration to this matter and to act as they did by consulting the mandatory code of conduct. You'd agree with that too?
Yeah, I would agree with that, but keeping in mind, I wasn't privy to the conversations between Neem Hor and Hattem Zadloul.
No, but this is an email which was sent to and received by you.
Yes.
And then it continues. Additionally, any person who gives evidence to the court and relies on that alleged agreement, knowing that it did not exist, is potentially exposing themselves to perjury charges, which has criminal and civil consequences. And that again is an accurate statement and demonstrates the gravity of the dilemma in which Global found themselves. You'd agree with that, would you?
No, I would not agree with that. The fact of the matter is, Hatem Zaghloul gave evidence at trial. The judge said that he was a credible witness.
He gave evidence at trial when new lawyers had been instructed, and whether those lawyers did or did not face the ethical dilemma, we don't know, but we must assume that they didn't. And the ethical dilemma arose from what had taken place that morning and is recorded extensively in this email. That's the position, isn't it?
Those lawyers were given that email and reviewed it thoroughly. They had absolutely no problem in proceeding with the case.
You've agreed, Mr. Beckley, that there was an ethical dilemma and that there was therefore justification.
An ethical dilemma based on your characterization of the facts.
Yes, based on what is set out here.
Yes.
Now, that
email was given to subsequent counsel. They reviewed it thoroughly. They reviewed it. They reviewed the matter, the case matter, with Hatem Zaghloul, and they had no problem whatsoever in proceeding with the trial. Hatem gave evidence, and the judge concluded that Hatem was the credible witness.
Mr. Beckley, I'm more interested in your response in the face of what you received when you say correctly that you'd been asked to leave, and therefore you have no direct knowledge of what is set out here.
Correct.
I asked Mr. Zaghloul, and he said that he spoke to you in the light, or you and he had a conversation in the light of this email. Is that correct?
I believe so, yes.
And what was the nature, as far as you understand and recall, of that conversation?
He indicated to me that he had said nothing in this meeting with Neem Hor that deviated from any of his witness statements.
If that is correct, Mr. Beckley, why did you not...
I think he gave, when the hearing commenced, I think that he made a statement clarifying exactly what the situation was with respect to the so-called agreement.
Why, Mr. Beckley, did you not, in the light of what Mr. Zaghloul said, go back to Global and say we need to get to the bottom of this because Mr. Zaghloul is saying that he said nothing different? Why didn't you go back to them then?
Because it was obvious, based on their email, that they were effectively throwing in the towel. Now, what their motivation for doing that was, I can't say, but they were effectively throwing in the towel, and we had a court case the next morning.
If there was a misapprehension, and if Mr. Zaghloul told you that there was a misunderstanding as to what he'd said, the simplest, most straightforward way of dealing with it would be to go back to Global and say, there's a misunderstanding, let's clear it up. You didn't do that, did you? You didn't do that, did you, Mr. Beckley?
Certainly not. Based on that email, there was no way that we would have the confidence of proceeding with them when they said effectively we're going to lose. As it turned out, we engaged new counsel, had absolutely no time to prepare, and they ended up winning on the substantial portion of the case, which
Mr. Beckley,
indicated to us that we would definitely lose.
we can.
We had absolutely no confidence in them. Why would we continue? Why would we waste our time continuing with counsel that had effectively thrown in the towel after months and months and months of preparation? There's absolutely no way we would have gone back to global.
Mr. Beckley, Mr. Zadloul says that he told you that there had been, that he'd said nothing different.
That's
and
right.
I asked him as to whether anyone had gone back to global to say there'd been a misunderstanding and that it needed to be cleared up. And his evidence was that it was up to you to decide what to do next. So
Correct.
In the face of Mr. Zadloul saying to you there's been a misunderstanding, you removed the instructions from global.
Correct.
You didn't try to clear up the misunderstanding, did you?
Absolutely not. Based on that email, it was clear to us that they were not prepared to defend the case, and we certainly weren't prepared to go forward with them representing us as counsel.
Mr. Beckley, we've gone through the email and we have seen that the concerns arose from an incompatibility, as they saw it, between the evidence of Mr. Zadloul in his witness statements and what they are reporting to you as Mr. Zadloul having said that morning.
Yes, and as I said, we proceeded with the hearing, and the judge found that Mr. Zadloul was a credible witness. We ended up winning the substantial portion of the case that Global had told us that we were going to lose.
That's not the point I'm asking you about, Mr. Beckley. I'm asking you if Mr. Zadloul said, as he said, the simplest and easiest and most obvious solution would be to go back to Global and say, there's been a misunderstanding, let's get to the bottom of it. You didn't do that, did you?
Absolutely not. We had extremely limited time to engage new counsel that we had confidence in to proceed with the trial. We're certainly not going to waste that precious time going back to having a discussion based on that email that was sent to us by Global, effectively throwing in the towel at the last minute, saying they couldn't defend us.
They were not throwing in the towel, Mr. Beckley.
Well, read the email, and I think you'll come to the conclusion they were doing precisely that.
Well, Mr. Beckley, I have read the email, and everyone in this case has doubtless read the email. But let's look at the foot of the page. Please confirm your instructions as a matter of urgency in relation to the above. So far as Global was concerned, they were continuing to prepare on a limited basis, limited by the moral and ethical, limited by the ethical dilemma in which they found themselves, and as explained to you. That is what was continuing to happen, wasn't it, Mr. Beckley?
I don't get your point.
Well, they haven't thrown in the towel because they're asking you to confirm their instructions.
Yeah, based on their assessment that the only solution is to make an offer of settlement immediately, essentially saying we don't proceed to trial, essentially, quote, we are throwing in the towel, unquote. They were abandoning us. What other choice did we possibly have but to engage competent counsel to take the case on, which they did? And as I said, we won the substantial portion of the claim, which Global clearly indicated to us that we had no hope of winning. If you read the email, Global was effectively saying to us, settle this matter before it goes to trial. We had absolutely no confidence in Global after receiving that email, throwing in the towel at the last minute before the trial was scheduled, 8 o'clock in the evening before the trial was scheduled. What choice did we have? We couldn't proceed with them. We had to engage competent counsel immediately, who had virtually no time to proceed. They did proceed, and they won the substantial portion of the case that Global said we could not win.
Mr. Beckley, this email says in categoric, clear terms, please confirm your instructions as a matter of urgency in relation to the above.
Right, and our instructions were, we want you removed from the case.
And at the top of the next page, I am available to discuss this tonight or tomorrow morning at your convenience.
Okay.
So if you had been told that the moral dilemma in which Global felt themselves to be was easily soluble, it would be the easiest thing in the world to have picked up the phone on the evening of the 18th of February and said, look, there's a misunderstanding. We can clear it up. And that would remove the moral dilemma, which was the impediment so far as Global is concerned, wouldn't it, Mr.
A contrived misunderstanding at a time when it was critical for us to engage alternative competent counsel to defend us in this case. They having effectively thrown in the towel on the basis of that email. I mean, read the email.
Where is the contrivance in this email, Mr. Beckley?
I don't know where the contrivance is because I wasn't party to these so-called to the discussions between Hatem Zagul and Neem Hor.
No, Mr. Beckley.
Nor was Sharon, I believe.
Mr. Beckley, I'm afraid I have to press you because you have just said that there was contrivance on the part of Global in relation to their representation of TIG in this matter. Where is the contrivance?
Absolutely. They had spent months and months and months in preparation for this case. Then at the 11th hour, at 8 o'clock in the evening before the trial was scheduled to commence the following day, they effectively say you have no defense.
Mr. Beckley,
they had sat down with Hatem Zagul, I believe on at least 3 occasions prior to that, and thoroughly gone through and prepared his witness statements.
And then he says something
different. At the 11th hour, they effectively throw in the towel. What choice do we have? We have absolutely no confidence in the ability of these people to defend us because they said they couldn't defend us.
Mr. Beckley, I come back again. It is a very grave charge to allege contrivance against a firm of lawyers. Where in this email?
What's the issue here? What is the issue here?
Where is you? I'm giving you an opportunity.
Are we now switching?
I thought, please, Mr. Beckley.
Your Honor, I believe that if you allow me,
answering the question. It is a fair question. You have referred to contrivance. It is a serious matter. You are being asked where do you say there was contrivance in this matter. Would you please explain yourself?
Yes, I'm going to withdraw that statement with respect to contrivance.
Thank you.
Would allow me, Your Honor, to state that the questioning went to the limit of imposing ideas and statements on the witness, which I don't believe this is the way of cross-examination of a witness.
I see nothing, I have not seen anything improper or excessive in the cross-examination, Mr. Kana, and I'm afraid I cannot agree with you. Please continue, Mr. Patrick Joyce.
I'm obliged, Your Honour. Mr. Beckley, I think we have now probably explored sufficiently the email of the 18th of February. Let's go back and see where we are in relation to your witness evidence in this regard. Your first witness statement is back at C27, And we'll just briefly look at where we've reached. Paragraph 5 at the foot of page C27 is the case note. We've covered that. Paragraph 6 and 7 relate to Mr. Zadloul's first and second witness statements. I've had an opportunity to cross-examine him in relation to those witness statements. Paragraph 8 refers to the skeleton argument and opening submissions, which were prepared by Global by Miss Hoare, and those were dated the 14th of February 2019. Can you confirm that those submissions were, in the first instance, made available to your replacement counsel?
Yes, I believe they definitely were.
And were they made available to the court on the hearing of the 20th, 21st of February?
Yes, I believe so.
And we can see the skeleton argument, can't we, at page G75, Mr. Beckley?
Okay, Michael, I have the skeleton argument.
Thank you, and we can see that it's an extremely comprehensive skeleton. It runs to 75 paragraphs, 22 pages, which is to be found in the bundle between G75 and G96.
Correct.
That was all Global's work, and it was put to good use in the hearing before the Court of First Instance, wasn't it?
Yes, I believe it was submitted to the court, definitely.
We go back to your first witness statement at page C28. We've dealt with the email of the 18th of February, and I would formally put it to you that you had a very clear, straightforward way of resolving the moral dilemma if you could, but you chose not to adopt that straightforward course of resolving the difference of resolving the misunderstanding. You terminated Global's retainer, didn't you?
Correct.
And you terminated their retainer without responding to Ms. Lacan's invitation.
Correct.
To phone you, for you to phone her and discuss the matter.
Correct.
And they then provided every assistance to your new counsel, and they provided every assistance, including attending upon the court for the purpose of coming off the record and new legal representatives coming on the record, which is something that hadn't otherwise been attended to.
Correct. They attended to take themselves off the record.
And we can read the judgment separately and at our own time. Mr. Beckley, I think for the sake of completeness, we should just look on to your fourth witness statement. Paragraph 29, please, which is on page C39.
Correct.
You raise, separate and distinct from the matters we've just been discussing, The issue with the billings for this case is also the excessive hours charged by Ms. Hall.
Correct.
Where do we find particularization and detail of that?
If you take a look at the billings with respect to, as an example, with respect to the preparation of the skeletal argument, if you add up those hours, you can easily see that those billings are excessive.
Which document are we referring to in relation to excessive billings with regard to Abu Zaid?
The billings of your client.
Yes, which document would you like us to look at in support of what you've just said, Mr. Beckley?
The billings, the invoices of your client with respect to Abu Zaid.
Yes, which document in the bundle would you like to take the court to in support of this unparticularized statement?
As I indicated to you, my list of, unfortunately, my iPad is expired, so I can't do that. It's out of charge.
Can you point me to any particularization of what you have said in paragraph 29?
Yes,
Anywhere
if you examine the billings of your client and the charges of Neem Hor, as an example, with respect to the preparation of the skeletal argument, you will be able to come to the conclusion that those billings were excessive.
Mr. Beckley, in order to level a charge of excess hours, we have to first of all identify the hours that have been charged, and then the party raising the case of excess hours having been billed must indicate with proper particularity which hours are excessive and why they are excessive. And that's what I'm asking you to do.
And again, I'm telling you, if you examine the invoices of your client and segregate the hours of Neem Hor, you will find that those hours are excessive.
Mr. Beckley, it's your case, or it's TIG's case, and I want to know how you, as the former General Counsel for TIG, particularize that case.
And as I told you previously, I don't have the analysis that I made.
So not only do we not have it in the hearing bundle, you don't have it yourself, and insofar as this has ever existed, you haven't had it for at least the last 8 months.
That is correct.
Mr. Beckley, could we just look at Ms. Lacan's first witness statement, pages C17 to 18?
Michael, could you direct me to the paragraph number? Again, I'm looking at a hard
paragraph 32 on page C, paragraph 32 of yes, C17. If you don't have electronic access, probably doesn't mean anything. It is Ms. Lacan's first witness statement of the 7th of June this year, paragraph 32.
Correct. I have it.
Let's see how much of this is common ground. Global sent frequent reminders for payment of the outstanding invoices. For example, on the 5th of December 2018, our head of accounts sent an email to Mr. Beckley noting that our outstanding balance was just over 1 million dirham and that some invoices had been outstanding since August 2017. A copy of that email is to be found at her exhibit G, and if you wish to have a look at that document, it is page page H1.
Yes, I have the document entitled Outstanding Balance dated August 11th, 2018.
Yes, and that confirms that there had been an outstanding balance of just over £1 million dirham with invoices pending since August 2017, doesn't it?
Correct.
Sent by Mr. Mohammed to you, and the supporting documentation is at pages H2, 3 and 4. That is consistent with an earlier email, which we can find at bundle F13, please, Mr. Beckley.
Again, as I said, my pad has expired, so.
Oh, well, then I'll have to read it to you. I'm sorry. This is an email sent internally, and it's from Ms. Lakan to the managing partner and Mr. Jishan Mohammed, who we know from H1 is the relevant accounts manager. Dear Ali and Jishan, William got back from Canada today, so that's suggesting that you got back from Canada in early September 2018. Would that be broadly accurate, Mr. Beckley?
Yes, I believe so.
And then it continues, I just had a call with him about, amongst other things, our fees. He was under the impression that at least one transfer had already been made to us, as he'd chased the finance team last week for an update. I explained that as of last week, we'd not received any payments. Does that sound accurate, Mr. Beckley?
I believe that is accurate.
Good. Let's see if we can find more common ground. The email continues, I told him that usually our internal policies dictate that we should put pens down at this stage, but given the relationship, neither Ali nor I wanted to do this. William said it would be disastrous for them if we were to stop acting, as we advised them on so many matters, including corporate matters. I assured him that I had no intention to stop, but just wanted to let him know that we were getting internal pressure from the partners and from accounts, as the amount outstanding was significant. Does that ring any bells? Putting pens down at this stage and you asking, please don't do that?
Yes, I recall Sharon stating that.
And then we have a case that's currently stalled because our opponent is not cooperating. There's a possibility for us to have him arrested. I mentioned that I would rather have some clarity on our fees before starting that expanded scope of work. This will hopefully be a good inducement to release a few payments. So we see a problem back in September 2018, don't we?
Which problem is that?
Well, a problem with non-payment of fees.
Yes.
And we see that there is again a problem in December 2018, don't we?
Which document are you referring to?
H1, which I've already taken you to, and the supporting account details at H2 to H4.
Yeah, You're referring to the list of outstanding balances?
I am.
Yes. Dated August 11th, 2018.
No, I'm referring, I've taken you to the document at F13, which is the internal note about the outstanding fees, and the 9th of September, which records a conversation between Miss Lacan and yourself, which
Yes.
you have agreed with in cross-examination. I
Yes.
have then reminded you that I had previously taken you to H1, which is a covering email to you from the accounts manager for Global Advocacy, dated the 5th of December 2018, drawing attention to outstanding accounts since August 2017 in a sum of then over £1 million dirham, with the supporting documentation at pages H2, H3 and H4. Yes?
Yes.
So we've gone from September through to December 2018. We can pick up the narrative back on Ms. Lacan's witness statement at page C17.
Which paragraph number, Michael?
We're going to go from, we've looked at 32, we're going to look at 33.
Okay.
The explanation being given for the delay in payment was the company was experiencing cash flow issues as a result of business conditions impacting its business, particularly in Saudi Arabia, and therefore processing times were being delayed. Mr. Beckley called me on at least one occasion to assure me that Global's payments were being processed, but noting the impact of market conditions on the time frame. Do we have common ground in that paragraph, Mr. Beckley?
Yes, we do.
And then on the 10th of January 2019, Mr. Al-Hashimi told Miss Lacan that he had met with Mr. Jabara, who had promised him to make a payment of 290,000 dirham towards our outstanding fees by the end of January 2019. Mr. Al-Hashimi also told me that Mr. Jabara was going to provide a payment plan to settle Global's outstanding invoices. However, the only payment received was for an amount of 92,000, far short of the 290,000 that had been promised. On the 29th of January, I wrote an email to Mr. Beckley asking why that amount had not been paid and indicating that if the explanation was not satisfactory to management, we would have to come off the record. A copy of that email is at Exhibit H. And we can see Exhibit H, which is H5 in the bundle.
Okay, can you read that email to me?
Yes, I can. It's dated January the 29th, 2019, and it's addressed to you primarily and Mr. Khalid Javera secondly. I refer to our meeting on the 10th of January 2019. Do you recall that meeting?
No, I don't, but please continue.
Well, it would have been a meeting about outstanding fees in the light of Mr. Jishan Mohammed's email that we've just been looking at, drawing attention to over £1 million dirham being outstanding. Does that jog your mind? Does that jog your mind, Mr. Beckley?
Yeah, I know I had at least one meeting with Sharon.
Okay, and then she goes on, we are concerned to note that we are now almost in February, and to date the only payment that we have received towards our outstanding invoices is approximately 92,000 dirham, which is significantly less than the 290,000 that we were promised during our meeting on the 10th of January 2019, would be made to us by the end of January. We have also not been provided with the schedule of payments that we were told was being prepared. This unfortunate, just pausing there again, I'll read it paragraph by paragraph. We have common ground there, do we, Mr. Beckley?
Well, I didn't attend that meeting that is being referred to in paragraph 34.
I see, okay. We appreciate, well, whether you did or you didn't, this email was addressed to you. Do you take exception to its contents?
Was Mr. Jabber copied on that email?
Yes, he was, but you were the primary addressee. Do you take exception to the contents?
Yeah, because I did not attend that meeting. I have no idea what discussions took place between Ali and Khalid Jabra.
I'm not really asking you about that, Mr. Beckley. I'm asking you as General Counsel. You have an email addressed to you about a previous arrangement, and where it says there was no payment as promised and no schedule of payments prepared. And you are the primary addressee of this email. As General Counsel at the time of the industrial group, are you in a position to confirm the accuracy of what I have just said?
No, I am not, because I didn't attend the meeting between Mr. Ali Al-Hashmi and Mr. Jabra. I didn't attend that meeting.
That doesn't matter, Mr. Beckley.
Yes, it does matter. It does matter. It matters. It does matter because Mr. Jabber was the point of contact with respect to the resolution of these outstanding invoices, not me. That's why I'm telling you I wasn't privy to that meeting.
Did you make any inquiries?
I probably did make some inquiries, but I can't recall exactly what was done.
And the email continues, this unfortunately leaves us in a very difficult position. We cannot continue to cash flow work that we are performing on the industrial group's behalf. We appreciate that the company is experiencing cash flow difficulties as a result of poor market conditions. However, given the significant amount of work that is yet to be incurred preparing for the Remy Abuzaid trial, it is not sensible for us to continue to accrue with such a sum outstanding. Please, can you urgently provide an explanation as to why there is a shortfall in the promised payment amount for January and the proposed payment schedule? If the response is not satisfactory to our management, then regrettably we will need to cease acting and come off the record. Did you provide an explanation as requested, Mr. Beckley?
No, I didn't provide an explanation as requested because I didn't attend the meeting between Mr. Ali and Khalid Jabra.
And can you, as primary,
Global was well aware that at that time this matter was in the hands of Khalid Jabra for resolution.
Can you point to any explanation having been provided in the papers which are before the court?
I have no idea whether there was any discrepancy. I have no idea. I have no idea what transpired at that meeting.
Well, at any event, we know the basis on which the claim has been brought because it has been brought on the basis of outstanding invoices where the industrial group has taken exception to particular elements, all of which we have explored. There is no indication, is there, that any of those outstanding invoices have been paid?
Yeah, I believe that there was discussions between Khalid Jabra and Ali Al-Hashmi to try and resolve, but I wasn't privy to all of those meetings.
There is no indication in the papers before this court of any payment of outstanding invoices, is there?
I don't believe so because there was issues with respect to those payments.
And finally, can we look back at the particulars of claim, and we can begin at paragraph A8, please.
Okay, you're
the page A8.
Yeah, please read it to me because I haven't got that document in front of me.
Okay. As regards the Bradley Dexter matter, this is the disputed invoice where exception was taken to the hours, but does not elaborate as to why the time spent was not reasonable and necessary, nor why it took over 12 months before highlighting concerns. Are you happy to accept that there was a considerable delay before you highlighted any concerns with regard to the Bradley-Dexter fees?
Yes, I believe there was a delay in performing a complete analysis on the billings.
And if we go on to the next page, page A9, paragraph 10.2.1.
Are you going to read it?
Oh yes, I'll have to, I'm sorry. This is relating to Arwa Al-Banawi and the claims in relation to the sums disputed, which is the 24,000 we've explored. The defendant objects that the time spent was excessive, even taking into account the defendant's proposed deductions for reasons which the claimant rejects, as elaborated in the claimant's email to the defendant dated the 27th of June 2019, an amount remains due and payable, an amount of 58,881 dirham and 86 fil. So again, it looks as if the issue was only crystallized in the letter before action, the response, and emails in mid-2019, whereas the period where you are disputing the fees ended in October 2018. Again, Mr. Beckley, it took many months before any concern was raised on those fees at all. That's correct, isn't it?
Yes, it took many months, but keeping in mind we had discussion, I had a meeting with Sharon with respect to specifically the excessive billings in the trademark case.
And then in relation to the Rami Abu Zaid case, same page, paragraph 10.3.2, it was not until the 23rd of June 2019 that the defendant, in an email of the same date timed at 6:33 p.m, raised any issue with regard to the time spent by Ms. Hoare on preparation for trial in relation to the Abu Zaid matter.
Yeah, keeping in mind that we received that billing after the trial.
This is the bill that we were looking at. No, because let me read the full paragraph. I'm sorry, I should have read that to you. You don't have the benefit of it. The full amount of those invoices remains outstanding. The defendant disputes 260,000 dirhams worth of time spent collectively by a paralegal, Ms. Nazanin Esfandia and Ms. Nahum Hoare of counsel over a period spanning from May 2018 to February 2019. Despite the final invoice for this matter being sent on the 12th of March 2019, it was not until the 23rd of June 2019 that the defendant, in an email of the same date, raised any issue with the time spent by Ms. Hoare on preparation for trial. The first concern over Ms. Hoare's billing was raised months after the final invoice was sent to you. That's the case, isn't it, Mr. Beckley?
Yes.
Thank you. What I would suggest to you is that it was done because there were indeed cash flow problems, and that the non-payment of these fees is because of that reason, not because of any of these reasons, that the defendant, the industrial group, has chosen to see fit to put before this court?
Incorrect. Incorrect. We wanted to do a thorough analysis of the hours that we were being billed.
Mr. Beckley, such a thorough analysis that it has not seen the light of day in these proceedings, and where you have given evidence based on recollection of a document you no longer have, could not possibly have seen for 8 months before you gave your witness statement, and therefore is simply insubstantial. No analysis produced, no basis for challenging these fees. That is the situation, isn't it, Mr. Beckley?
No, that's not the situation. Even by looking at the bills, even you could determine that those hours were excessive.
I was not doing the work. The work was fully itemized. You or those at the industrial group did not see fit to challenge them for months. There is no real basis for challenging these invoices at all, is there, Mr. Beckley?
Oh, there definitely is. An analysis of those billings will clearly indicate that the hours charged by Neemhor in particular were excessive.
Mr. Beckley, I've given you every opportunity to elaborate on that analysis. I'm not going to ask a further question. It's already been covered. Thank you very much.
Thank you.
Mr. Kanan, any?
Yes, Your Honor. I have, it seems that our colleague has consumed most of the time allocated for the witness hearing. However, I try to do it as brief as possible for time saving. Other than the ARWA letter of engagement, do you recall any other letter of engagement within the scope of this of these procedures?
With respect to these particular cases, I do not recall any other letter of engagement that we entered into.
Okay. The billing, in the absence of a letter of engagement, would you consider that the billing produced by the claimant is binding and confirmed for payment?
No, absolutely not.
That's a matter for me, Mr. Kanan, not for Mr. Beckley to comment on. So you will be making that submission to me. It is not a matter for me to comment on.
Okay. The claim of fees was left to the approval of the financial authorities within the TIG, or simply to the administrative authority?
No, the finance department under the head of finance had to approve every single invoice, and they performed their analysis of each invoice and determined whether it was payable.
Let us take the example of ARWA billing. When you will notice that there is a different type of billings made for administrative and for legal. Was Rabia or Ms. Giles advising you on the progress of the Arwa matter and the additional cost incurred other than the sealing? Were you advised of this periodically?
Come again? I'm sorry, I didn't understand the question.
If you go back to the invoices, upon the review of the invoices, you would find various charges for telephone calls, for visits, were you informed or advised by the claimant that periodically of the increase of billing due to these administrative proceedings?
No, we weren't, but we had agreed initially that so far as the fees are concerned, it would be between 10 and 15 hours, and expenses or disbursements would be in addition to that.
What if we go back to Rabia confirmation that of the ceiling or cap of 10 to 15 hours, you have advised him of your readiness to accept only the cap. Did you receive any feedback from Rabia as to whether he approved your request or not?
No, I did not. It was based on discussions directly with Rabia and myself.
And Rabia, based on the discussions, Rabia reconfirmed to you that the cap is still valid and will be respected by the claimant.
Yeah, between 10 and 15 hours of time plus disbursements.
And this is regardless of the letter received from Ms. Giles.
That's correct. That's correct.
You confirmed the replacement law firm was completely in line with the code of conduct. Should this firm have an ample and adequate opportunity to review the facts of these proceedings and the cases, do you think that the case results would be much better to the favor of your company, and whether this may have led to the total discharge of the Article 18 application?
Your Honour, I'm not too sure again how this arises from cross-examination, and it's really a matter for submissions based on known law in the DIFC.
Mr. Canaan, I don't think it does arise from cross-examination, but even if it did, it's not something which can be asked of Mr. Beckley.
Okay, when you appointed the global, did you expect to provide them, take into consideration their regular experience towards similar matters?
Yeah, definitely. We had a long-standing relationship with Global. We had basically a process in place with respect to legal matters.
Thank you, Your Honor.
Yes, thank you.
Thank you. No further. That's it.
Your assistance also. Since Mr. Beckley is the last witness, there's no reason not to excuse him. Any objection? Thank you very much, Mr. Beckley. Your excuse.
Thank you, Your Honor.
Right. Just spend a moment, Counsel. Is the position of the engagement letter advanced at all?
I will, may I invite my instructing lawyer, Ms. Wright, to update us on any developments which I've not been aware of whilst I've been cross-examining. I'm afraid I don't have any up-to-date information at my fingertips.
Yes. There certainly is, if Ms. Wright is somewhere online.
Yes, I am. Well, there hasn't been any further updates. As Michael is aware, that we provided the information to Canaan this morning as to how the engagement letter was sent to TIG, the date, the exact time. It was in fact sent by email to Mr. William Beckley. So we've given all those details to to Canaan this morning. And
I believe you were also aware of the emails addressed by Sandra in relation to this letter of engagement.
That's right. Sandra sent a few inquiries in relation to the bundling, actually. It wasn't a specific email, and I'm more than happy to share that with the court. She was directing her email to Nazanin, the paralegal, who was uploading the bundle.
Thank you.
In response to that, obviously the letter of engagement only came into consideration this morning. And the reason for that is when Sandra, just 2 days ago, asked for the...
I'm not concerned to worry about that. I just want to know whether or not it's going to end up as part of the materials before me. I think I will just have to leave it to the parties. As I understand it, details of when Global says it was provided to TIG have been provided. I would expect TIG to check that through. And when we next meet, I will be told the result of that, and we will just deal with the question of that letter before we embark on submissions.
Would Your Honour wish, those instructing me to file a copy of the covering email giving its date and time with the court, so that it's at least available if we can't resolve the matter by agreement with Mr. Samir Canaan?
Well, you can't resolve the matter. What are you going to do? If he does not, if it is not accepted that it was received, what are you going to do?
I suppose on a balance of probabilities, if there's clear evidence that it has been sent and there's no bounce back and it's the right address, then we would invite the court on a balance of probabilities to accept that it was sent, and because it's electronic, received, and the fact that there's been no confirmation doesn't detract from that position.
You might wish to have an affidavit available, not filed, in case that's necessary. The question of whether that will be received can be resolved with the assistance.
Do I understand that this was emailed to the TIG? It was sent by email. It was emailed to them.
That's correct. Yes, I could give you the precise date and time if necessary.
Okay, thank you.
It should be checked. Well, I'm not going to spend any more time on it. We'll deal with it at the commencement of submissions. Thank you very much, Ms. Wright. What about submissions is the foreshadowed program of outlines, not in outline, just a memoir by Monday lunchtime, say 1 o'clock, and then we have oral submissions addressing the outlines on Tuesday at 10 o'clock, both times Dubai times. Is that still acceptable to the parties?
It's okay with us, Your Honor.
I'll just check with Mather, who is there. Mather, will that be all right with the court? You can manage that, can you? Sure, if Mather is there still. Ms. Wright, if you would be good enough to follow that up with the court to make sure that can be done. If there is a problem, let us all know.
I will. You.
Your Honour, in the time available, I haven't formally been able to check and confirm my availability, but as it's 7 o'clock in the morning, I rather think I'll be available.
Yes, that's unfortunately probably so. The last thing that I would like, before asking either of you if you have anything else, is addressed to Mr. Kanan. Your sound is very echoey. That has been commented on a couple of times. Sometimes you mind if some experimenting to see if you can improve the sound quality, because it will make this a lot easier. You don't have to ask you to repeat yourself.
We will, Your Honor, but also possibly the same issue that there is an echo in the sound in general. So because this sometimes creates a difficulty in hearing what exactly is said. So I agree with you, possibly there is an echo from our side, but it is also an echo from the other side, Your Honor.
Maybe so. I can hear Mr. Patrick Joyce or Ms. Wright much better than you, in the sense that without the echoing. So all I'm doing is asking, see what you can do, because it would make life a lot easier.
We'll try to improve it, Your Honor. We'll try to improve it.
All right. Is there anything else, Mr. Patrick Joyce, from your point of view before we adjourn till Tuesday?
Your Honour, no, I have nothing else on my agenda.
Thank you. Anything on your agenda before I adjourn the case, Mr. Kanan?
Nothing for the time being, Your Honor. Thank you.
Thank you very much. In that case, I will see you on Tuesday.
Thank you.
Thank you.